Yesterday, the closing of the day, I had mentioned certain numbers.
Closing of the day. Matin opening of the day problem.
Problem is, my lord, the serial numbers and the item numbers what I have mentioned is not tallying with the writ petitions what I have mentioned.
ನೀವೇ ಹಾಕ್ಸಿದ್ರಿ, ನೀವೇ ಕೇಳ್ತಾ ಇದ್ದೀರಾ. ಏನ್ ಮಾಡ್ಬೇಕು ಅದಕ್ಕೀಗ?
Rectification memo ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಡಿಲಿಂಕ್ ದ ರೆಕ್ಟಿಫಿಕೇಶನ್ ಆಪೋಸಿಟ್ ಸೈಡ್ ಕೊಟ್ಟಿರಿ. ಎಸ್, ಆಲ್ ಎಲ್ಲ ಮೆಮೋಸ್ ಕೊಡಿ.
Since tomorrow it is
ನೋ ಟುಮಾರೋ, ಆಲ್ ಮಂಡೇಸ್ GMCPC ಕೊಡಿ. Give all the memos. Withdrawal 1 ನಿಮಿಷ. Give GMCPC ಎಲ್ಲ ಕೊಡಿ. ಪರವಾಗಿಲ್ಲ. 9th ತಾನೆ. Correct. 7 Monday is 7th sir. Monday is 7th sir. No problem.
Your lordship,
ನಿಮ್ ಮುಂಚೆ 1000 ಮೆಮೋಸ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಏನ್ ಮಾಡೋದು?
your lordship,
ಅವ್ರು ತಗೊಳ್ಳೋದು ಬೇಡವಾ? ಅಲ್ಲ, ಅವ್ರು ತಗೊಳ್ಳೋದು ಬೇಡವಾ? ನೀವ್ ಹೇಳಿ, ಅವ್ರು ತಗೊಳ್ಳೋದು ಬೇಡವಾ? ಅಲ್ಲ, ಅವ್ರು ತಗೊಳ್ಳೋದು ಬೇಡವಾ? Everybody's matter is urgent. ಅದಕ್ಕೆ some method following. ನಿಮ್ 3 ಮೆಮೋ ಇದ್ರೆ ನಿಮ್ ಫಸ್ಟ್ ಮೆಮೋ ಯಾವ್ದಿದೆ ಅದ್ರ ಪ್ರಕಾರ ಬರುತ್ತೆ.
your lordship,
Tell you please be quiet. ಕೊಡಿ 230 ಕೊಡಿ. Am I not coming? Wait, you forgotten the drill? Yes. Pending matter to the Varadarajan sir. ಬಟ್ ಅವ್ರ ಅಪೋಸಿಟ್ ಸೈಡ್ ಅವ್ರಿಗೆ ರೆಸ್ಪಾಂಡೆಂಟ್ ಹೇಳ್ಬೇಕಲ್ಲ. ಹಾ ಹೇಳಿ. ನೋ ಪ್ರಾಬ್ಲಮ್, ದಟ್ ವಿ ವಿಲ್ ಡೂ. ಆಯ್ತು ಆಯ್ತು, ನಾಳೆ ಬರುತ್ತೆ. ನಾಳೆ ಎಲ್ಲಿದ್ರು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಮೆನ್ಷನ್ ಮಾಡಿ, ವಿಲ್ ಟೇಕ್ ಇಟ್ ಆಸ್ ದಿ ಫಸ್ಟ್ ಕೇಸ್. ಅದನ್ನು ಹೇಳ್ಬಿಡಿ ರೆಸ್ಪಾಂಡೆಂಟ್. ವೇರ್ ನಾಳೆ ಫ್ರೈಡೆ. GMCPC na 230. Give it. Pending GMCPC ಕೊಡಿ sir. Pending ಮಾತ್ರ ಕೇಳಬೇಡಿ. It is only on seniority. Give it. Vacating stay ಹಾಕಿದ್ರೆ ಮಾತ್ರ ಹೇಳಿ. ಪರವಾಗಿಲ್ಲ. No problem. ಕೊಡಿ. File ಇಲ್ಲ, no dates sir. Pending matters don't ask dates unless you have filed vacating stay application.
It was ordered today, but it is not listed because list end ಆಯ್ತು ಅಂತ.
ಕರೆಕ್ಟ್, ಎಂಡ್ ಆಗಿದೆ. ಏನು ಅರ್ಜೆನ್ಸಿ? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟ್ರಾ? ನಾಳೆಗೆ ಬರುತ್ತೆ.
230.
ಓಯ್, ಏನ್ ಅರ್ಜೆನ್ಸಿ? ಬಿಡಿಎನಾ? ಮತ್ತೆ ನೋಟಿಸ್ ಮಾಡಿದಾರ? ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ. ನಾಳೆ ಬರುತ್ತೆ, ಕೊಡಿ.
Lordship, my case is set down for 4-6, your lordship.
Sorry?
Trial court 4-6 matter is set down for reporting.
For what purpose, sir?
Reporting compromise. My application for post error has been rejected by the court. Suppose if the matter is not taken.
Tomorrow.
2:30 of my lord.
Tomorrow. Wait, am I not hearing here? Yes.
Shivram Karan Nagar layout. It is not a challenge to occupation. Only site purchase this case malada. To refer the matter to committee mala.
ಕೊಡಿ, ನಾಳೆ ಕೊಡಿ. ಎಷ್ಟು ಮ್ಯಾಟ್ರ್ ಇದೆ ಅದು? ಒಂದೇನಾ ಸರ್?
ಕವರ್ಡ್ ಇದೆ, ಜನರಲ್ ಅವಾರ್ಡ್ ಒಂದೇ.
ಜನರಲ್ ಅವಾರ್ಡ್ ಕವರ್ಡ್ ಎಲ್ಲ ಕೊಡಿ ಮೇಡಮ್. ಜನರಲ್ ಅವಾರ್ಡ್ ಎಲ್ಲ ಹಾಕ್ಸ್ಬಿಡಿ ನಾಳೆ.
62, my lords. In the first list, petitioner died, my lords.
No adjournment, don't take. Mention it is called.
Yes. Suit for declaration, your lordship. I had filed an IA for amendment of prayer.
When?
That was rejected.
Rejected when?
Like 2 weeks back, your lordship.
Monday. I've told you all fresh matters will come. Give it. General.
It's the matter is for evidence, your lordship.
No problem, sir. Yes.
pending matter, B group, LR application has been rejected in FTP nalli, 1970 FTP matter.
ಕೊಡಿ next week ಬರುತ್ತೆ.
Posted for judgment on 5th, your lordship.
ಅದು ಕೊಡಿ ದೇಶರಾಜ್ ಸರ್ ತಿಳಿಸ್ಕೊಡಿ.
Lordship, posted for judgment on 5th of this month. And your lordship had given date for today, but it's not yet.
Wait, I'm not yet come to, yes ಕೊಡಿ.
WP is not maintainable.
ಹಾ
WP is not maintainable, my lord. Already approached the trial court up to liberty court ಇಂತೆಲ್ಲ ಅಪ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ ಸರ್. ಇದರಲ್ಲಿ RF ಜೊತೆ ಟ್ಯಾಗ್ ಆಗಿದೆ ಸರ್. ಅದಕ್ಕೋಸ್ಕರ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಇದೆ, ಅದು ಯಾವುದು ಮೂವ್ ಆಗ್ತಾ ಇಲ್ಲ.
ಎಲ್ಲಿ
ಇಲ್ಲಿ ಇಂಡಿಯಾ ಸರ್ ಟ್ಯಾಗ್ ಆಗಿದೆ.
ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ
not to precipitate ಅಂತ ಆಗಿದೆ ಸರ್.
ಎಸ್ ಕೊಡಿ, ಮೆಮೊ ಕೊಡಿ, ಅದೇನ್ ಬರಲ್ಲ.
ಅದರಲ್ಲಿ WP ನು ಕೂಡ ಇದಾಗ್ತಾ ಇಲ್ಲ.
ನೋಡೋಣ.
ಆಲ್ರೆಡಿ ಅಪ್ರೋಚ್ ಮಾಡಿದ್ದಾರೆ ಸರ್ ಅದರ
ವಿಲ್ ಸಿ ಸರ್, ಎಲ್ಲದರಲ್ಲೂ ಎಂಟ್ರಿ ಮಾಡಿರ್ದೆ ತಾನೆ.
ಎಲ್ಲ ಇದರ WP ನ ಟ್ಯಾಗ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ ಸರ್.
ಆಯ್ತು, ವಿಲ್ ಸಿ ಕೊಡಿ.
ಇಲ್ಲ ಕೈಲಿ ಅಂತ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಮೇಡಮ್.
Trial court has been issued an attachment warrant on the property, my lords.
Monday ಕೊಡಿ.
It is listed on 10th, my lords.
Monday is before 10th, right?
Yes, ma'am.
Give it. ಅಲ್ಲ 9th ಹಾಕಿ ಮೇಡಮ್, ಮಂಡೇನು ಬೇಡ, 9th ಡೇಟ್ ಕೊಡಿ. ಅದಲ್ಲ
Lordship, it's listed for judgment on 5th of this month.
ಫ್ರೈಡೆ.
Lordship,
ಫ್ರೈಡೆ
Fresh GMCBC.
ಫ್ರೆಶ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಸರ್. ಫ್ರೆಶ್ GMCPC please give.
It was ordered to be posted today.
No, it won't be. It will come on Monday, sir. Give it. It will come on Monday. Give it.
Tomorrow is the date given.
For what, sir? For what?
For filing objections to interim order passed by the trial court.
Do it, sir.
Application for vacating.
Do it, sir.
The order has been passed without jurisdiction, my lords.
Why?
Commercial court has the jurisdiction to pass the interim order on such disputes.
Uh-huh.
My invoices have been withheld for more than.
Where is the suit pending, before commercial court or the civil court?
Civil court, my lords.
You filed an IA to transfer it?
No, I filed a writ petition for rejection of that suit.
CRP na?
GMCBC, my lord.
Kodi, naale kodi.
Today, my lords.
Tomorrow.
My lords.
All of you, please don't tell together.
Today,
Yes.
2:30, my lord.
No, tomorrow.
Today.
Lordship,
Tomorrow.
tomorrow, your lordship.
ಏನು tomorrow? Friday, ನಿಮ್ದು 5th ಇರೋದು, Friday ಕೊಡಿ ಅದು.
Please.
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರಾ? ಫ್ರೆಶ್ ಆರ್ ಪೆಂಡಿಂಗ್? ಫ್ರೈಡೆಗೆ ಹಾಕಿ. Tomorrow. CRPs ಎಲ್ಲ ಕೊಡಿ tomorrow.
My lord, GMCPC we filed withdraw memo, Your Honor.
Withdrawal ತಗೊಳ್ಳಿ ಮೇಡಮ್, GMCPC withdrawal.
Tomorrow.
IA for vacating interim order is filed.
Give it. 9th.
One matter.
IA for vacating interim order ಯಾವಿದೆ ಎಲ್ಲ ಕೊಡಿ.
IVF matter, there are so many things. One is,
IVF matter is not before me, sir.
it has to take us further. We will not-
No, sir, I have released it from part heard, it go before the other courts. Yes. ಕೊಡಿ.
Lord, one matter, a rare matter, which is parted by your lordships. There was a direction to the petitioner, who is the developer, to pay 10 lakhs on or before 12th of June.
ಅದು ಕೊಡಿ,
In spite of it,
ಅದು ರಿಲೀಸ್
yes.
ಮಾಡ್ಬಿಡೋಣ ಕೊಡಿ. Yes.
My lord, this
ನಾಳೆ
writ,
ಹಾಕಿ ಮೇಡಮ್.
my lord, this writ matter, where after lapse of 16 years, an application for, in a partition suit, an application for withdrawal of the suit with the liberty to file a fresh suit has been ordered, my lords. After lapse of, after completion of the cross-examination of PW1, my lord, where, my lords.
ಮಂಡೇ.
My lord, this.
ಅದೇನ್ ಕಾಯ್ತಾ ಇದ್ದೀರಾ? ಮಂಡೇ ಕೊಡಿ ಎಲ್ಲ. Wait.
matter.
Pending.
matter.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಆದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್. ರಮೇಶ್ ನಿಮ್ ಪೆಂಡಿಂಗಾ?
Pending. My lords, now the matter is listed. for-
ಪರವಾಗಿಲ್ಲ. Yes.
The suit has been.
No, sir, if I take one pending like that, I will take everything. It is according to seniority, it will come.
Writ petition pertaining to education. But as per the roster, it has to be heard by the judge, English. Is disabled. Therefore, I'm given to learn, my lord, that your lordship has been given.
ಕರೆಕ್ಟ್. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು?
Cancellation of approval.
ಫ್ರೈಡೆ ಆಗ್ಬೋದಾ?
My lord,
ಅದು ಎಜುಕೇಶನ್ ಮ್ಯಾಟರ್ ಫ್ರೈಡೆಗೆ ತಗೊಳ್ಳಿ.
LBDM matter.
ಎಸ್ ಸರ್. ಯಾಕೆ ವೈ ಆರ್ ಯು ಆಲ್ ವೇಟಿಂಗ್?
my lord.
ಗಿವ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇರೋದೆಲ್ಲ ಕೊಡಿ. ಗಿವ್ ಆಲ್ ದಿ ಮೆಮೋಸ್. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಂತ ಮೇಲ್ಗಡೆ ಬರ್ರಿ ಕೊಡಿ.
My lord, this writ
Give all the memos. ಕೊಡಿ ಸರ್. No date, give it.
My lord,
BDA Tuesday or Thursday ಬಂದೇ ಬರುತ್ತೆ.
my lord, one matter at 2:30.
ಪರವಾಗಿಲ್ಲ ಕೊಡಿ.
GMCPC fresh matter.
Wait. ಕೊಡಿ ಎಲ್ಲ. It will come on 9th or 16th, date will be fixed, give it. Why? 2:30, yes. Next week, yes.
Construction stay.
Pending matter one ತಗೊಂಡ್ರೆ ಎಲ್ಲ ತಗೋಬೇಕು, give it, yes. Construction stay ಆಗಿದೆಯಾ? Application ಹಾಕಿ vacating stay ಗೆ. ಹಾಕಿದ್ರೆ immediate ಆಗಿ I'll give you a date. I'll give you a date immediately. Yes.
Another matter, many of the changes circumstance, 1980 suit, FDP is, as matter has to go with FDP court, Supreme Court orders. One daughter has died. Who ಮಾಡಿದ್ದೀರಿ?
Friday ಕೊಡಿ.
My lord, one matter at 2:30. Lord, this matter pertains to the.
Yes, one ನಿಮಿಷ.
Not moved my memo today, my lord.
What memos?
But I was given the date today
ಏನಕ್ಕೆ, for what purpose?
for serving the copy to the rest.
Servant come.
It has not come today.
You servant come, sir, it will come.
Served, my lord. It has been 15 days since I have served.
Huh.
Hardly bargaining 1 minute of your time to move to the next process, my lord.
Huh.
It was supposed to come today.
It will come, give it.
2:30.
No, 2:30, give it, yes.
My lord,
Friday,
my lord, this writ petition was filed in August to,
then Monday.
my
Yes.
lord,
Why?
Land acquisition of the Bidadi township, my lord.
Huh, so
More than 10,000 acres has been.
notified now. ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ?
Possession got them. Possession
Preliminary notification, possession ತಗೊಂತಾ ಇದ್ದಾರಾ?
already
Oh,
demarcated, my lord.
yes, sir. Very nice submission. Preliminary notification, possession ತಗೋ, ಎಲ್ಲಿ ಗವರ್ಮೆಂಟ್? ಯಾವಾಗ ಇದೆಲ್ಲ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದ್ದೀರಾ? Preliminary notification possession ತಗೊಳ್ಳೋದು? Some semblance in telling the urgency, sir. What is all this? What is all this?
Photographs.
Preliminary notification issue ಮಾಡಿ 4 ದಿನ ಆಗಿದೆ, possession ತಗೊಂತಾ ಇದ್ದಾರಾ?
March 2003.
What?
Notification.
ಕೊಡಿ, ನಾ Friday ಕೊಡಿ.
my lord, this writ petition was
ಸುಮ್ಮನೆ
filed,
ಅರ್ಜೆನ್ಸಿ ಏನೇನೋ ಹೇಳ್ಬಾರ್ದು.
my lord, this writ petition was filed in August to,
ಒಂದ್ ನಿಮಿಷ, ಲೀಗಲಿ ಟೆನೆಬಲ್ ನೀವು ಹೇಳಿದ್ದು. ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ ಪೊಸಿಷನ್ ತಗೊಳಕ್ಕಾಗತ್ತೆ? ಆಗತ್ತಾ ಹೇಳಿ? ಆಗಲ್ಲ ತಾನೆ? ಏನ್ ಮಾಡಿದಾರೆ ಈಗ ಮತ್ತೆ?
10,000 acres ಅನ್ನ ಸಮಿತಿ compounding.
ಆಯ್ತು, ಕರೆಕ್ಟ್. ಅದು ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ ಇಶ್ಯೂ ಮಾಡಿದಾರೆ ತಾನೆ? ಇನ್ನು ನೀವು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಫೈನಲ್ ದೇ ವಿಲ್ ಕನ್ಸಿಡರ್ ಅಂಡ್ ಪಾಸ್. ಏನ್ ಅರ್ಜೆನ್ಸಿ ಇಲ್ಲ ಆದ್ರೆ ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ ಸ್ಟೇ ಮಾಡ್ತೀನಿ ನಾನು. ಕಾನೂನು ಗೊತ್ತಿಲ್ಲ ಅಂದ್ರೆ ಬೇರೆ, ಗೊತ್ತಿರೋರೇ ಮಾಡಬಾರ್ದು. ಎಸ್,
my lord,
Friday.
my lord, this writ petition was,
FR ನಂಬರ್ ಕಂಪ್ಲೈ ಆದ್ರೆ ಮಾತ್ರ, ಅದು ಗೊತ್ತವ್ರಿಗೆ ಬಿಡಿ, ಕಂಪ್ಲೈ ಆದ್ರೆ ಮಾತ್ರ ಬರೋದು.
my lords, this writ petition was filed in August 2024, my lord. 1 year in, 1
ಓ,
year.
ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ ಸರ್ ಇಲ್ಲಿವರೆಗೆ?
Office objections comply ಆಗಿದೆ. It has.
ಆಗಿದ್ಯಾ? ಕಂಪ್ಲೈ ಮಾಡ್ತಾನೆ ಇದ್ರೆ 1 ವರ್ಷದಿಂದ?
ಇಲ್ಲ, comply ಆಗಿದೆ, my lord.
ತುಂಬಾ ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ?
ಇಲ್ಲ, kind
ಏನಿಲ್ಲ
1 year ಇಂದ ಬಂದಿಲ್ಲ. Date may be given.
ಅಯ್ಯೋ ಬೇಡ ಕೊಡಿ.
My lord, any date.
ನೋ ಪ್ರಾಬ್ಲಮ್, ಇಟ್ ವಿಲ್ ಕಮ್ ಸರ್, ಗಿವ್ ಇಟ್. ಎಸ್, ಗಿವ್ ಇಟ್ ಸರ್.
My lord, pending matter, my lords, whether remanded by the Supreme Court, my lord.
ಯಾವ್ದದು? ಯಾವ್ದದು?
My lords, please to direct CBI investigation, my lords.
ರಿಮಾಂಡೆಡ್ ಬೈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್?
Yes, my lord. States appeal, my lords. Court remanded.
ಚಂದ್ರಕಲಾ?
Yes, sir.
ಕೊಡಿ.
My lord.
ಫ್ರೈಡೆ.
My lord.
ಫ್ರೈಡೆ ಹಾಕ್ಸಿ ಮೇಡಮ್.
My lord, LABD a pending matter, my lord. May be taken on Friday, my lord.
ನೋ ಸರ್, ಗಿವ್ ಇಟ್.
My lord.
ಮೆಮೊ ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ.
Friday, my lord. Sir.
Yours will come on Friday because Supreme Court remitted matter. Yes.
My lord, GMCC fresh matter, my lord.
Please, ಯಾಕೆ wait ಮಾಡಿ?
Notification was issued on the, and it was affixed on the property yesterday and is listed today before the trial court.
2:30. Yes. No adjournment in the morning. Mention when it's called.
Lord, serial number 93.
No adjournment in the morning. Mention when it is
I am
called.
not seeking for adjournment, my lord. I am only requesting for priority listing.
Priority serial number?
Last 93.
I will see.
Street
If it does not reach by the end of the day, you make a mention. Yes.
Number 1,
ಇದಿರ್ಲಿ, pass over.
number 2.
ಅದು there is a different order passed by the court. ಅದು mistake ಆಗಿದೆ. What was your submission, madam? And you are wanting to file an application of that kind before the concerned court? Yes.
Not this honorable court, my lord, at an earlier point of time, my lord was pleased to see, my lord, that can't be clubbed because the property is different. Defendants are different. It can simultaneously taken up together, my lord, before the same court.
That is what I said, I guess. See, not clubbing, the same court will take it in seriatim. Then what? So what then? Which is, 1 minute, which is the order of this court which has rejected clubbing? ಈಗ ಹೇಳಿದ್ರಲ್ಲ.
Lord, the trial court has rejected.
L
the
court has
application,
rejected.
Against which, my lord, they are in.
ಬರಲ್ಲ, ಒಟ್ಟಿಗೆ ತಗೊಂತಾರಲ್ಲ ಬಿಡಿ. Then what? Then what, madam?
Because in all the cases, my lord,
Aithu.
evidence has been recorded, different exhibits.
Oh, wait. No, sir, don't worry. No, madam, don't worry. 18 cases. ಏನು ಜೊತೆ ಕ್ಲಬ್ ಆಗೋ ಬದಲು ಜೊತೆಗೆ ಬರ್ತಾ ಇದ್ದಾರೆ ಅಷ್ಟೇ. No, defendants are different. Defendants are different. They would have different projections. You claim ನಿಮ್ದು ಒಂದೇ ಇರಬಹುದು. Defendants different ಇದ್ರೆ different. You may be appearing, madam, but defendants are different. If the court is taking it simultaneously on the same day, no prejudice. I will not direct clubbing. That day also I told you the same thing, that I will not direct clubbing.
The reason why we file clubbing application is because it saves the court's time, and there are chances of the witness improvising his stand every 18 times.
No,
For the same, the issues involved is one and the same. If you can, I've also produced the issue copy also. All the issues which has been framed in all the cases is one and the same. It is regarding to the
Issues are same.
Issues are one and the same in all the 18 cases.
Evidence in all the cases has already been commenced. Documents have already been marked. 10 adjournments have been taken for cross-examination. They did not cross-examine. It is closed. Defendant side is closed. When the matter comes up for arguments, my lord, they come up before the court.
The clubbing application was filed and the matter was posted for cross-examination.
No, I'm not permitting clubbing, madam. I'll only pass an order. It's already coming in seriatim. Then what else can be done? Nothing.
It is being taken up simultaneously. Let the plaintiff PW1 be cross-examined with the common evidence.
That you file an application there. We will file an application. I will direct the court to consider PW1's evidence to be taken in common to all the 18 cases. All right? Yes.
Well, there was one submission that I made, early disposal request was made.
No. The petitioner is the defendant. The suit in OS 733 of 2018 is instituted by the respondent plaintiff. Suit for?
Declaration and possession.
Declaration and possession. The suits are 18 in number. The learned counsel for the petitioner submits, since the issues framed in all the cases are similar, a direction was sought before the concerned court for suits to be clubbed and heard together. The learned counsel for the respondent plaintiff submits that in every case the defendant is different. Issues may be similar, but since the defendant is different in every case, then they have been allotted the shops. It cannot be that they will project the similar contention. Each of the defendants would project the similar contention. The submission of the learned counsel of the plaintiff stands to reason. The concerned court has rejected the application filed by the defendant seeking clubbing of the suits and passing a common order. The learned counsel for the petitioner would fairly submit that the court is taking the matters in seriatim every day, every time when it is listed. In that light, no prejudice would be caused to the parties to the list, more so in the light of the fact that the the defendants are different. ಮೇಲ್ಗಡೆ ಒಂದು separate order sheet ಮಾಡಿ. This court had disposed the petition on so and so, noticing the error in the order. The learned counsel for the petitioner had moved a memo of being spoken to. A perusal at the order would indicate that it was inadvertently taken from another order. Therefore, the said order stands recalled. The matter is stands recalled and the petition is disposed by a separate order anta ಮಾಡಿ ಇದನ್ನ ಮಾಡಿ. In that light, suit 2017 will direct disposal. Since the suit is of the year, correct. The learned counsel for the petitioner submits that a direction be issued to the concerned court to examine PW1, who is common in all these cases, at one go. If such an application is made by the defendant before the concerned court shall pass necessary orders in accordance with law, as that would save the time of the court. Except the aforesaid observation, I do not find any warrant to interfere with the order passed by the concerned court. The petition is thus disposed with the aforesaid observations. Yes.
Lord, early disposal as expeditiously as possible.
It is needless to observe that the suit is of the year 2018. The court shall endeavor to conclude the proceedings as expeditiously as possible.
Great.
ಇದ್ರಲ್ಲಿ ಏನ್ ಮಿಸ್ ಆಗಿದೆ?
This is my lord, after we depositing the 2 crore
I
amount.
think I've written that only.
That is missing, my lord. My lord, may kindly see the last but one para, the penultimate para. Learned counsel for the petitioner
Submits that on the score of huge determination of tax and not approving the plan that is submitted before it. Submits that he would deposit the principal amount in that light or deem it appropriate subject. Oh.
My lord, today, my
No,
lord,
no.
I'll deposit with the registry, but a memo of compliance.
The learned, this court granted an interim order on 26/6/2025, which reads as follows. The petitioner moved the matter being spoken to, has moved the matter being spoken to on the score that the order that was passed was the plan would be approved subject to the deposit. Those words are missing in the order. The perusal at the diary of the stenographer would indicate that that was dictated and it is inadvertently omitted. The learned counsel for the petitioner also places a memo of compliance with the order of deposit of 2,75,91,552 before the registry of this court. As observed, the registry of this court shall keep the amount in the in a interest earning fixed deposit in interest earning fixed deposit in a bank. In the light of the compliance, I deem it appropriate to direct the respondent BD to approve the plan submitted before it, which shall however remain subject to the result of the petition.
Approve within a week or 3 days.
Approve within a fortnight. Please approve the plan within a fortnight.
Would my lord just clarify that if it is, they were otherwise complied with all other conditions?
Correct. Approve a fortnight in accordance with law.
Please, great.
My lord, there is actually one more small correction
Please.
is required. My lord, in the third last para, my lord, the learned counsel submits that he would file a statement of objection to demonstrate betterment tax is already determined in the year 2008. 18, my lord.
18. Alonso, already the learned counsel for the respondent submits that the indication at the third, at the 5th paragraph is that the betterment tax is already determined in the year 2008. It is the year, mentioning of the year is an inadvertent error. It should have been 2018. The correction be effected to, and correction as indicated here in above shall be effected to. Yes.
Great.
Certified copies. Yes, next. Animal trophy.
Yes, my lord should recollect this pertains to
Animal trophy. Yak Michael.
Edwin planning.
Should I tell you all the details? Illala.
So my lord, only from the complaint whether the ingredients of PMLA are made out or not.
ಅದಕ್ಕೆ ಸ್ಟೇ ಕೊಟ್ಟಿದೆ.
ಹೌದು. Detailed.
ಬಂದಿರ್ಲಿಲ್ಲ.
ನೀವು ಬರ್ದೇ ಇದ್ದಾಗ ಸ್ಟೇ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಾ?
ಅಲ್ಲ, that's not the reason, but
ಯಾರು ಇರ್ಲಿಲ್ವಾ?
ನಾನಿರ್ಲಿಲ್ಲ.
ಇನ್ಯಾರಿದ್ರು?
ನಮ್ಮ ಕೊಲಿಗ್ ಬಂದು ಟೈಮ್ ತಗೊಂಡ್ರು.
ಮತ್ತೆ
could I just point out the complaint?
No, this was, I had heard you at least 4 times before the day on which I granted an interim order.
My lord had actually indicated that stay would not be granted.
Oh,
yes.
You can make out a case for vacation now. You can make out a case for vacation now.
No, my lord, we will have it disposed, my lord.
No, you tell me how would giving of a letter or a certificate on a particular night would amount to offense under the PMLA.
Lord, my submission is this. My lord, this particular doctor initially would give a correct certificate.
Correct. At 11:40 PM.
After which, my lord, after which there's a sea of change at the behest, my lord, as admitted by the petitioner himself at paragraph
120B
12.
idea.
My lord,
120B allegation.
120B is the predicate offense. Adu allide. In fact, I would want.
Alle irbekagide.
Adu alle ide. In fact, even if he's not an accused there, because my lord, all those activities.
One need not be accused in the PMLA. 120B should be the allegation in the predicate
offense. It is an allegation. And
not only the poor, my lords.
Correct.
They clarify even 120B to be read with the offences alleged.
No
if the offences alleged are not scheduled offences, 120B by itself will not.
But my lord,
that's power of the.
Idral offenses ಏನು?
All the offences which are alleged against the
not
doctor,
scheduled offenses.
none of it are scheduled.
They are scheduled offences. They are scheduled offences.
Ashte, that is the only point that you have to tell.
It is 120B, 420, section 51 and 39 of the Wildlife Protection Act, which are all scheduled offences.
That is pertaining to them.
No, that's enough.
That is enough. That is
against you ಇರಬೇಕಾಗಿಲ್ಲ ಅದು.
Well, it's-
That's Pavana
how do you-
Dibur.
He's not even an accused.
That's Pavana Dibur.
Submission, I'll point out on 120B what Pavana Dibur holds, my lord. I'll point it.
My lord, let us assume for a moment, my lord, he is not an accused there. On that premise, we
But
will go.
need not be, sir.
And
I am
I
only
will,
telling.
I will even
If
submit.
if the trail leads to the person who is drawn into the web of PMLA, money trail or otherwise, he can be an accused in the
Yes,
PMLA.
yes, my lord. My lord,
But
all this.
the offense there against everyone should be 120B.
120B.
And the meeting of mind should be with this man who is
Yes.
drawn in the PMLA. That's all.
No, my submission is not that. I would submit to this, my lord. As far as this man is concerned, probably, my lord, he was not part of that forgery, fabrication of records, or keeping that man in custody, etc. All those things, my lord. My lord, there is a schedule offense. And my lord, there are proceeds of crime. These proceeds of crime are the properties at estates and houses, etc., animal trophies,
Correct, all that.
all those things. Now, my lord, what would happen, my lord, is this particular doctor, my lord, he would issue a certificate. He would first issue a certificate. My lord may kindly see the certificate which is produced by the petitioner himself. That is at page number 88. This particular certificate, my lord, is issued after 4 months of the death of this person.
Which page?
88.
88.
Initially, my lord, I will come to 86. Initially, the
No,
certificate.
this is 1/5/2013 certificate.
Yes.
All right.
Oh,
Date of death is 11/3/2013.
yes.
Correct?
Yes.
He was admitted at 2:45 PM, discharged at 9:30 PM, as was treated so and so. This is on the basis of the records. Which is the
This certificate 88, as admitted by petitioner himself, he says it's a mistake. I did not have the
on
records.
10/3/20 admitted. What records?
He says that he did not make the records, his hospital staff made it, and merely signed it on the health. 88.
No, this is to certify Edwin so and so at 7:50 PM, general weakness, cough, fever, so and so. IVs, antibiotic, discharged on the evening around 9:30 PM. I am at 88.
Yes, ಅದಕ್ಕಿಂತ ಮುಂಚೆ can I come to 86?
ಅದು ಮಾಡಿ, yes.
And the type copy is at 87.
Yes.
This is to certify that Mr. Edwin Jobert Van Egwin, so and so, died by lung infective cardiorespiratory arrest at 5:30 AM on 12/3/2013 at Bisalmanti, Mysore, India. This is the original certificate. My lord, the date is more than the date. The time is very important.
5:30 AM.
5:30 AM. Now, my lord, what would happen, my lord, is that this particular person would give a complaint the previous day. He would give a complaint of all these allegations the previous day, and he dies early morning. He is pronounced dead by the very same doctor in the morning. Then, my lord, after about 4 months, the first accused, who is the beneficiary and the kingpin and all that person would approach him, as admitted by the petitioner himself in his petition. My lord, it is found at paragraph 13 of the petition. He would say, can I take my lord to paragraph 13?
Yes, sir.
At page 8.
Yes.
Say, the petitioner avers that approximately 2 months subsequent to the issuance of the initial death certificate, an individual identifying himself as Michael Floyd Ishwar, purporting to be the son of the deceased Mr. Edwin Jobert Vanigan, approached the petitioner's hospital seeking a death certificate. In response, the petitioner instructed the hospital authorities to verify the records and prepare the document. Accordingly, the death certificate was drafted by the hospital staff and duly signed by the petitioner in accordance with standard procedures. The copy of the death certificate dated 1/5/2013 is produced as P. The petitioner acknowledges the death certificate which is signed inadvertently state the time of death at 12:30 AM instead of the correct time at 5:30. This clerical error is alleged to be inconsistent with the time recorded in the initial certificate, leading to the current dispute. Now, my lord, I would take my lord now to this particular this. He admits it is at the behest of someone else. That is the main person. Kindly see page 88. This is not actually a death certificate. It is more of a death report. This is to certify
to
that.
whomsoever it may concern.
Yes, but I will show subsequently how it was used. This is to certify that Mr. Edwin Jobert Van Egwin, aged about 101 years, male, admitted on 8/3/2013 at around 7:50 PM, and generalized weakness, cough, fever, treated so and so at attributable, discharged on evening around 9:30 PM. He was readmitted on 9/3/2013, 3 PM, and discharged at 9:30 PM on the same above treatment. On 10/3/2013 was admitted at 3 PM and discharged at 9:30 PM and for the above treatment. On 11/3/2013 was admitted at 2:45 PM and discharged at 9:30 PM was treated and the same above medications. The patient was semi-conscious. These are all very important. Restless, was not responding to the oral commands from 8/3/2018 till 11/3/2013 and declared dead so and so. My lord, it is not the death. It is this explanation saying that he was incoherent, he was unconscious, he was semi-conscious and was not obeying to the demands. Now, my lord, what happens is,
and declared dead on 12/3/13 at 12:30.
yes, let us forget that time for the moment. It might not, as per the petitioner's statement, make much of a difference. But my lord, these statements makes a lot of difference. Now, my lord, what happens is that the main accused, the petitioner of the predicate, the first accused of predicate offense, files a quashing petition before this honorable court.
Justice Satyanarayana avaru.
I don't want to read much because it has been harshly come down by the honorable Supreme Court. My lord is aware of it. That particular certificate is used, and my lord, this honorable court would quash the case against him. There, my lord, there's a noting stating that this person was incoherent. He was not able to go to the police station. It appears as if
Which is my order after that.
My lord's order, my
Because
lord,
I have dismissed it.
Yes, it is dismissed. Taking note, it is not before the court, but
It's not produced here.
It's not produced.
Yes, Sandesh sir.
No, my lords, that order is not produced. My lord's order
You
of
have it-
A1
have it
is
with
not
you?
produced. I'll give it, my lords.
Because it's a detailed order on accused number 1,
My lords dismissed the quash petition of A1. My lords, I will give.
which was allowed earlier.
Which was
Yes, my
allowed
lord.
earlier.
Allowed earlier,
Lordship,
apex court comes,
Set it aside,
sets it aside and
investigation
comes
went
back.
on. Yes, my lords, investigation
then it
goes-
comes back to me.
Then it came back and my lords dismissed it insofar as A1 is concerned.
That is,
Absolutely right.
did not go back to
No,
the
no,
Supreme
no,
Court. Yes.
No, they are facing trial, including this petitioner who was subsequently included for destroying the evidence.
For this particular,
I'm not on that at all, my lord.
now, against him, it's 120B and 201.
Only 201 and
Only
201 and 120B, correct? Yes.
My lords, against me is 197, 201, 465, read with 120B. 3 are not schedule offense. 120B is a schedule offense.
120B is a schedule
Schedule.
offense.
And
These-
420
I will-
also against everybody. So, my lord, my
Okay.
submission is.
That's all right.
Out of
Yes.
the charge sheet prakara, they've
None-
segregated.
Earlier order ಕೊಡಿ. Earlier order ಇದ್ರೆ ಕೊಡಿ.
And also, my lords, what's the exact offenses against each is in the charge sheet
You have
itself.
not produced here?
No, my lords, the charge sheet,
Code of
kindly
Sir,
notice the offenses so that 420L al baralla. They've segregated against whom, what are the offenses alleged, which is marked in pencil, my lords there.
My lord, I would submit, my lord need not even look into it. Let us assume that he is not even an accused. Now, my lord, what happens, my lord, is that this particular person uses this particular certificate and projects this proceeds of crime as untainted. Now, that is where the role of the petitioner would come under the PMLA Act. My lord, he has supported him to project this proceeds of crime as untainted. Though this particular offense might have happened earlier, he might not have been an accused also. But my lord, subsequently by supporting him, which is a process, my lord, which is always continuing, my lord, he is not guilty. Is my submission. In fact, Pavana Dibur judgment, my lord is aware.
No, I had dismissed it.
Haudu.
I had dismissed it.
And
Apex
it went
court has
to Supreme
reversed
Court and Supreme Court reversed it. My lord, it's very clear. It's not-
reversed it on a point that was not argued before me. But that was, that's what the Apex court observes.
Yes. But my lord, may kindly see that Pavana Dibur judgment, my lord. In fact, it clearly with illustrations it has been given. And I don't want to waste the time of the court.
No, I am
My lord,
aware
may
of that.
cle-
I am
it
aware
says
of
about 269 paragraph.
No, I am aware of
270
that.
ಎಲ್ಲ ತಾವು ನೋಡ್ರಿ. It clearly says, my lord, that even if he is not an accused,
That is
even
why,
if he is
that is why,
not,
there 120B was not the offense.
it was not the offense.
That is why Supreme
Yes,
Court.
and the
said
Supreme
it.
Court would say 120 by itself will not be a predicate offense. It will have to be with conjunction with another predicate offense, which is here. And my lord, he might, yet again I would submit, my lord, he might not be part of that entire cheating, etc., my lord. But my lord, subsequently having generated proceeds of crime by them, he is now supporting them to project it as untainted. Is my submission.
He is in aid to that.
He is in
project.
aid to that. So, my lord, it will come under the rigors of Section 3 of the PMLA Act, or, and that is all is my submission.
RRR. Okay, yes.
That's my submission is reading of this complaint, whether the ingredients of section 3 is made out against accused number 4. This is the basic submission. My lords, the case of the prosecution is that, my lords, there were 3 documents that were allegedly fabricated. Now, the fabrication of the three documents were a sale deed, adoption deed, and gift deed. All this has happened between 2005 to 2007. The persons who have fabricated, accused number 1, signatories to those documents are 2 and 3. So A1, A2, A3 are part of the predicate offense where they say it's fabrication of records. Now, my lords, dehorse what transpired earlier, post investigation against A1, A2, A3, the offenses alleged are cheating and other predicate offenses read with 120B. The offense against the doctor, my lords, in the charge sheet is 1 on 201, 465, 197, read with, my lords, 120B. Very specific insofar as the doctor is concerned. 3 are not schedule offenses. 120B is a standalone offense that I will point out through Pavana Dibbur, my lords, what they say in 120B. Now, my lords, coming down to whether this complaint discloses the ingredients of section 3. For section 3, my lords, has repeatedly held, my lords, one is proceeds of crime, money laundering. There should be a process or activity in furtherance of the dirty money, which has led to a proceeds of crime. This is how section 3 is looked at. Now, please have the complaint, my lords. I'll point out from the complaint itself. The complaint commences at page 18.
Yes.
My lords, the relevant portion, page 19. Let us see the FIR is pointed out there, my lords. The FIR at page 19 for the predicate offense. My lords, the FIR, the information was given on 2/3/2013. That may be relevant, my lords. But the FIR gets registered on 11/3/2013. That is evident from the documents itself. Now, in the FIR, please look at the very first paragraph, my lords, when the offense is alleged to have taken place, my lords. Entire cheating, breach of trust, and so-called amassing proceeds of crime is between the periods, my lords, 2005 to 2007. My lords, our proceeds of crime, my lords, what is relevant here is proceeds of crime. That proceeds of crime, according to their case, they've given the dates, my lords, 14/11/2005 to 10/8/2007. This is most relevant, my lords. My lords, a certificate given in 2013, how would it be relevant for the proceeds of the crime? The period is important. Now, this entire act, according to them, is between 2005 to 2007. Persons involved are 3. They are the ones who have the proceeds of crime. Please notice in this, my lords, paragraph 1 in the, they talk about the sale deed, adoption deed, gift deed, and the will at page 20. My lords, they would say the beneficiary of all this is accused number 1, my lords. That's Michael Floyd Ishwar. The persons who aided him are accused 2 and 3, Dharma Gopal and Rego. Now, these are the 3 persons. Now, kindly now notice, my lords, against the doctor, page 20 in the bottom. What is it that they say about the doctor, about him giving a death certificate of a person who was aged 101 years that time, my lords?
Exactly.
Please notice, my lords, Dr. Chandrasekhar. He is a doctor. I'm sorry, my lords, I'm at page 20 bottom only. Please notice, my lords, he comes in picture in 2013 only for the purpose of treating this person for 4 days and issuing a death certificate. The point is, did this death certificate, was it used for any proceeds of crime? That's the point, my lords. From their complaint itself, it doesn't. So, my lords, in the bottom, they speak about the treatment given by Dr. Chandrasekhar. Page 21, my lords.
Yes.
And my lords, kindly, most relevant would be, my lords, the dates which they have put in there. 2013 is when he treated for 4 days and he has issued the death certificate. Then, my lords, please notice page 23. E in the bottom, my lords. The 3 or 4 deeds which are mentioned there.
Yes.
In E, sale deed, adoption deed, gift deed, will between 14/11/2005, 8/10/2007. Specific dates which we get at page 23. Then, my lords.
Yes.
When the summoning took place under section 50, on 2 dates, the doctor was summoned. My lords, gets it at page 26.
Yes.
Serial number 10, my lords, page 26, serial number 10.
Yes.
His statement under 50 recorded. And then, my lords, how they would say that it is a case of money laundering commencing from page 28, paragraph 3.
28,
Paragraph 28, paragraph 3.
yes,
Brief facts which leads to PMLA.
yes.
Right in the bottom of that page, the investigation conducted, going to the next page, my lords, by
Yes.
the CID, Bangalore establishes that Michael Floyd Ishwar had acquired properties illegally by committing offences and thereby projecting the same as untainted property. Now, what's the specific allegation? It is A1 who has acquired all these properties illegally, and that is the untainted property.
Correct.
So, my lords, at this point of time, process or activity hasn't commenced, my lords, because once you have the untainted property, you do a process and activity that brings it under laundering. So here they speak about the untainted property by A1. Thereafter, my lords, please notice page 30, G, my lords. Against whom are you establishing a case of laundering? Page 30, right at the bottom. Last 3 lines, it was established that Michael Floyd Ishwar had indulged in the offense of money laundering under so and so. Then, my lords, on the next page, the value they give of proceeds of crime is 120 crores. My lords gets it at page 31.
Yes.
And who do they attribute 120 crores? Only to A1 and supported by A2, A3. Please notice there, my lords, at page 31. The properties are mentioned. Page 32, description of the property is most important, my lords, all standing in the name of A1. And all this again relatable to 2005 to 2007. Standing in the name of A1, page 33, the other property standing in the name of A1. And in the bottom value may be seen, my lords, 117 crores, all standing in the name of A1. This is the proceeds of crime. Then, my lords, please thereafter notice, specifically, they would get statements of others, my lords, in which we have only one witness. Now, just prior to that, the investigation against A4, my lords would get that at page 38. 38. All that they say, my lords, on the basis of statements of recorded.
38 to 39.
30, all that they say is you had given 2 certificates. One was dated, one was timed at 5:30, other at 12:30. That is your allegation.
Yes.
Now, my lords, a written statement was taken of one independent witness, my lords. That independent witness is a great granddaughter of the deceased.
Yes.
My lords, at page 39. Her entire statement from page 39, my lords, till page 45, all is against A1. He was the one who has done this. He has the proceeds of the crime. Everything is against A1. The only independent witness that we have. And then, my lords, what is the role attributed to A4?
You had
Please,
filed discharge also?
how the discharge was rejected. That's why we have come here. My lords, page 45 only, kindly notice second paragraph, my lords. What is my role? I go back, I'm informed in the morning that he's not breathing. I come, I examine him, he's dead. This is the role. Please notice at page 45, second paragraph.
On the next day, 13th.
On 11th night, page 45. my lords.
That paragraph is it?
Yes, my lords. She was sleeping, she calls me, I go there, I find he is dead and I declare him dead. This is all. Nothing to do with anything of the property, nothing to do with anything of the proceeds. Not that a penny has been paid to me from the proceeds of the crime, nothing. Then, my lords.
Not necessary for you to make money out of it.
My lords, proceeds of crime is bekagutte. Process or activity in furtherance of, my lords, otherwise 3 will not come. If I'm not going to be, my lords, for 201 is different, my lords. Destruction of evidence is different. But for PMLA, my lords, proceeds of crime, I must be a part of proceeds of crime. Now, this certificate issued by me in 2013, how does it affect the fabrication done in 2005 to 7? Please notice thereafter, my lords. Further, they themselves, my lords, in the complaint, they make it.
You should restrict your submissions to A4.
How do you?
You're going to A1 to A3 to say projecting tainted money from 2005 to 2007. Your role springs for 4 days, sir.
How? My lords, page 47.
8th, the patient comes to you according to you.
Page 47.
8 to 11th, you have treated him. 12th he dies. One certificate says he dies at 5:30 AM. That is on the 13th. The other certificate you say it is 12:30 AM. All right. Because of the discrepancy there, he files a petition quashed, Supreme Court reminds, all that fine. Now you are drawn into the web of PMLA at a later point in time.
Proceeds of crime.
That we'll see.
That's all. My lords, I think page 47 specifically they say about this treatment of this given by this doctor. Page 47, B in the Hiddu, G varige, my lords. That is the treatment which we have given. Then, my lords, they say role of each accused is specified in the complaint. Page 52 may be noticed.
Page 47 leno B2?
B in the next page, G varige, treatment given by the doctor. Then, my lords, page 52 only individual roles attributed. Page 52, please notice the roles attributed, my lords. Accused number 1, according to them, is a kingpin who has done all this. He is a person who has done the fabrication and enjoyed the fruits of that fabrication. That's how it is. My lords, 52, role of A1, my lords would get that.
Yes.
And they would then go to role of accused number 2 who has a signatory or a fabricated document at page 54. Similarly, A3 who aided this at page 55. He helps the fabrication of record. And page 57 is the role of accused number 4.
57 to 59.
Idralli, my lords, whether there is anything to do with PMLA. Anything. Not a penny given to him, nothing. He has only given a certificate. Certificate has not been used as an aid towards any process or activity under section 3. Now, if that is so, my lords, if it is not used at all, how is it that he is being prosecuted under PMLA? My lords, that would be my first submission, my lords, and false in the at best, my lords. Page 58, I have noted the conclusion insofar as A4.
Yes.
Page 58 ali. Please notice his conclusion. Dr. Chandrasekhar.
Committed offence under 120B IPC.
The 201
Has committed
IPC.
offence on 201 and likewise false death certificate planned to escape from involving the so.
Yes, my lords, 120B giving a false death certificate. This is what they say. Now, my lords, how does this constitute a laundering? Now, if their whole case was my death certificate was used for them to create a document and they've been able to have proceeds of crime there, understandable. Their own cases, all this fabrication took place between 2005 to 7. They've enjoyed the fruits of that fabrication. They're enjoying the proceeds of crime.
Fabrication with regard to accused number 1, fabricating everything and taking away the property of the old man or not.
Yes.
In fact, he had tied him in the outhouse,
Correct. My
kept
lord
him
said,
in the outhouse,
my lord said observed all that, my
took
lord.
away all his property. And later, because of the death certificate, everything has happened, is what they say. Laundering agatto ilva, will answer it.
Because of the death certificate, ಏನಾಗಿದೆ ಅಂತ, that they must say. Was it used? My lords, idralli, kindly notice, my lords, I'll just finish last portion of it, the offenses which they've alleged. Page 59 ali, just above paragraph 11, the last portion of it. Thus, it is evident he had knowingly assisted, involved in criminal activity under 2(1)(x) and (y), punishable under 3 of PMLA. Not one ingredient, my lords, which would get attracted in so far as section 3 is concerned. Now, kindly now notice. Pavanadipur.
Yes, yes.
But even I am relying on the same judgment.
Yes, my lords, it's useful for two purposes.
Yes.
I am ಕೊಡ್ತೀನಿ.
ಕೊಡಿ, ಇವರೇ ಕೊಡ್ತಾರೆ.
My response will be at para 15 of the judgment, my lord.
It's my judgment, I know.
ಹೌದು. Coming back to section 3 of the PMLA, on its plain reading.
Onde nimisha, which is favorable to me, I will just point out. Then, my lords, two important aspects here, my lords, in Pavanadipur. You need not be an accused insofar as a predicate offense.
No problem.
A classical example is, my lords, in a case of cheating, if 10 crores has been cheated by A.
That is money trail coming here.
Money trail, if B aids in getting proceeds of the crime, he becomes an accused in PMLA, though he's not an accused in the predicate. This is one aspect.
No, you need not labor on
That is
illustration.
what, my
Come
lord,
to the point.
And the point is whether 120B by itself would be a case that
Why
can-
120B can't be a standalone offense?
That's what, my lords, kindly notice, my lords. My lords,
No,
paragraph,
are you saying 120B can't be a standalone offense?
for the case of PMLA, they say no. Please notice, my lords, paragraph 29, paragraph 29. My lords, the earlier view was it could be 120B by itself could be, but here the interpretation was you will have to see 120B for what? If 120B for a non-schedule offense, you can't attract 120B for PMLA. If it is for a schedule of paragraph 29.
29.
ಹೌದು. My lords, which
ಈಗ ನನಗೆ SCC ಔಟ್ಪುಟ್ ಕೊಡಿ, ಸಾರಿ ಪ್ರಿಂಟ್ಔಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ. ನೀವು SCC ಆನ್ಲೈನ್ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ. ಇವರು ಮನುಪತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ.
This SCC online, my lords. Adರಲ್ಲಿ paragraph 29.
Correct.
Please notice, my lords, this
Scheduled
paragraph
offense,
deals
yes.
with 120B.
Paragraph 29.
Full, my lords, they say conspiracy is an agreement between the accused commit an offense. If you look at the punishments provided at 120B, it becomes evident that it is not an aggravated offense. It only incorporates the principles of vicarious liability. So, my lords, we read it along with the offense for which it has been alleged. Now, the offenses which have been alleged against me in the predicate offense are all unscheduled offenses, non-scheduled offenses. Section 120B included in so and so. In other words, the offense is punishable. Coming back to the facts of the case, so and so.
Sir, your answer, the answer lies in para 30.
31.5.
No.
31.5.
Answer lies in para 30. Amal 31.5.
31.5 ಅಲ್ಲಿ ತಾವ್ ನೋಡಿ. The offense is punishable under 120B will be.
Wait.
I'm sorry, that's 31.5 ಅಲ್ಲಿ. The offense is punishable under 120B IPC will become schedule offense only if the conspiracy alleged is of committing the offense which is specifically included in the schedule. So, my lords, even according to them, the predicate
Sir,
offense.
in Pavana Dibur's case, there was no allegation of criminal conspiracy at all.
How, when my lords dealt with the matter,
There was no allegation of criminal conspiracy. So para 30 came about.
Yes. And 31.5, my lords may just notice that.
Yes,
in case,
yes,
my lords,
sir.
because if it is their case that I am roped in only on the base of 197, 201, 465, none of it are schedule offenses.
Yes, sir.
If they're only going on 120B, this is the answer.
Yes. Heard, reserved.
And my response would be at paragraph 15 in my Manupatra judgment, my lord. Said,
Like how it starts with what?
It starts with coming back to section 3 of.
Indian.
I'll book it. I'll give you an extra. 17, para 17.
My lords, I'm not giving Vijay Madanlal Chaudhary, my lords, though it deals with process and activity. Section 3, in fact, my lords, in Parvati's case has dealt with it elaborately. When it becomes an offense, there has to be a process or activity in furtherance of the proceeds of crime. That portion, my lords. Ultimately, my lords,
Entry mode subsisting would continue till the disposal of the petition. Next.
Number 5.
On filing of
The cost, your
acknowledgement.
lordship.
Cost.
There was a cost, the matter has been dismissed.
Nanda.
That a petitioner was on the wheelchair.
Hold that, yes. The order imposing costs of rupees 1 lakh upon the petitioner dated 13/2/2020. The application ಹಾಕಿದಾರ ಅವರು? Present ಇಲ್ಲ application. Let him file an application. ಇದು ಮಾಡಿ. The order stay ಮಾಡಿರ್ಬೇಕಲ್ಲ last time. I've stayed it. Yes. List the matter on 21st. Next. Withdrawal in terms of the memo. Next.
7.
Furnishing R6 to R10. ಇದರಲ್ಲಿ ಸ್ಟೆಪ್ಸ್ ಏನು? ಮತ್ತೆ ಅದೇ ಅವ್ರು ಯಾರು ಅಪೇರ್ ಆಗಿದ್ದಾರೆ? Tag the petition along with ಬರ್ಕೊಡಿ. So and so. List after 2 weeks. Entry ಮಾಡಿ ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ. Next.
8.
ಈ PDS ಯಾಕೆ ನನ್ ಮುಂದೆ ಹಾಕ್ಸಿದ್ರಿ ಎಲ್ಲ? Huh?
First matter, my lord, we have filed a memo for
We have
retirement.
filed a
my lord.
memo of retirement.
That
Twice
has
the
not
matter
been
has come
accepted,
up.
my lord.
Memo for retirement hakidira.
Twice, my lord.
ಹಾಕಿದ್ದಾರೆ.
Then it should go before this regular court.
Please, my lord.
Where is that?
That one for re-
Siddappa
dealing
BM. First matter la?
First matter.
148.
ಒಂದ್ ನಿಮಿಷ ಸರ್.
First matter, Shruti Chaganti.
ಇದು ರಿಟೈರ್ಮೆಂಟ್ ಹಾಕಿದ್ದೀರಾ?
Retirement ಹಾಕಿದ್ದೀವಿ sir. On 6-1 itself we have filed, my lord.
ಏನಾಗಿದೆ ಮೇಡಮ್?
Yes, sir. 1322. 1489 of 2024. First matter itself, my lord.
India.
8.1.
Authorization cancel ಮಾಡಿದ್ದಾರೆ.
The learned counsel appearing for the fourth, ಇದು serial number 8 ಅಲ್ಲಿ order. Learned counsel appearing for the fourth respondent submits that the learned counsel has filed a memo for retirement. ಯಾರಿಲ್ಲ ಬೇರೆ ಬಂದಿಲ್ವಾ?
ಬೇರೆ ಬಂದಿಲ್ಲ sir.
Memo for retirement. In the light of the memo for retirement being filed by the fourth respondent, the matter be posted before, these matters be posted before the bench having appropriate roster as the disability is no longer in subsistence.
Name may be deleted.
Interim orders subsisting in these cases shall continue till the next date of hearing.
Name may be deleted, my lord.
The registry to delete the name of Shruti Changati as appearing for the fourth respondent. Next.
9.
Your lordship, one small submission. In 8.1, there is no interim order at all, your
ಇಲ್ಲ
lordship.
ಅಂದ್ರೆ ಅದು ಇಲ್ಲ ಅಷ್ಟೇ. Yes.
My
ಅಲ್ಲೇ ಕೇಳಿ.
lordship,
ಅಲ್ಲೇ. Next.
The 8 it is there.
Serial number? R1 ಯಾರು?
I may be permitted to find the color.
ಅಲ್ಲಿ ಹಾಕಿ registry ಹಾಕಿ. Learned counsel so and so undertakes to enter appearance for the first respondent. Registry to print the name of so and so as appearing for the first respondent. The learned counsel for the petitioner files a memo seeking dispensation of service issuance of notice upon R2 to R34. The memo is taken on record. The issuance of notice stands dispensed with at the risk of the petitioner. Interim order subsisting will continue till the next date. ಏನ್ suit ಏನು?
Partition suit, my lord.
ಯಾವಾಗ ಹಾಕಿದ್ರಿ?
After 18 years, my lord. My lord.
List, 1 minute. List on
Urgency
next,
is that-
one ನಿಮಿಷ. List on next Wednesday in preliminary hearing.
Urgency is that, my lord, there is a time bound given by the honorable.
No, that's all right. Yes, we'll close it.
Yes, my lord.
Yes.
10.
List next, 9th hack in preliminary hearing. Interim order subsisting will continue to the next date of hearing. Yes, what is this?
Lord, this seems to be a challenge to two orders passed in execution proceedings. The entire dispute arises out of a dispute under the Karnataka Sauharda Act. I am a claimant and I brought a dispute and an award is passed in my favor. Appear under instructions, my lord.
Yes, yes.
So the award is
No,
in
no,
my
let the
favor.
petitioner start.
Please, my lord.
Rectification of office objections raised in IA 25. What is IA 25? IA 1 of 25.
Infructuous now.
Learned counsel for the respondent submits that IA 1 of 25 is rendered infructuous, is disposed as having become infructuous. Next, it's vacating interim order.
Yes, madam.
ಹೇಳಿ.
Madam, respond number 3 is the society reached under the provisions of Sauharda Sahakari Act, my lord.
All right.
The respond number 1 and 2 are the members of the society. They had deposits with the respond number 3 society, my lord. My lord, it is appears that, my lord, in view of non.
What is the order under challenge?
I will just be argument. In view of non-payment of the deposits, they filed a dispute before the society register, joint register of the societies, my lord. My lord, in the meantime, what has happened, there was certain omission and commission of the respond number 3 society. The government of Karnataka, by its notification, my lord, I produced appointed the competent authority, my lord. It is in page number 15, page number 49, my lord. I am permitted to read, my lord, the
suit for what?
They have for recovery, in view of the, my lord.
What recoveries?
Refund of the deposit of amount.
How much deposit?
4 lakhs has been deposited by them.
Deposited
interest.
before, with whom, sir?
With the respond number 3 society.
You are petitioner.
I am the petitioner and I am the ex-director of the respond number 3 society.
Why are you before the court?
My lord, they have filed an execution petition making me as a party to the proceedings.
You
My
are
lord,
not a party in this suit?
Yes, in the dispute also, it is an ex parte order. It has been made an order against all the office bearers of the society need to be paid the amount jointly. My lord, Annex G, page number 49. It is a notification issued by the state government of Karnataka
My lord, in view of the omission and commission of the respondent Mathri society, invoked the section 5 of the KPID Act. And appointed the competent authority to seek, call for claims from all the depositors of the respondent Mathri society. My lord, in view of section 10, my lord, there is a clear bar to the proceedings to be initiated. My lord, I may permit to read section 10, my lord.
KPID independent ಆಗಿ ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಬಹುದು ನಿಮ್ಮ ಮೇಲೆ.
ಇಲ್ಲ, all the proceedings he says that should be transferred to the special court ಅಂತ ಹೇಳಿ.
ಈಗ now it is before the civil court.
Yes, my lord.
In execution.
Execution.
That's right. They have not, and the
All
award
pending
remains
proceedings. It
unchallenged.
says all pending proceedings. It says that I may permit to read, my lord. Section 2, the
ಯಾವ್ದು page 49 is it? ಯಾವ್ದು section 10 ಓದ್ತಾ ಇದ್ದೀರಾ?
Section 49 I may permit to read, my lord.
That I have read, sir. Come to section 10.
Yes, my lord.
Yes.
Section 10, my lord, the special court. For the purpose of this act, the government may, with the concurrence of the Chief Justice of the High Court of Karnataka, by
ಸ್ಪೆಷಲ್
notification.
ಕೋರ್ಟ್ ಇದೆ, ತೊಂದ್ರೆ ಇಲ್ಲ. jurisdiction ಬಗ್ಗೆ ಹೇಳಿ.
That is there, my lord. Constitute one or more special court and subsection 2 may by permit to read, my lord. No court, including the court constituted under the presidency of the Town Insolvency Act, other than the special court shall have jurisdiction in respect of any matter in which provisions of this act is invoked.
All right.
Yes. Subsection 3, my lord, any pending case in any other court in respect of which the provisions of this act is invoked shall stand transferred to the designated court from the date of notification issued under subsection 1.
All right.
My lord, the notification, my lord, it is dated on 59/2023. As per annexure G, my lord.
Now what is the order now challenged?
My lord, I have filed an objection stating that this
Page.
page, my lord, impugned order is page number 22, my lord. Relevant page number 14, my sir. Reason, my lord. I take this honorable court, my lord, page number 20, my lord. Para number 3. By relying on the above said order of appointment of a special officer and the order of appointing a joint registrar of a cooperative society as a competent authority, and also relying on the copy of the that is another JDR, my lord, vehemently argued that the learned counsel for the JDR number 5, 6, 7 and there is no personal liability against the judgment that are, and the properties of the society judgment number 1 society are vested with the competent authority. The claim of the petition should be before this such competent authority, not before this court, and have prayed for dismissal of the execution petition. My lord. What the trial court says, my lord, executing court, my lord, unless otherwise the order is modified or nullified, this
The executing court cannot go beyond the decree.
beyond, that's what I
Correct?
said. Executing court cannot go, but when there is a special act, section 19, my lord, it is a special enactment.
ಅದು ಮತ್ತೆ ಗೊತ್ತು. Yes.
Section 19 of the KPID Act, my lord.
Yes, sir. Overriding effect.
Overriding effect, my
Correct.
lord. Overriding, this is a 2000, my lord,
Yes,
this
sir.
act came into force in 2004.
Got points, my lord. The notifications would not come to my learned friend's aid because all of those are after the date of my award. In fact, after even the date.
What is the date of the award?
Please, my lord. Date of the award is 27th of March, 2022. 23. And the date of the notification.
59.
That is 59/23.
2023.
Yes.
The second, my lord, the notification itself clarifies the reason the notification is being made is so that those who have not made a claim already can approach an authority. My lords will see that on page number 52.
Yes.
It says, in order to avoid duplication of efforts, necessity has arisen that a competent authority call for claims from all depositors. I am already a depositor in favor of whom an award has been passed. The third issue, my lord, is that they were all the petitioners were parties before the competent authority and award was passed against them. The award remains unchallenged. Their objection before the executing court was that the executing court does not have jurisdiction because it does not fall under the Sauhardi Act, but actually falls under the KPID Act. Another writ petition had been filed before a coordinate bench where
What happened to that?
it was dismissed on the ground of maintainability because the award had remained unchallenged with a finding that these disputes are covered under the Sauhardi Act.
Madam Tole.
My lords will see here what had happened. They filed a writ petition directly challenging the award itself. My lords will see the issues are considered.
Anything else, sir?
That, what the my learned is submitted, my lord. The notification, it not says that only who have not claimed that. It is a
Anyway,
clear
it is
case.
long after the award, sir.
That's right.
Irrespective, my lord, when
There is
the,
no irrespective. It does not have retrospective effect.
There's-
What
it is
irrespective?
not retrospective.
There's just
when
one
the
other point. I'll add.
prospective effect itself, my lord. When-
Prospective effect is ನಿಮ್ಗೆ apply ಆಗಲ್ಲ. Irrespective ಬರಲ್ಲ. It is retrospective ಆಗಿರ್ಬೇಕು ಅಷ್ಟೇ.
But the
when
last
the-
point I would like to make with my lord's permission is that the notification was passed because the directors, such as the petitioners, had mismanaged in the funds and an
Escape
Yes, that's
liability.
right. It cannot
Yes.
be that they escape liability.
Anything
through
else,
this.
sir?
Well, it is not escape. The
ಬಂಗಾರ ಕೊಟ್ಬಿಡಿ
the
ಅಷ್ಟೇ.
notification specifically. says,
ಡೆಪಾಸಿಟ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಈ 4 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ರೆ ಕೇಸೇ ಬರ್ತಾ ಇರಲಿಲ್ಲ.
My lord, it is a case, my lord, competent authority has taken the assets of the, all the societies of the respective 3 societies. Now, paying by this petition does not arise. Now, competent authority has taken care. My lord, in recently, my lord, the,
Competent authority comes into existence on 15/9/2023.
Yes, my lord.
Yes, sir.
they have taken all the assets and
No problem, sir.
depositors, the liabilities. My
Court
lord.
will direct them to produce. Don't worry, sir.
My lord,
Lord,
not only that, my lord,
I
they
appear
have
for
also
respondent
called.
number 1 and 2 in the
You are for
matter.
the plaintiff.
For the respondents.
This is a connected matter, my lord.
My lord, in
There are
both the
two-
matters, I appear for respondent number 1 and 2, my lord.
You are appearing for the society,
No, my lord.
My lord,
for
there
the
are two-
depositor.
Depositors, my lord.
Dharnesh,
DHS, in-laws.
in-laws, what in-laws?
My lord,
DHR.
decree holders.
Not a
my lord.
party to the.
Decree
it is
holders,
not
my
a
lord.
party.
My lord, the short issue which arises for this.
No
consideration
issue
is there.
arises. Nothing is there in this case. Anything else, sir?
There is a matter, is there? My lord, on 26/4/2025, the competent authority issued notification calling all the
Correct, sir.
deposit. Yes, my lord.
Award date ಹೇಳಿ, sir.
My lord, irrespective, when there is a award.
Irrespective ಬರೋಲ್ಲ when it is
Sir,
not
there is award, without
retrospective.
there being an award, my lord, there is a claim, they
No, I
can make
did
it,
not
my lord.
convince you. Now, date of the award is 1 year, 1.5 years before the notification.
Yes, my lord.
ಅಷ್ಟೇ. Anything else, sir?
My lord, irrespective.
I
if
must
there
be
is- there-
irrespective.
Even
Irrespective
otherwise,
of
my
it, I'll
lord,
impose cost now.
my lord, I
What,
am
sir?
permitted to make submission, my lord.
You
Even
think
otherwise, if there is no award also, they are entitled to make claim, my lord. That's what I wanted to make a
ಈಗ
submission.
award ಇದೆಯಲ್ಲ, sir?
Even otherwise, ಇದ್ರೂ ಸಹ
ಇದ್ದವ್ರು
ಮಾಡಬಹುದು.
ಮತ್ತೆ ಹೋಗಿ ಕ್ಲೈಮ್ ಮಾಡ್ಬೇಕಾ ಅಲ್ಲಿ?
They have to make application, my lord, to claim
ಬೇಕಾಗಿಲ್ಲ,
that, because they are
Sir,
competent authority has
that
taken.
notification is issued for, to benefit those persons who have not yet registered their claim.
It is wrong, it is my learned fund has
No,
read
that is
wrongly,
the
my lord.
interpretation of that
No,
itself.
my lord, I may
I will
permit
write it, sir.
My lord, notification, I may permit read, my lord.
ಎಷ್ಟು ಸರ್ತಿ ಓದ್ತೀರಾ ಅದನ್ನ?
ಇಲ್ಲ ಓದಿಲ್ಲ ಅದು.
ಓದಿ.
My lord, it is reported, the properties belong to the financial entity may have spread over in various districts and depositors are scattered throughout the state of Karnataka and possibly in other state also. In order to avoid duplication of efforts, necessity has arisen to authorize
ಅಷ್ಟೇ ಸಾಕು.
competent
In order
authority.
to avoid duplication of
Yes,
efforts.
ma'am.
ಸಾಕು.
ಇಲ್ಲ ಇನ್ನೊಂದು ಲೈನ್ ಇದೆ ಹೇಳ್ಬಿಡ್ತೆ.
ಎರಡು ಓದಿ, ಎರಡನೇ ಲೈನ್.
Authority, competent authority to call for claims from all the depositors, my lord,
Very good.
of the so and so society. My lord, when there is a made a notification by the competent authority to make their claims, they are at liberty to make claims before the competent authority.
ಈಗ
Now-
ಇಂಟರ್ಮೋಡರ್ ಇದೆಯಾ ಇದರಲ್ಲಿ?
Yes, ma'am, there is an interview.
ಇದನ್ನೇ ಹೇಳಿದ್ದೀರಾ? Yes.
Yes. Therefore, my lord, therefore, in excess of the powers conferred section 5 subclass 1 of the Karnataka Protection of Interest of Deposit Financial Act 2004, the government of Karnataka hereby appoint joint registrar of the cooperative society, cooperative election authority, TTMC building so and so as the competent authority. My respective submission before this honorable court, in view of the appointment of the competent authority by invoking section 5 of the KPID Act, the depositors, whether they approach or obtain order, whether without there being an order, they have to make an application because the assets of the depositors and all the things has been taken over by the competent authority. Competent authority will disburse the amount. Not that, my lord, the officers who are the ex-directors are liable or they are holding any assets of the respondent number 3 society, my lord. Therefore,
ಅಷ್ಟೇನಾ? ಇನ್ನು ಎಷ್ಟೊತ್ತು ಮಾಡ್ಬೇಕು ಅಂತಿದ್ದೀರಾ?
my lord,
ಹಾ,
the
ಹೇಳಿ.
facts is that, my lord.
ಅಷ್ಟೇ.
When the competent authority taken over the assets of the society, my lord, they have to approach the competent authority. They cannot go the directors, ex-directors, my lord.
Correct, sir. ಅಲ್ವಾ? Anything else?
To this court, my lord, my respective
ಅದು ಅವಾಗ್ಲೇ
submission,
leave it to this court ಹೇಳಿದ್ರೆ ಆಗ್ತಾ ಇತ್ತು.
I will make
ಇಷ್ಟೆಲ್ಲ ಮಾಡಿದ್ಮೇಲೆ I will leave it to you
I
now.
will make my synopsis also. is there,
ನೋ
my lord.
ಸಿನಾಪ್ಸಿಸ್ ಕೊಡಿ ಮೇಡಮ್ ಇಲ್ಲಿ.
ನಾನು submit
ಇರೋದು
ಮಾಡ್ತಾ ಇದ್ದೀನಿ.
4 ಡೇಟ್ಗೆ ಸಿನಾಪ್ಸಿಸ್ ಯಾಕೆ?
ಇಲ್ಲ, ಇದನ್ನ detail ಆಗಿ I made it out.
ತೊಂದರೆ ಇಲ್ಲ ಸರ್. The petitioner, the judgment debtors 5, 6, 7, 8, 9. Oh, 7, 8, 9 are at the doors of this court calling in question proceedings in execution 1405 of 2023, with particular reference to an order dated 17/8/2024. Heard so and so. Facts enumerated are as follows. The respondents, decree holders, who are, how many are there?
Three of them.
Three of them. huh?
Two, my lord. Respondent 1 and 2 are the decree orders.
Respondents, decree holders 1 and 2 had deposited or invested certain money. Yav Sauharda idu?
Respondent number 3 society, my lord.
In the respondent number 3 society, Shri Vaibhava Sauharda, Niyamita, so 3 alide madam. The deposits were not returned. Therefore, the decree holders institute proceedings in OS.
Not OS, my lord, dispute before the.
Dispute before the?
Joint registrar.
Institute a dispute before the joint registrar of cooperative societies.
Under section 39 of the Sauharda Act.
And institute proceedings before the competent authority under section 39 of the Sauharda Act. The respondents 1 and 2, sorry, the petitioners, they did not appear, is it?
It is an ex parte order.
The petitioners did not appear, and an ex parte award is passed in favor of the decree holders on 27/3/2022. This award is sought to be executed by filing an execution petition in execution 1405 of 2023. As observed herein above, the award is dated 27/3/2022. Long after the award, long after the passage of the award and institution of the execution proceedings, the government of Karnataka issues a notification on 15/9/2023. The notification reads as follows, page 49 to 52. The notification indicates that matters that are pending and claimants who have not registered any claim before any fora should approach the competent authority for registering their claims. The petitioner on the score, the petitioner's judgment debtors on the score of issuance of a notification move the concerned court, holding that the concerned court should transfer the issue before the competent authority and has no jurisdiction to continue the proceedings. The concerned court does not accede to the application filed by the petitioner, and the petitioner's judgment debtors are before this court in the subject petition. This court, on the submissions made by the learned counsel appearing for the petitioner, had granted an interim order of stay. The respondents have filed their application seeking vacation, the decree holders have filed an application seeking vacation of the interim order. The learned counsel appearing for the petitioner would take this court through the notification dated 15/9/2023 to contend that whatever proceedings, at whatever stage they are, or whatever proceedings, irrespective of the stage at which they are, before any fora, should go before the competent authority. Therefore, the concerned civil court cannot even continue the execution proceedings. On the strength of the said notification, the entire edifice of the submission of the petitioners are built. The learned counsel appearing for the respondent Aditya and Ms. Nisha Tiwari would submit that the decree holders had, long before the institution of the notification itself, had secured an award at the hands of the hands of the competent authority then. The competent authority is notified only on 15/9/2023. The notification does not have retrospective effect, neither is retroactive. Therefore, the learned counsel would submit that the petition, the execution proceedings cannot be stalled at the instance of the judgment debtors, and the proceedings must be permitted to be continued. I have given my sounds. The four narrated facts linked in the chain of events are all a matter of record. They would not require any reiteration. The solitary submission of the learned counsel for the judgment debtors, the petitioners, is based upon a notification which is quoted supra. The notification comes into existence on 15/9/2023. The notification is indicative of the fact that in order to avoid duplication of efforts, necessity has arisen to authorize the competent authority to call for claims from all the depositors of the third respondent Sauharda Society. Therefore, taking cue from this, the learned counsel for the petitioner seeks to contend that the execution proceedings also would have to be transferred before the competent authority. The submission is noted only to be rejected. On a plain reading of the notification dated 15/9/2023, which is issued in terms of the power conferred under the Act, it does not have retrospective effect and is neither retroactive for the petitioner to contend that the proceedings that had culminated in passage of an award on 27/3/2022 should be transferred to the competent authority in furtherance of a notification issued on 15/9/2023 is a submission that sans countenance. Therefore, the plea on which the petitioner has presented the subject petition being untenable, the petition deserves to be rejected and is accordingly rejected. Cost impossible.
Submissions, subsection 3 of the section 10 transfer not the notification.
I said the learned counsel for add Martin. Yes.
Both petitions. Yes. In the first petition, there were 2 depositors. In the second petition, there are 3.
Whatever. Issue is the same.
Same.
Next.
Deeply obliged.
Next.
11.
Appearing for the petition on this matter, my lords.
In terms of the memo.
2 and 3. Obliged, my lords.
Yes.
Serial number 12, my lords. Today itself, I will carry out the amendment and I will file the amended petition, lords.
I appear for respondent number 7 and 8, my lords. Since there's an interim order operating, the earliest possible date, my lords. Of course, at their behest itself, the amendment was sought to be made. It's been almost 2 months, my lords. Let them do it.
Today itself, I will.
We'll vacate the interim order.
It's a status quo order.
ಅದಕ್ಕೆ
44.
ಸ್ಟೇಟಸ್ ಕೋ ಆರ್ಡರ್ ಅಂದ್ರೆ ನೀವು ಅಮೆಂಡ್ಮೆಂಟ್ ಕ್ಯಾರಿ ಔಟ್ ಮಾಡಬಾರ್ದು
ಇವತ್ತೇ ಮಾಡ್ತೀನಿ ಅದಕ್ಕೆ
ಸ್ಟೇಟಸ್ ಕೋ ಇಸ್ ಫಾರ್ ದಿ ಪಾರ್ಟೀಸ್ ನಾಟ್ ದಿ ಕೌನ್ಸಿಲ್.
It's a large extent of land, 44 acres land.
Whatever.
Property.
What is the challenge?
ಆಯ್ತು ಸ್ಟೇಟಸ್ ಕೋ ಇದೆ ನೀವೇನು ಹೇಳೋಂಗೇ ಇಲ್ಲ. Yes. The learned counsel.
Note has been put up for purpose of.
The learned counsel for the petitioner submits that the needful would be done in the course of the day. List the matter on Friday. Yes. In the event needful is not done, the interim order would get automatically vacated.
There was a order not to the BDA to get the records.
You don't worry about that, sir. ಇವೆಲ್ಲ ತಂದ್ಬಿಡಿ ಮತ್ತೆ ಬ್ಯಾಗ್ ಗಟ್ಲೆ ಎತ್ಕೊಂಡ್ಬರ್ಬೇಡಿ. ಬ್ಯಾಗೇ ಇದೆಯಾ? Yes.
13.
ಅದೇ subject to the condition. Next.
13.
Memo for retirement filed by
The respondents have filed a memo for retirement.
R2, 3, 4.
For respondent number
Chandrasekhar N is already on record. Learned counsel T. Sheshagiri Rao has filed a memo for retirement on this score that Chandrasekhar N is already on record. In that light, memo accepted, permitted to retire as appearing for respondents 2, 3, and 4.
My lords, the matter may be disposed. It's covered by judgment matter, my lords.
GMCPC covered.
My lords, the issue is very simple, my lords. Where, my lords, the respondent number 1 to 4 filed a suit for declaration.
List on Friday in preliminary hearing.
Interim order may be kindly extended.
Idea. Yes. List after 4 weeks. Interim order subsisting will continue till the next date. You are the plaintiff.
I am the defendant in the suit, my lords.
14.
An application.
The order 3 rule 2 application, my lords, it has been rejected by the trial court.
List the matter on 30th July. Next.
It's a disposed matter, 14 matter.
14 ಏನು?
Disposed of matter, order was.
Why has it come now?
There was a modification, there was an application for modification of.
ಅವ್ರು ಬರೋದೇ ಇಲ್ವಲ್ಲ ಈ court ಗೆ? There is no representation by of the petitioners continuously. On the last date also there was no representation. And even today there is no representation. Dismissed. Yes. IA 1 of 2025 seeking modification stands dismissed for non-prosecution. Next.
No, my lord, the application is filed by me, respondent.
Nimda. Petition dispose ಆದ್ಮೇಲೆ ಏನ್ dismiss ಮಾಡೋದು ನಾನು?
What has happened is ARC company has already taken over the asset.
Correct. What is that modification you have filed?
There was a proposal for considering
So
one-time.
we should allow the
one-time-
application then.
Yes, one-time settlement, ಅವರು ಅಪ್ಲಿಕೇಶನ್ ಇದನ್ನ ಹಾಕ್ಬೇಕಾಗಿತ್ತು.
ಬರ್ಲಿ
Affidavit
ತಗೊಳ್ಳಿ,
file
ಸುಮ್ನೆ ಗಲಾಟೆ
ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಮಾಡ್ತಾರ ಅವ್ರಿಗೆ ಹೇಳಿ ಸೆವೆಂತ್ ಕೋರ್ಟ್
Pass over ಮಾಡ್ಬಿಡಿ.
Pass over. Yes.
15.
My lord, I appear for petitioner, my lord. The needful is done, my lord. We have filed the process for respondent number 3.
Enter ಮಾಡಿದ್ಯಾ?
Yes.
Enter.
ಅದಕ್ಕೆ ಸ್ಲೋ ಆಗಿ ಮಾಡ್ತಾ ಇದಾರೆಲ್ಲ. Yes.
No, my lord, this is the second time we have filed the process, my lord.
Learned counsel submits needful has been done.
Particular.
Who is R3?
No relief in particular has been sought against
File
R3.
a
It is
memo,
on
sir.
trying to
ಇದ್ರ
impress
ಮೇಲೆ
on it.
ಇಟ್ಕೊಂಡು ಎಂಟ್ರಿ ಮಾಡಿ ಕಂಟಿನ್ಯೂ ಮಾಡಿಸ್ಕೊಂತಾನೆ ಇದ್ದೀರಾ?
D1
No, my lord, this is the second time we are filing the process memo.
for
And the
production of document.
Have you claimed anything against them?
yes, my
Against
lord.
R3
This is
ಇಲ್ಲ
the-
ಸ್ವಾಮಿ, ಅವ್ರದ್ದು ಇಲ್ಲ.
They are the party in the trial court, my lord, and are entitled to the share in partition. Thus, they are made the party.
Partition.
Application is
In
for
trial court,
production of document, only against 1 and 2, not 3.
List the matter on 11th in preliminary hearing.
Gratefully allowed.
Yes. Enter order subsisting will continue till the next date of hearing.
Obliged, my lord.
16.
I served the copy to contesting respondents.
I'm for the contesting respondent.
Hmm.
Lord, my additional written statement has been allowed.
No, you have not yet, wait. You have just now come in.
I filed
The
for
learned counsel for the,
Lord, but they have filed their application matters gone to trial stage. my lords.
what application?
My lords, I filed an application and my additional written statement was taken on record. That order is challenged before your lordships. Now, without prejudice, they actually filed their application in the trial court and evidence, it was kept for evidence.
They can go on with evidence. I have not sought for stay of the proceedings. Only impugned order is stayed. But 1 to
No,
9.
impugned order is stayed.
Impugned order.
Learned counsel Aditya
Narayan.
Narayan undertakes to enter appearance for the
I
respondent.
filed yesterday.
Submits that his entered appearance for the respondent. 1 to 13.
No, only 3.
10 to 13.
10, I'm sorry. Respondents 10 to 13.
10 to 13.
Well, 1 to
Registered to
9,
print the name of so and so is appearing for respondent 10 to 13.
1 to 9 can be dispensed with.
1
They
to
are
9?
not necessary. 1 to 9.
Memo. Learned counsel.
I will file. I'll file.
Learned counsel files a memo seeking dispensation of the 1 to 9. 11th.
Please.
Interim order subsisting will continue to the next date of hearing.
17.
R1, 9, 11, 15 yaru.
Lord, it is perennially in the stage of orders because, my lord, after they've obtained the interim order from this honorable court, my lord, it's always in the stage of steps. I came on record for respondent number 10, my lord, because I
Yes,
was not
sir.
served.
What's
a
the
copy.
matter? Tell me.
I was not served it. I know, the copy
What's
is
the
come. I
matter?
was not served notice rather.
What's the order under challenge?
Now, my lord, the impugned order is at annexure A, my lord, where only emergent notice came to be issued.
If both of you are there, go before the
Please.
court and court will hear both of you and pass out.
Admittedly, my lord, I have a sale in my favor.
All right, ಅಲ್ಲಿ ಹೇಳಿ sir, ಇಲ್ಲಿ ಹೇಳೋದಲ್ಲ.
Now, my lord. no
39, 1 and 2 ಬರೀ notice issue ಮಾಡಿದ್ರ?
ಹೌದು, ಅಲ್ಲಿ-
ನಾವು ಇಬ್ರು ಇದೀರಾ, go there. I will direct the court to
there are-
consider in 2 weeks and pass out.
Now, my lord, there are about.
No, sir, I am not going to hear it here at all.
ಅಲ್ಲ,
It was
16
entertained only because notice was issued to preserve status quo. I had granted the order.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಆತರ ಇಲ್ಲ.
ಇಲ್ವಾ?
Kindly,
ಏನು?
interim order is there, my lord, where.
Interim order ಇದೆ, that also.
ಅಲ್ಲ, it is not hurting them, my lord, not to
It is
alienate to
100%
third parties
hurting me.
ಇರೋದು. They are the subsequent purchasers, my lord, kindly.
The application is yet to be disposed.
That is true, my lord.
Correct? Both of you go before the concerned court.
My lord, may I seek only this, till that application is
Not
disposed?
till the application. For 2 weeks, I will extend it. Let the court pass orders later.
Please.
Yes. The petitioner is before, petitioners, plaintiffs are before this court, calling in question an order of the concerned court which declined to grant temporary injunction as sought under order 39 rule 1 and 2 of the CPC. In order to preserve status quo with regard to the rights of the petitioners, plaintiffs, this court had granted an interim order of stay or interim injunction as was prayed for. The respondent was yet to be represented before the concerned court. The respondent is now the contesting respondent is now before this court. In the light of the representation of the contesting respondent, I deem it appropriate to direct the parties to appear before the concerned court and the concerned court to hear the application that is pending consideration before it filed under order 39 rule 1 and 2 within an outer limit of 3 weeks from today. In the light of the interim order subsisting in the case at hand, I deem it appropriate to extend it for a period of 3 weeks, leaving it open to the concerned court to pass necessary orders in accordance with law on the application that is now directed to be heard in the subject order, ordered accordingly.
I think from the date of receipt of the order would be because.
ಆಯ್ತು, receipt of the order. ಒಂದು ವಾರ ಬಿಟ್ಟು ರಿಲೀಸ್ ಮಾಡಿ.
ಅದಕ್ಕೆ because.
ಅಷ್ಟೇ ಎಲ್ಲದ್ರಲ್ಲೂ ಅದೇ ಮಾಡ್ತಿರೋದು. 39 1 and 2 only to protect you ಒಂದೆರಡು ವಾರ ಬಂದ ಮೇಲೆ ಅಲ್ಲೇ.
Only till the orders is passed ಅಂತ ತಾವ್ ಹೇಳಿದ್ರೆ, till there is an order that is
Let the
passed.
court pass the order. Now, this is what I am passing in every case.
3 weeks ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, if they don't pass the order, my lord, this interim order would be vacated.
No, first move ಈಗ immediate ತಗೊಳ್ಳಿ 3 weeks ಅಲ್ಲಿ order pass ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿರೋದು. That doesn't mean he will not take up the matter next. Release ಆದ ತಕ್ಷಣ ಮಾಡಿ.
All right,
please, oblige.
Next.
18.
Learned counsel submits needful is done, office to verify.
19.
ಯಾಕೆ ಕಟ್ಟಿರ್ಲಿಲ್ಲ ಮುಂಚೆ? ಸ್ಟೆಪ್ಸ್ ಯಾಕೆ ತಗೊಳ್ಳಿಲ್ಲ ಮುಂಚೆ? ನೋಟಿಸ್ ಯಾವಾಗತ್ತಾಗಿತ್ತು? ಇದಕ್ಕೆ ಪ್ರಾಕ್ಸಿನ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ಗೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡಲ್ಲ ಅಂತೇಳಿ. ಪ್ರಾಕ್ಸಿ ಕೌನ್ಸಿಲ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಎಕ್ಸ್ಟೆಂಡೇ ಮಾಡಲ್ಲ. Unless you tell me why you did not take steps after taking the interim order. Why? ಯಾರು ನಿಮ್ ಕೌನ್ಸಿಲ್? ಬರಕ್ ಹೇಳಿ. ಔಟ್ ಆಫ್ ಸ್ಟೇಷನ್. ಸರಿ, ಅಡ್ಜರ್ನ್ ಮಾಡೋಣ. ಎಸ್ ಕೊಡಿ. Learned counsel for the petitioner. ಆಗ್ಲೇ ಬರ್ದಾಗಿದೆ. If needful is not done, it will get vacated ಅಂತ. ಅದಕ್ಕೆ ಇವತ್ತು ತಗೊಂಡಿದ್ದೀರಾ ಪ್ರೋಸೆಸ್. ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ಇಂಜಿನಿಯರ್ ಎಲೆಕ್ಟ್ರಿಕಲ್ ಯಾವ ಡಿಪಾರ್ಟ್ಮೆಂಟ್? ಬೆಸ್ಕಾಂ. ನಿಮಗೆ ಯಾಕೆ ಇಂಟೆಲಿಜೆನ್ಸ್ ತೋರಿಸ್ಬೇಕು? ಎಸ್, ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ 11th finally. Learned counsel submits needful has been done, office to verify. Interim order subsisting will continue to the next date of hearing.
19.
On filing of acknowledgement and summons.
Filing affidavit and respondent number.
Why have you not filed the acknowledgement?
Lord, I have filed, I'm filing.
Why did you not file it as directed?
Filing.
We'll vacate the interim orders like this.
There is no interim order.
ಸುಮ್ಮನೆ ನಾವು ಆರ್ಡರ್ ಮಾಡೋದಷ್ಟೇ.
There is no interim order.
Learned counsel submits needful has been done.
No, my
office
lord,
to
respondents number 1, 2, 3 have refused. I'm filing an affidavit. Respondent number
Learned
4
counsel
has
for the
accepted.
petitioner submits respondents 1 to 3 have refused hand summons. The affidavit is taken on record. The registry is directed to print the names of respondent 1 to 3 and show them as served.
My lord, this is against, my lord, issuance of emergent notice.
List on Friday.
So, my lord,
List on Friday in preliminary hearing.
repeated, my lord. Interim.
Preliminary hearing on Friday. Yes, next.
20. For the petitioner, my lord, this is that acquisition matter. Your
Same
lordship.
order.
Please, your lordship.
ನಿನ್ನೆ ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದೆ ಐಜಕ್ಕೆ, ಅದು ಆಡ್ ಮಾಡಿದೆ ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್, ಅದನ್ನ ಹಾಕ್ಬೇಕಷ್ಟೇ. ನಿನ್ನೆ ಸೀರಿಯಲ್ ನಂಬರ್ ಏನಿತ್ತು ಮೇಡಮ್?
Your lordship, I have mentioned the writ petition numbers. in this.
ಕೊಡಿ. Dispose. Next.
Your lordship, notice to
ಇನ್ನೂ
rest
ಇದೆಯಾ?
of the respondents. Notice to respondent number 2 and 3 may kindly be dispensed with, your lordship.
ಅದ್ರಲ್ಲಿ ಮಾಡಿದ್ದೀನಿ ಅದೇ ತರ ಅಲ್ಲ.
Very well. Great.
Next.
21, my lords. Notice is not been issued. Copies were directed to be served before the respondent counsel.
We'll see.
Copies have been served, we have filed the
Let me
acknowledgement.
see. Let
Please, my lords.
21 ಕೊಡಿ. Copy serve ಮಾಡಿದ್ದೀರಾ?
We have served the copy of filed the
Counsel for
acknowledgement.
the petitioner submits that the order dated 16/6/2025 is complied with. The respondents are yet to be represented. List after 2 weeks, interim order subsisting will continue to the next date.
Please, my lords.
Next.
22.
The office objections may be overruled.
Office, the indication of furnishing PF stands deleted. Yes.
Your lordship, I have taken the steps, your lordship, in
When?
respect of hand, very next day, your lordship. But the hand summons, your lordship, is 70 years, the kolar, the.
Steps ತಗೊಂಡಿದ್ದೀರಾ?
Steps ತಗೊಂಡಿದ್ದೀನಿ.
Then don't take hand summons ಅಷ್ಟೇ.
Please.
ಕೋಲಾರ್ ಇಲ್ಲೇ ಇರೋದು.
ಅಲ್ಲ, that, but she's 70 years old, your lordship. So that's the reason I am not.
Counsel for the petitioner submits needful has been done. Counsel serve madilva.
ಇಲ್ಲ ಕೌನ್ಸಿಲ್ ಮಾಡಿಲ್ಲ.
ಮತ್ತೆ ಅದೇ ಇರೋದಿಲ್ಲ ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಹೇಳಿಲ್ಲ ನಾನು.
So
I have not said hand summons, sir.
on 15 days, your lordship.
15 days serve ಮಾಡಕ್ಕ.
1 week, sorry.
Finally, a week's time is granted to serve, to comply with the order dated 16/6/2025.
Please.
Next. Post immediately after service of notice upon respondents 1 to 5, interim order if any shall continue to the next date of hearing. Next.
24,
Same order.
25,
For the respondents,
ಯಾವ್ದ್ರಲ್ಲಿ?
25.
Awaiting service in respect of respondents, all respondents?
one I think still.
Statutory appeal is provided under 43 rule 1R, and there is suppression of facts and misrepresentation of
ಬೇರೆ
facts.
respondents ಯಾರು sir ಹೇಳಿ?
Literally, I'm suffering an order without they being, have
1 and 2
got a
ಯಾರು?
decree in my favor.
Wait.
All family members, all of them, your lordship.
You are judgment debtor? Then?
Your lordship, I was not.
Plaintiff?
Plaintiff in this matter.
Ah.
Now, their main objection is that I have an alternative remedy. I should have filed an MFA under order 41, under order 43. Now, what their, your lordship, this is an,
That appears to be correct.
your lordship, this is an order where it has not been rejected. My order 39 applications not rejected, issue notice to respondents have been, that is all. So therefore, there
We'll
is.
send it to the court. Both
We
of
had
you.
already entered appearance.
Then ಅಲ್ಲೇ ಮಾಡಿ.
ಅದನ್ನ suppress ಮಾಡಿ ಇಲ್ಲಿ ಬಂದು.
ಇಲ್ಲ, suppress
application
ಯಾವ್ದು
pending,
ಮಾಡಿಲ್ಲ.
application pending ಇದೆ ಅಲ್ವಾ?
ಇದೆ.
We'll continue the interim order for 3 weeks.
Till it.
Same order, not till 3 weeks ಮಾತ್ರ.
Then your lordship direction that it is by then decided. your
That is what I, previous matters have done that only.
lordship. Only service for some of them I'm not.
ಅಲ್ಲಿ represent ಆಗಿದಾರಾ?
Not everybody is
No.
represented. It's still awaiting even in trial.
On the day impugned order was passed, wakalats were filed.
By whom?
By
3, 4, 6 and 7.
3, 4?
6 and 7. And that was suppressed. And here they have.
Oh, don't worry about suppression now. I will send it there only, madam. Yes. The
Extension.
petitioner is before this court. Petitioners, the petitioner plaintiff is before this court calling in question an order dated 21/5/2025 passed in OS 126 of 2025, whereby the concerned court declines to grant an order on order 39 rule on application filed under order 39 rule 1 and 2 and only issues notice. This court on hearing the learned senior counsel had granted an interim order of stay. The respondents have now, respondent number?
3, 4, 6 and 7.
3, 4, 6 and 7 have now entered appearance and would submit that the application is pending consideration before the concerned court. In the light of the application pending consideration at the hands of the concerned court, I deem it appropriate to dispose the subject petition, continuing the interim order for a period of 3 weeks and directing the concerned court to hear the parties to the list and pass necessary orders within an outer limit of 3 weeks.
Without being influenced by this, because they.
Influence. Without, all right. It is needless to observe that merely because this court had granted an interim order and it is continued for the next 3 weeks, it would not mean that the concerned court should also pass an order of injunction. The order on an application under order 39 rule 1 and 2 shall be passed strictly in consonance with law.
Your lordship, that should suffice to state that merely because this was, lordship, the
Correct,
usual
correct.
words.
No,
your
no,
lordship.
that is there because now ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂದ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಕೊಟ್ಬಿಡ್ತಾರೆ ಆಮೇಲೆ.
If
ಅದಕ್ಕೆ
not-
in accordance with
Then
law.
it may
It
be
is
heard. I am
sufficient.
prepared.
Not being influenced is
Not being
sufficient, your
influenced,
lordship.
fine. Yes. With the aforesaid observations, the petition stands disposed.
Your lordship, in there also, service of notice is not complete. Now, on that basis, if they do not complete it within 3 weeks, then we are also.
Then court will pass necessary orders, yes.
The decree ಇರೋದು ಕೆಲವ್ರಿಗೆ ಮಾತ್ರ ಪ್ರಾಪರ್ಟೀಸ್ ಬಂದಿದೆ. They are the concerned.
Then
people.
suit
All others,
partition.
the people against whom decree is not
Lordship,
passed,
they have
they
filed
may
a-
not come.
They have filed a
They-
suit, 1996, the
ಅದಲ್ಲೇ
owner has.
I can submit that.
Your lordship, our only difficulty is the 3 weeks outer limit. Your lordship has said that they've passed. If the notices are not served by then, our difficulty, your lordship.
The court have said 3 weeks to pass this order or pass necessary orders in accordance with
Please.
law.
1/8 is the next date of hearing.
August 1st. So then,
Your lordship, instead of 3 weeks, within the next 2 hearings, your lordship, so that
No,
1/8
no,
and then you have 1 hearing after that.
If they have suppressed,
file-
it may be hard on merits
Advance-
also.
I'm
I
willing
can,
to argue right now.
I
advancement.
can demonstrate that they have.
Wait, Om Kumar, what is this? Advancement application hacking.
Your lordship, that could also be mentioned. 1/8, then again they
That
say
he
we are
will do
not.
it, don't worry.
He will not do it deliberately, because
No,
1/8 is the
why will I
next
not do?
hearing date. I am protected
I have
only
got the
for 3
decree
weeks.
now, and against the decree, even the earlier order of this.
The
honorable
parties
court-
are at liberty to move, the learned counsel, the senior counsel for the petitioner submits that the next date of here listing before the concerned court is 1/8/2025. Therefore, the parties to the list are at liberty to move the court to advance the date.
Great.
Only.
26.
I served the notice to the trial court advocate, my lord. R2 and 9 and 7, my lord.
Counsel for the the acknowledgement.
Acknowledgement I filed before the counter, my lord.
Hakidira?
Hakidra.
Counsel for the petitioner submits that the order dated so and so is complied with by service of notice upon the counsel representing the respondents. There is.
And remaining
the
respondents.
Respondents are yet to be represented. List on Monday.
My lord, some of the respondents are placed expert in the trial court, my lord.
Memo ಹಾಕಿ ಯಾರಿಗದು?
Trial court ಅಲ್ಲಿ expert.
ಅದು ಯಾರು ಅಂತ ಹಾಕ್ಬೇಕಲ್ಲ?
I'll file.
Yes. Urgency ಇದೆಯಾ?
My lord, the restoration of suit, my lord. Only ground is that instead of filing
List
the
on
petition under
Monday,
order
Monday.
9 rule.
Monday.
Credits.
My lords, in this matter, I undertake to file Wakala.
Learned counsel Archana Murthy, right?
Please.
Undertakes to enter appearance for the respondent, registry to print the name of so and so is appearing for the respondent. Enter ಮಾಡಿದ್ಯಾ? List on 23rd interim order subsisting would continue till the next date of hearing.
28.
Furnishing of PF R39.
Petitioners, Your Honor. For petitioner, my lord.
ಆಮೇಲೆ
Needful done.
Learned counsel submits needful has been done, office to verify.
Interim order.
Interim order subsisting will continue to the next date of hearing.
Check this one.
20 post immediately after service of notice upon the respondent, interim order will continue ಮಾಡಿ. Next, same order.
31.
31
Same lord.
for same order, yes.
I am seeking dispensation of notice to the
ಯಾರ್ಯಾರಿಗೆ?
respond number 1, 3 to 10, please.
Learned counsel files a memo seeking dispensation of issuance of notice to 1, 3 to 10. Memo is same taken on record.
Interim order.
Interim order subsist post immediately after service of notice upon 2, 11 to 15.
Please.
Interim order subsisting will continue to the next date of your next.
32.
Counsel submission. A week's time is granted to do the needful. Now counsel submission kodi.
Amended petition to be furnished.
Then week's time is granted to do the needful. Next. To comply with the office objections. 33.
3.
Office objection is complied.
Learned counsel submits office objections has been complied with office to verify. List the matter on Monday in preliminary hearing.
This may be on Tuesday, my lords.
ವಕಾಲತ್ ಹಾಕಿಲ್ವಾ?
My lords, that's a submission, filed a memo.
A week's time is granted to do the needful, to comply with the office objections. Next.
34.
Yes, sir, by me. Regarding this matter, in the year 2003, they have filed the bare injunction suit against the defendant. My lord. The defendant was died in the year 2005. The decree was passed on 3/1/2016.
On a dead person, ಅದೇನಾ ಇದು?
Yes, ma'am. The death certificate has placed.
ಏನ್
in-
counsel submission?
based on-
Accepting the,
ಇದರಲ್ಲಿ certificate copy
accepting
judgment
submission of the council office objection stands overruled. Emergent notice to the respondent, petitioner to serve on the council who represented the respondent in the execution proceedings. Counsel for the petitioner submits that a decree is secured by the respondent against a dead person who had already died in the year 2003,
2005, ma'am.
2005, and the decree is
Passed in 3/1/2006.
on 3/1/2006, which is sought to be executed by filing an execution petition
After lapse of 18
after
years.
lapse of 18 years. There shall be an interim order of stay of further proceedings in execution so and so till the next date of hearing. Yes, next.
Item preliminary hearing 35.
Lordship, proxy counsel appearing for the petitioner. Kindly grant a week's time.
Interim order ಇದೆ ಅದಕ್ಕೆ weeks time. Yes.
Yes, please.
When do you want, sir?
Maybe in the next week.
Maybe, yes. At the request of the council appearing for the petitioner list next week.
Interim order.
No, sir. Proxy counsel interim order action ಮಾಡಲ್ಲ.
Lordship,
Get
senior
the
is not-
counsel.
Sorry, petitioner counsel is not in the town. Lordship.
ಅದೇ get the counsel.
He is not. in
Colleagues
the-
ಯಾರು ಇಲ್ವಾ?
No, Lordship.
Tell the council that proxy counsel action ಮಾಡಲ್ಲ interim order. Interim order ತಗೊಂಡು ಮತ್ತೆ ಬರೋದೇ ಇಲ್ಲ ಕೋರ್ಟ್ಗೆ.
No, Lordship.
Yes. List day after tomorrow on Friday.
Interim order.
Interim order stands extended to the next date of hearing.
Not sure.
36.
I appeal for the petitioner's counsel. Lord, petitioners are the decree holders. Respondent is the judgment debtor. The execution petition has been filed based on the decree for declaration of ownership and possession. In the execution
ಆಯ್ತು
proceeding,
ಕೋರ್ಟ್ ಕಮಿಷನರ್ ಅಲ್ದ ಇನ್ಯಾರು ಮಾಡಕ್ಕಾಗತ್ತೆ? 26(9) application is allowed.
correct, Lord. But retrial and reinvestigation is not.
Reinvestigation ಇಲ್ಲ ಹೇಳಿದೆ. Where is come to the order?
Application kindly see at page number 58, annexures E. His prayer is to.
You are the
decide-
decree holder.
Lord, I am the decree holder.
Degree holder ಅಂತ ಹಾಕ್ಬಿಟ್ಟು.
Judgment debtor files an application.
It should be decree holder.
Lord,
Cost rate.
yes, brother. Petitioners are the decree holders.
ಅದು ಏನ್ ಪ್ರಿಂಟ್ ಮಾಡಿದಿರ ಅಲ್ಲಿ ನೋಡಿ.
Decree holder and execution.
Degree holder.
Yes.
ನಿಮ್ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಯಾರು ಕೇಳಿದ್ರು?
Instead of C, it is
ಮತ್ತೆ?
G.
Makes a world of difference.
Kindly.
Petitioner to serve on the council who represents the
Lord,
judgment debtor.
Lord,
In
in
1
spite
minute,
of
sir.
service, in
Judgment
spite of service, they have not appeared.
ಎಲ್ಲಿದೆ? ಸರ್ವ್ ಆಗಿದೆಯಾ? ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಹೌದು, entry order ಇದೆ.
2021 matter.
Old matter.
When were they served, madam ನೋಡಿ?
28/3/21.
Application is filed by them.
Filed by the judgment debtor, it is at annexure.
The
C.
petitioner. ಒಂದೇನಾ ಇಬ್ರ?
It is the.
The petitioners are decree holders. They are before this court in the subject petition, calling in question an order passed by the executing court on 6th March 2020 on an application filed by the respondent, the judgment debtor, seeking appointment of a court commissioner to redo the entire exercise which led to the passage of the decree. The respondent, the judgment counsel for the respondent judgment debtor is served on 28/3/2021 and 4 years have passed by, has not bothered to represent before this court. The learned counsel appearing for the petitioner submits that the plaintiff had instituted a suit in OS 4771 of 2008 seeking declaration that they are absolute owners of the suit schedule property and had directed and further direction to the defendant to hand over vacant possession. ಕೊಟ್ಟಿದಾರಾ?
What is that?
Hand over vacant possession of the property. Pursuant to the decree, seeking execution of the decree, the petition, the judgment decree holders file execution 2706 of 2018. Before the concerned court, an application is filed under Order 26 Rule 9 to secure a report from the, for appointment of the court commissioner to secure a report and secure a report with regard to the suit schedule property all over again, notwithstanding the same exercise being done at the time of this suit. The learned counsel for the petitioner submits that vacant possession is already handed over by the judgment debtor to the hands of the decree holder.
No,
In the,
that is not.
ಅಂದ್ರೆ
I am
ಈಗ
seeking delivery. I am seeking delivery warrant.
ಅಲ್ಲಿ ಮಾಡ್ಲಿ, ಎಸ್, so and so. ಅದು ಬರಿಬೇಡಿ. In the light of this, the concerned court has passed the following order. Reasons 68(2). A perusal at the reasons so rendered by the concerned court would undoubtedly mean that The concerned court in the execution proceedings has put the clock back to the proceedings in the original suit of the year 2008, that too on an application filed by the judgment debtor on under Order 26, Rule 9. In the learned, as contended by the learned counsel for the petitioner, the application should not have warranted consideration, as that exercise had already been done at the time of answering OS 4771 of 2008 in terms of the judgment and decree dated 20th September 2016, to which the respondent was indeed a party and heard. In that light, the petition deserves to succeed. The order dated so and so stands quashed. Stands quashed. The concerned court shall take the execution proceedings in accordance with law to its logical conclusion. Next.
My lord, appear for the petitioner. Here the point is that survey number 54/1, which I claim has not been acquired, no award has been passed, possession has not been taken. Mr. Giridhar, who appears for one person who claims to have been allotted by the BDA, says that I've been allotted on site 898. The BDA, in spite of being observed by the court, would have to file objections, does not file objections even today. They file the objection saying that where is it that
you are appearing for the BDA,
not for, not
No,
in-
my lords, I am for the auction
Mr. Uni
purchases.
Krishna, I think, appears for BDA.
4 dates, my lords, just 4 dates for the consideration of this court, my lords.
Huh.
The preliminary notification is in the year
Our
1970.
what is the matter?
No, the question is, my lord, I'm ready
The
to argue.
purchaser from
My lord,
the
my lord,
owner who
they
has
will go on
acquired.
repeating.
Everybody, one minute. Yes.
My only submission is, if your lordship records that the BDA has no objection, has not filing objections, my lord, I'll proceed. Because the BDA, what happens is, having done something wrong, now does not want to put anything in writing. Let them at least file, even have it tomorrow, please file, let them file an affidavit.
Heard the learned senior counsel.
May I just make one
ನಿಮಿಷ
submission?
ಸರ್, ನಾಳೆಗೆ ಆಗ್ತಾ ಇದೀನಿ ಅಷ್ಟೇ.
ನಾಳೆ ಬೇಡ, ನಾಳಿದ್ದು ಹಾಕು.
So and so.
ಹಂಗಿದ್ರೆ ಸೋಮವಾರ
But
ಹಾಕಿ.
I have one submission to make.
Weekend ಹೋಗಿ ಯಾಕೆ ಹಾಕ್ತೀವಿ?
May I
ಸೋಮವಾರ
request
ಹಾಕಿ.
this court to see just 2 facts, my lords.
No, facts, I will
Put it-
also.
No, please, sir, 1 second. You
I
made your
thought
request.
I
I'll
have
just
not
make a
yet
submission.
started hearing of the matter. If it starts, then he has to hear.
I just have 2
Vacating
dates
stay
to give,
ಹಾಕಿದ್ದೀರಾ?
my lords. May I just give 2
Vacating
dates?
stay
my
ಹಾಕಿದ್ದೀರಾ?
lords? There is an interim order. I have filed my statement of objections. My lords,
No,
land
no.
is notified in the year 1970. He is a purchaser from the landowner. He cannot maintain
When-
the writ
when?
petition.
My lord,
He
and-
purchases it in the year 1995. And
My
now
lord,
an
the land
interim
is
order
not
is
acquired,
granted.
award is not passed.
1 minute. 1 minute.
Interim order is granted at
1
the,
minute, sir.
I'm sorry,
Dates ಹೇಳಿ.
22nd September
Preliminary
1970.
notification.
PN, my lords.
22nd
22nd September 1970.
1970.
Yes, my lords. Final notification 15th of July 1971. He purchases in the year on 4th of October 1995
From the landowners.
from the landowners. Writ petition is filed in 2023. May I request this court to see the prayer in the writ petition? Just one prayer, my lords.
If he preempts me by arguing, because he will now say,
No,
I have
it's
asked
okay.
for negative
ಇಲ್ಲ,
declaration.
ಅದು ಇದು, these are the dates.
Dates, no, I'm not,
Dates are stubborn. Who says it?
No, no,
Does
dates
not
are-
matter. Yes.
now he says go to the prayer, then it's a negative declaration.
ನೀವೇ ಬನ್ನಿ prayer, ನೀವೇ ಬನ್ನಿ.
ಇಲ್ಲ, ಇಲ್ಲ, ಬೇಡ, ಅವರೇ ಹೇಳ್ಕೊಳ್ತಾರೆ.
The prayer, my lords, second prayer. Declare that the
E-auction,
respondents have no right whatsoever of the petition schedule property in so and so pursuant to final notification. This is virtually challenging the final
Well, no, I'm not,
notification.
the award is not passed, possession is not taken.
That you cannot contend.
My lord,
As simple as that.
I will make that
A
submission.
subsequent purchaser cannot challenge the,
No.
that's the settled law.
That is, my
It's
lords,
not
settled.
My lord, may
Not
make-
settled?
No, no, I will settle it tomorrow on Monday with the judgments. My lord. I've got some judgment, I'll
Lords,
submit. Because what the,
auction
because the whole
purchaser-
point is the BDA has now left out a portion and now he's now trying to take that portion which is in my possession.
2023 ಇಂದ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ ಇದು?
ಅದು ಯಾಕಂದ್ರೆ every time
They're
court
unable
ಮುಂದೆ
this
ಬರೋ-
reason.
court ಮುಂದೆ ಬರುವಾಗ court has been telling the BDA, file your objections, file an affidavit, say something.
No.
The BDA refuses to do anything.
My lords, the interim order is granted
now,
on the
sir.
premise.
Whatever BDA says, it's of no avail.
Very well. If that is so, then
Because these 4 dates, you are a subsequent purchaser, 1995 purchase, now file the petition in 2023. award ಕೊಟ್ಟಿಲ್ಲ, it's lapse ಆಗಿದೆ, ಅದೆಲ್ಲ
That is
landowner
not
ಹೇಳ್ಬೇಕು.
part of
You
the
can't say
acquisition.
that.
That part, not part of the
Sir,
acquisition
you
at
can't
all.
say that. Landowner should come before the court.
Well, I'll make my submissions on Monday. Please have it on Monday. I'll have to make my submissions.
Lords, our construction has come to a standstill.
2 ವರ್ಷದಿಂದ ಸುಮ್ಮನೆ ಇದ್ರೆ 3 ದಿನ ಇರಿ ಸರ್. ನನ್ ಮುಂದೆ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇರೋದ ಇದು?
ಮೊನ್ನೆನೂ ಹೇಳಿ ಇವತ್ತು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿದೆ.
ಮಾಡಿದೇವಲ್ಲ. I told you, buck stops here, we will do it.
Yes, buck will stop.
Monday,
Yes. Monday ಬೇಡ. Monday CPC 200, 300. Tuesday in preliminary hearing.
Swami, Tuesday 8th.
ಇಲ್ಲ ಅಂದ್ರೆ ನಾಳೆನೇ ಆಗ್ತೀನಿ.
Tuesday ಹಾಕೊಳ್ಳಿ.
Tuesday, yes.
I may be given some leeway, little pass over in the event I'm stuck somewhere.
Even if it is 6 o'clock, I will finish.
Very well.
Yes.
Great.
38.
Kindly pass over. 38. Why pass over?
Senior is on the way, my lord. He has engaged in another court.
Who is the owner of Toyota Innova?
Not RC is standing in my name right now. Not two applications had come to be filed. One for interim custody, which I had filed, and they had filed for an injunction to restrain me from taking the car, madam.
From driving the car?
From taking possession of the car. Initially, both applications.
ಈಗ ಯಾರ ಹತ್ರ ಇದೆ ಕಾರ್?
ಈಗ ಅವ್ರ ಹತ್ರ ಇದೆ.
ನೀವೇ ಡ್ರೈವ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
RC ನಮ್ಮ ಹೆಸರಿಗೆ.
Injunction order has been granted.
RC ಅವರ ಹೆಸರಲ್ಲಿ, ಕಾರ್ ನಿಮ್ಮ ಹೆಸರಲ್ಲಿ, ಎಲ್ಲೋ ಏನೋ ಆಗಿ ಆಮೇಲೆ ತೊಂದರೆ.
Therefore, the appellate court said, as directed them not to drive, other men they are before this court.
ಡ್ರೈವ್ ಮಾಡಲೇಬೇಡಿ.
ಹೌದು.
I will observe that if you drive and cause any harm to anybody, it will not, he will not be responsible.
Definitely, I will take an undertaking.
ಏನ್ ಅಂಡರ್ಟೇಕಿಂಗ್?
I will file my
undertaking. ನಿಮ್ ಕ್ಲೈಂಟ್ ಹೇಳಿ. How old is your client? How old, sir?
55. 50.
Huh?
55.
55.
He's the administrator, my lordship.
Administrator of?
Sri Kotilingeshwara temple.
Kotilingeshwara temple.
There is no record to demonstrate that the
car temple da.
Yes, my lord.
That is
My
their
contention, it is a
Temple car ಓಡಾಡ್ತಾ ಇದ್ದೀರಾ?
temple don't ಅವ್ರು ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ, it's a car of an individual, as per succession I have become the owner. They say that
Innova by succession.
ಅಲ್ಲ ಅವ್ರು ಹೇಳೋದೇನು ಅಂದ್ರೆ after his death it is vested with the deity, that is their pleading. Such pleading there is not supported by any document or any other material on record to support such.
Well, let the court consider. Again, interim order ಇದೆಯಾ?
Interim order.
ಏನ್ ಬೇಡ ಬೇಡ.
ಅಲ್ಲ, I am asking for interim. It cannot be kept idle. It's a depreciating.
Not idle, he is driving.
No, he is not driving. Trial court has, appellate court has directed him not to drive. If it is kept idle, my lord, tomorrow it suffers from depreciation, and already 6 years has elapsed since the
ಆಗೋಗಿದೆಯಾ?
It's a diesel car, my lord.
DT to the Innova, Innova to the DT. Yes.
That is the
yes, sir. Pass over. Why? He is coming in that car.
No.
Then wait. Yes. Pass over. General order, present toast.
For the responding.
ಮೊನ್ನೆನೂ ಬಂದಿರಲಿಲ್ಲ, ಇದ್ರ ಕೊಡಿ ಮೇಡಮ್. ಒಂದು ಪಾಸ್ವರ್ಡ್ ಮಾಡುವ.
ಪಾಸ್ವರ್ಡ್ ಬೇಡ.
There is no representation on behalf of the petitioner. Interim order ಇದೆಯಾ?
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇಲ್ಲ, ಬಟ್ ಒಂದು 20-25 ಸಲ ಆಗಿದೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್.
There is no representation on behalf of the petitioner. At his request, the matter was posted today in preliminary hearing. Therefore, the pendency of this petition will not come in the way of any proceedings before any fora. List the matter as a last chance on 11th. In the event he would not be present, the petition would be dismissed for its non-prosecution.
11th ಇಲ್ಲ.
18th, 18th, yes.
40.
Lordship, in this matter, I am appearing for petitioner, my lordship.
Correct address, second time.
Waste some time to take steps against R7 and 8, Your Honor.
R7 and 8.
9 and 10.
Fresh process, first process ಯಾವಾಗ ಕೊಟ್ರಿ ಸರ್?
After
got the interim order, immediately next day I will pay the processing, my lordship.
Oh, this, yes. Needful to be done in the next 2 weeks. Interim order subsisting will continue till the next date. Next.
41.
Respondents, implement order at annexed. That's an application under order 16 rule 6 was filed. The same was came to be dismissed without even objected by the other side. And even trial court has not heard me.
Then legal representatives. Yes, sir. We'll quash it and send it back.
My lord,
You had no
summary of-
objection. Court has objection.
My lord, prerequisites, as per the rule 80 of the civil rules of practice, three prerequisites has to be met with.
Why you did not object there?
On the day, my lord, in limine, it was rejected.
ಮತ್ತೆ here are avektan. Then what you said is correct. What he says is correct.
I agree with that, my lord. There is a rider on the part of the trial court.
Correct. That doesn't mean he should not
Matter
fear
has to
anybody
be
and pass
disposed of
orders.
within the scheduled time. The other side used to take adjournments after adjournment, and the application is also not attached with that endorsement.
That
So
was
that
the
only,
observation
that is also
made by
one of
the
the
court.
prerequisite.
Shall I make some
Yes,
two
sir.
submission matters? The suit schedule property, I take background of this history, my lords. Suit schedule property was claims to be the property of respondents here.
ಈಗ
But
ತಹಸೀಲ್ದಾರ್
actually I-
ತಹಸೀಲ್ದಾರ್ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಇದೆಯಾ?
That's what, for me, Tahsildar issued a proceedings that their LRF proceeding was not at all concluded. He produced the LRF proceedings certified copy that was contradicted to the witness.
We'll ask the court to rehear the matter and
Yes,
pass
yes, my
orders. The petitioner.
In addition to that, my lord, there are documents, it is already there on record to show that section
But
10
this is
application which
One
was
minute.
already
The
registered.
order does not indicate even a semblance of application.
I agree with that, my lord. But that is the discretion exercised by the court.
ಈ ತರ discretion exercise ಮಾಡಿದ್ರೆ ಅಷ್ಟೇ. Yes. The petitioner is before this petitioner, the fourth defendant is before this court in the subject petition, calling in question an order dated in date 12/2/2025, which rejects the application filed by the petitioner under order 16 rule 6, seeking a direction to the hands of the Tahsildar to produce the entire land tribunal record pertaining to LRF case number 7, so and so, page 84.
84.
So and so. The concerned court rejects the application on the score that the present defendant was not present on 29/1/2025. The orders passed on the said application are as follows, page 83 to 84. The learned counsel for the petitioner submits that he was not even heard in the matter. The case was kept by in the morning and recalled at 3:45 PM, and counsel for the defendant number 4 had submitted that he was not feeling well, and the same mention had been made in the forenoon session. Notwithstanding this, the order is passed rejecting the application. The order is quoted here and above. It does not inspire confidence even to its semblance, as there is no application of mind on the part of the petitioner. The learned counsel for the respondent submits that there's discretionary order to be passed by the concerned court. The discretion cannot be exercised in a cavalier manner, in the as exercised in the case at hand. In that light, on this short ground, that the order of the concerned court does not concerned court suffers from non-application of mind, I deem it appropriate to set aside the order passed by the concerned court dated 12/2/2025 and direct the concerned court to rehear the application filed under order 16 rule 6 and pass necessary orders in accordance with law, bearing in mind the observations made in the course of the order. For the aforesaid reasons, the following order allowed, quashed, the matter is remitted back to the hands of the concerned court to pass necessary orders, bearing in mind the observations made in the course of the order. Yes, next.
42.
Petitioner, my lord. The petitioner is a decree holder, my lord. I filed a money decree, my lord, and I filed an execution petition to execute the decree. The judgment debtors have challenged the decree before the appellate court, my lord, and the appellate court initially has granted a stay subject to 50% deposit. Since they are unable to deposit the amount, they seek an extension, my lord. And at annexure E, if I may draw the attention of the court to page 86, the appellate court, while extending the time, on page 86, my lord, the order dated 14/3.
No, 86 is an order of this court.
Please, ma'am, of the appellate
Oh,
court.
this
my lord.
commercial
The-
appeal. Oh,
commercial-
yes,
At the
yes.
appellate court, the order dated 14/3, my lord, the third paragraph, while extending the time, the court observed that consequently 2 weeks' time is granted to deposit 50% of the decretal amount. If 50% of the decretal amount is not deposited within 2 weeks, the appellant shall deposit 75% of the decretal amount within a period of 2 weeks. My lord, my decretal amount is for a sum of rupees 51 lakhs. They have deposited a sum of 25 lakhs, which is 50% of only the principal amount. It does not include the interest cost. My EP, my lord, is filed for about 77 lakhs. So I bring it to the notice of the
What is the
executing
decretal
court.
amount?
The decretal amount, it is the decree is forthcoming, my lord, on
Page?
page 69, 75, page 75. The last para,
51 lakhs 29,000.
51 lakhs 29,000.
50% of this ಎಷ್ಟಾಗುತ್ತೆ?
And my EP is for 77 lakhs, my lord.
26,000.
Oh, that is with interest at 12%.
Interest and cost. And the executing court, my lord, verifies all the records and gives a finding that indeed he has not deposited the entire amount. There is a finding that a decretal amount includes interest, cost, damages, and he has not deposited it, which, my lord, is forthcoming on page 30.
Amount, 50% of the principal amount, my lord. 50% of the principal
What is
amount.
the decretal amount?
Decretal amount,
Constitutes everything.
but here considering the fact, my lord, that the amount has been decreed.
ಈಗ ಮಿಕ್ಕಿದ್ದು ಯಾವಾಗ ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
4 weeks time will deposit.
They will deposit.
Let them deposit the amount till date.
Yes. Till date ಎಷ್ಟಿದೆ?
About 40
Interest
lakhs.
theory.
Interest theory about 40 lakhs. My EP was filed for 77 lakhs.
As on date of
ಒಂದೂವರೆ ವರ್ಷ
filing of the
10
appeal,
ಲಕ್ಷ
my lord, that's,
ಇವತ್ತು ಮಾಡಿಲ್ವಲ್ಲ, you're in default.
but it comes to that time, my lord. Stay order is there and also on
The
that.
time granted by the appellate court has
The
long elapsed.
petitioner, a petitioner is the decree holder. The respondent, the judgment debtor. The judgment debtor is before the division bench in a commercial appeal. The division bench on 14/3/2024 passes the following order, page 86. 50% of the decretal amount is what was directed to be deposited by the division bench. The petitioner, the respondent judgment debtor, deposits 50% of 51 lakhs, the principal amount, and does not take note of the entire decretal amount. The learned counsel for the respondent submits that if 4 weeks' time is granted, the 50% of the decretal amount would be deposited.
As per calculation, annexure G, my lord.
Annexure?
G.
ಯಾವ್ದು madam ಅದು?
Calculation is only is about a year and a half old.
Decretal amount. Annexure G ಇಲ್ಲ ಇವತ್ತವರೆಗೆ, you are in default.
But my lord, the amount stayed earlier.
Stayed by the division bench. I can't interpret the order of division bench. You should have moved it there. So and so. In the light of the said submission, the deposit shall be made as is directed by the division bench in terms of a memo of calculation that is appended as annexure F.
Annexure G.
G, my lord.
Annexure G, sorry, annexure G in the next 4 weeks. List the matter on 31st July.
In 43, I appear for the petitioner, my lord.
For the respondent number 1.
In this case, my lord, my application for deletion under 1 Rule 10(2) was rejected. I had challenged that, my lord, before this court. On the previous occasion, my lord, this court was pleased to grant an interim order staying for the proceedings, noticing that the entire claim of the plaintiff, my lord, who is respondent number 1 before this court, is against the other defendant and not me.
Yes. What are the steps to be taken? Dispensation.
ಅದು non-amendment of cost title, my lord, with respect.
ಅದಲ್ಲ, dispensation in ಎಲ್ಲ entire petition and dispensation ಕೇಳಿದ್ದೀರಾ?
ಅದು ಅಂದ್ರೆ ನಾನು ಎಲ್ಲ ಕಾಪೀಸ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಏನ್ ಹಾಕಿತ್ತು ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೆ, ಅದು ಟೈಪ್ ಕಾಪೀಸ್ ಗೋಸ್ಕರ ಕೇಳಿತ್ತು ನಾನು.
Are they not legible?
Most of them
No, they are not. The illegible copies that are indicated by the registry shall, the typed copies of the illegible copies that are indicated by the registry shall be complied with by the next date of hearing. So as cost title amendment ಏನಿದೆ?
The respondent number 2 was deleted, my lord, since he was placed ex parte before trial
And
court.
the amendment of cost title also be carried out. In the event the aforesaid would not be done, the interim order subsisting would get automatically vacated. List on 18th.
Would be extended until then.
Interim, subject to the aforesaid, interim order stands extended till the.
I'm grateful.
44.
Few of the respondents in the matter.
Petitioner in
Hmm.
this petitioner is the plaintiff in the trial court. He filed a suit for partition
Hmm.
and separate question in respect of this item number 1 to 5 properties which are left out at the time of the partition took place in the family on 7/2/2014.
Application ಎಲ್ಲಿ ಹಾಕಿದ್ರೆ?
The application is status quo order is passed by the sum court and the application is filed before the OS number, original suit.
31st January 20, that's rejected, is it?
That's rejected by the.
Rejected by the appellate court. The trial court.
Appellate court.
First appellate court, it was rejected.
The trial court had allowed it.
It was passed status quo order. There was, since there was an suit is for vacant land at the time of.
Oh, 39-192.
39-192, the second round of litigation, Malats.
My lord, see, this is the, this plaintiff is the minor co-defendant in the said suit. He was kept darkness about the suit.
ಈಗೇನ್ ಸೂಟ್ ಸ್ಟೇ ಆಗಿದೆಯಾ?
Suit stay ಇದೆ. Stay is operating against the defendant.
I have been permitted to put up construction, further construction.
It was permitted as per the, it was permitted by the Samb court and undertaking affidavit is also filed.
Still they are interfering, Malats, taking advantage of one ambiguity in the order.
Which order?
The previous order passed, Malats, by my lord's predecessor.
Page.
It's the order dated, no, Malats, this honorable court's order.
Item number 1 ಅಂತ ಇದೆ, he is seeking
Page,
item.
sir, page.
24/4/2025 was the order passed by this honorable court.
In this petition?
In this petition. If my lords may kindly turn to the second page. Item number 1 antide. I was putting up construction in item number 1 and 2. In between item
1 and 2.
1 and 2. It's the property is right in between items 1 and 2. And in fact, items 1 and 2, Malats, are a single property.
You want correction of this order?
I don't want correction.
Leave it. Yes. Interim order ಇದೆಯಲ್ಲ.
Please, Malats. My submission is let there be a direction to the trial court, Malats, because I have been dragged to court for the past 40 years. 1988 was the
Will direct the suit to be concluded. What is this date of the suit?
This suit, Malats, is 2021, second suit.
Second alla.
The earlier suit was filed in 1988 with respect to the very same properties, Malats. That is not in dispute. I don't think my learned friend would even dispute that.
Anyway, we'll direct the court to partition suit.
Partition.
jaldi agala.
Second
Item number 4 and 5 properties are totally different to the suit adjudicated in the previous.
The trial court, even on IN number 13, wherein status quo was granted, it says there is no case, tribal case made out at all with respect to 1 to 3 properties because it was already decided in the previous suit.
First appellate court has said something else.
No, Malats. First appellate court says when the trial court has said that there is no tribal case, how could it have granted status quo? Status quo is vacated. The order is passed in my favor by the
First appellate court vacates it.
Vacates it. And their IA for IA number 13 is dismissed. It's rejected.
Yes, sir. We'll direct the court to conclude the suit.
Please.
The petitioners, the petitioner,
Status quo may be.
the petitioner is the plaintiff. The petitioners are the plaintiffs.
Only plaintiff. Obre.
Sole plaintiff. Malats.
Why earlier suit ಅಲ್ಲಿ ಇರ್ಲಿಲ್ವಾ ನೀವು?
ಇಲ್ಲ, I am the co-defendant. It was the suit was.
That's a false submission.
ನಾನು ಇರ್ಲಿಲ್ಲ, minor defendant.
The petitioner is the plaintiff. He is before this court calling in question an order of the first appellate court which vacates the status quo order that had been granted by the trial court answering an application under order 39 rule 1 and 2. The learned counsel heard sounds. The suit in the subject OSIE OS 269 of 2021 is filed seeking partition of the property. The learned counsel for the petitioner submits that in an earlier suit which was for partition of the the petitioner plaintiff was not a party to the proceedings. The suit is pending before the concerned court. The issue that has driven as observed herein above by the but to driven the petitioner to this court is the vacation of the status quo order that is passed by the trial court at the hands of the first appellate court. This court has granted an interim order as was granted by the trial court. The issue now is the continuance of the interim order and the direction to the concerned court to conclude the proceedings within a time frame. The learned counsel for the respondent submits that earlier suit in OS
number 158/1988, please, Maharaj.
OS 151/1998 was instituted for seeking partition.
1988, please.
88 was seeking partition. The suit comes to be decreed on?
The suit was decreed on 10/8/1998.
The suit is decreed on 10/8/1998, but due to the right of the petitioner plaintiff not taken note of, then the plaintiff is said to have instituted another suit, i.e. the subject suit. In the light of the aforesaid circumstances and the parties litigating for the last 35 years, I deem it appropriate to direct the concerned court to conclude the proceedings with an outer limit of 6 months, if not earlier. The status quo or the interim order that is subsisting would continue subject to further orders passed by the court on applications so filed by the parties.
Yes. One submission. The suit is filed by these plaintiffs and the defendants are the linear descendants.
It is made clear that this court has not pronounced anything on the merit of the matter.
Against plaintiff and defendants, someone was filed.
Yes, next. Our argument hakidina.
Please.
Next.
55.
Pay for the petitioner, my lord. 4 to 6. Lordship may kindly recollect this came on the last occasion, my lord. We have served a copy on the other side also.
I have no objection for the rate to be allowed partially, my lords, insofar as insertion of para 4A. 6, my lords, is the objection, that's all.
What 6?
There are 2 portions in the amendment, my lords. One is to magnify the existing factual circumstances in para 4A. I don't think I will object much about that. Para 6A, my lords, it takes away an admission. That, my lords, cannot be. That is being objected.
Yes, sir.
Lord, 6A, I would like to, my lord, make 2 submissions, my lord. The lordship may kindly come to, my lord, the general power of attorney that I have produced, my lord, at annexure page 61, my lord. My lord, your lordship may kindly see the signature, my lord, of the petitioner. I'm not, my lord, by any stretch of imagination, my lord, putting your lordship into any hardship. That is not the court, this court's, my lord, but to naked eye examination, my lord.
Page.
Lordship, my lord, page 61, annexure E. My lord, the very same petitioner, my lord, in a collateral proceeding. My lord, says that I have not executed any general power of attorney of that nature.
Here is G. Ramesha. This is the same person?
Same person, my lord. Your lordship may kindly come to para 24, my lord.
Now, this suit is based upon the power of attorney?
They say, I have executed a power of attorney based on which I have sold all the properties. No, my lord.
4A, 6A.
For one moment. The pleading get 35 for a moment. He says that the power of attorney has been obtained. Our defense is also to the effect that, kindly see page 35 for only 2 lines there. Page 30. Para 6.
Page 35.
Page 35. Para 6. ಅದು ಯಾವ collateral proceedings ಒಂದು ಕಾಪಿ ಕೊಡ್ತೀನಿ.
ಅವ್ರ ಕಾಪಿ ಕೊಡಿ ಮತ್ತೆ.
ಕೊಡ್ತೀನಿ.
Collateral damage ಮಾಡ್ಬೇಕಾದ್ರೆ.
ಇಲ್ಲ ಮಾಡಲ್ಲ. And there I clearly say, my lord, I am not.
This suit was filed by them, it has been dismissed.
There is an RFA pending, my lord, admitted. RFA pending.
Lords,
yes. RFA pending and it's admitted.
Lords. Para 6 for 1.
So 4A ಇರಲಿ 6A.
ಹೇಳ್ಬೇಕಿತ್ತಲ್ವ ಸರ್, RFA ಹಾಕಿದಿರ ತಾವು. Suit dismiss ಆಗಿದೆ ಅಂತ ಹೇಳಿಲ್ಲ. Lords, 35 for 1 moment.
My lord, trial has not yet commenced. I just want to bring it to the notice.
He says that GPI has been obtained and they have sold away the sites. This is the crux of para 6. Now, my lords, he wants to turn back after 12 years, my lords, and make this statement saying that. My lords, I have based my defense also saying that it is true that he has executed.
Which is 4A, you know?
4A, my lords, is to magnify the contents of a compromise. Let him, my lords. I won't.
Yes, sir, we will permit 4A,
ಅಲ್ಲ 6A, there is a fraud played upon.
RFA.
Limitation.
ಅಲ್ಲ 6A ಅಲ್ಲಿ RFA ಬರಲ್ಲ. The reason, my lord, is that, the reason is that, my lord, they have not.
When was the application filed?
Application was filed, my lord,
Suit of the year 2013.
2013.
Written statement.
The application was
WS
filed
ಹಾಕಿದ್ ಯಾವಾಗ?
2013.
22/3.
Application filed on?
2024, my lord, 22/3/24. My lord, the reason is, my lord, I don't want to make any, my lord, allegation.
That's why you are hit by the proviso.
My lord, trial has not yet commenced, my lord, when there is a fraud played, my lord, my limited submission, I will make my submission.
No,
Only one.
Fraud played allegation has led to dismissal of the first suit.
My lord, there is no observation. My lord, I will say that. Now, what has happened, my lord, is that, my lord, if the general power of attorney, my lord, I would say this, my lord. If the general power of attorney comes back saying that it is not my signature, my suit goes, my lord. I will make that submission at the bar. Now, if it comes back saying that it is my signature, my lord, they succeed. My lord, it's a very limited point. Why are they hiding?
Now, no. Now, you had earlier said you had executed a power of
No, I have not said that. No, my lord,
Exactly
no, I
Where
will
is
come
that?
to that, my lord.
Where
What
is
has
that?
happened is, my lord.
Where is that?
That's para 6. It is para 6 of the plain, page 35 of the paper. It is respectfully submitted that an area of measuring 60 into 44 was given to the plaintiff.
Had
to
obtained unregistered GPA and
Yes,
plaintiff
please.
dependent on time of formation of the layout.
And based on the GPA, behind the knowledge of the plaintiff, different number 1 to 3 and different number 4, alleged to have sold some sites. So the execution of the GPA is not in question there. And
Now,
kindly see my.
6A, what do you want to incorporate?
6A, my
Now
lord,
they want to
I
go back
only
to
say
the-
this, my lord. I have not executed any GPA because, my lord,
Para 87 on page 87.
6A, I say, my lord, there was, my lord, no instructions from me to the earlier council. My lord, I don't want to make any allegations. my lord.
Council.
Well, ಅದಕ್ಕೆ ಬರೋದಿಲ್ಲ. Now, you may kindly come to page 87, my lord. Page 87, where the existing, my lord, proposed amendment at para 6A. When he made a routine to check the stones, so, my lord, to his knowledge, have entered into a JDA with defined number 8, which was preceded by a sale deed dated 1/7/2, executed by defined number 4, and defined number on a plain reading of the said sale deed dated, it is seen that defined as misrepresented that the plaintiff has executed an unregistered GPA in his favor, and based on the said purported
No,
GPA.
complete volte-face.
No, volte-face, my lord. What has happened, I am telling. I leave it to your lordship. At the end of the day, my lord, I bow down to what your lordship says. My lord, that general power of attorney, my lord, in the entire written statement, they do not say the date of the general power of attorney, my lord. That written statement I have produced before your lordship. They say, have you executed any registered general power, any general power of attorney? My lord, I have in the other proceeding, I have very clearly said I have not executed. My lord, to the naked eye examination, my lord, the signatures are absolutely different. Now, my lord, everything, my lord, the entire crux of the matter depends upon this. The only, my lord, the pendulum would swing, my lord. My respectful submission is the pendulum would swing.
It is already swung.
May not be, my lord. My
You are
respectful
making it
submission.
swing in your mind.
Ma'am, when there is a fraud played, my lord, that should
Fraud
not.
played is before the RFA. Now, that fraud you had alleged in a particular suit which has been dismissed.
No, that RFA has been admitted, my lord, that is pending.
So what? ಏನ್ ಮಾಡಕ್ಕೆ?
My lord, what has happened
Suit
is,
is dismissed.
my lord,
Same contention, suit is dismissed. Now you want to wriggle out of what you had
no,
said.
that contention was not taken up. The reason is this, my lord. What has happened? My lord, there was some.
No, he has filed a suit for partition. And my lords, based on the earlier compromise decree, he has also instituted a FTP.
FTP is pending, my
How
lord.
can, my lords, I don't think both of them can go on. Any which way, my lords.
But FTP, they have not contended that. My lord, my respectful submission is, my lord, my executing the general power of attorney does not remotely arise because there is no partition in meets and bounds. My lord, I could not have executed a GPA.
No, we will not go into that issue. I will not permit you to take away the rigor of para 6. That will change the nature of the suit itself.
My lord,
ಮಾಡಿ ತೊಂದ್ರೆ
I would be at the mercy of this honorable. My lord, one submission I would like to make.
And that is filed after 13 years of filing the WS.
My lord, trial has not yet come.
That's a different thing.
My lord, the only
issues frame ಆಗಿದೆ ಯಾವಾಗ?
issues frame agit 2015, my lord.
Anything
My
else?
lord, I don't know why they are hiding that general, let the general power of attorney be, my lord, produced before the honorable civil.
File it. Which GPA ಇಲ್ಲ?
ಈ GPA, they are not producing it before the court.
Which GPA, sir?
That this GPA that I have produced at annexure E,
ಅದು ಏನಾಗಿದೆ ಮಿಲಾಟ್ಸ್, now there is a apartment complex constructed.
ಅದೇ ಅದಕ್ಕೆ
That was
ಇದೆಲ್ಲ
tendered
ಬರೋದು.
to the developer. That has now been deposited with the association of the home buyers there.
Well, annexure E, my lord, if they produce, my lord, I have nothing more to say.
This is almost
I have
30
nothing more to
years
say. I have
what they are
that, my lord.
I also have nothing more to say. I will dictate now. Yes.
Annexure E, if there is an observation that if an application, my lord, is filed, let it be considered in
No, this
accordance
is your
with law.
admission, sir. I will not.
ಅಲ್ಲ,
permit.
ಇದು admission
Entire-
ಬರಲ್ಲ.
Your entire, the entire fulcrum revolves around para 6 and now you want to take away that and completely
when-
turn
my lord,
around.
When they are taking shelter under annexure E, my lord, let them produce the document before the trial court.
The court will kill.
There may an observation, my lord, to that effect. I am okay with that.
No observation.
Allah, then
There you can ask anything there.
Allah, the problem is again this.
I will only say he's wanting production of it. It is open for him to file necessary application.
Yes, please.
Ashte.
And so far as four is already. 4 is already.
The petitioner.
My lord, may I make another submission? Matter is coming on 4th, my lord.
So
ಅಲ್ಲ, plaintiff evidence ಅಂತ ಆಗಿದೆ finally ಅಂತ. I have to file an application to this.
For what?
ಅಲ್ಲ, this application to produce this document.
ಅದಕ್ಕೆ observation ಮಾಡಲ್ಲ. Yes. The petitioner is the plaintiff. Has instituted a suit for what?
Suit for
partition and certain consequential reliefs. The petitioner heard so and so mele ಮಾಡ್ಬಿಡಿ. In the proceedings, the petitioner files an application under Order 6 Rule 17 seeking amendment of the plaint. Prayer ಏನಿಲ್ವಾ, ಬರೀ plaint ಮಾತ್ರ.
So amendment
of the plaint that comes to be rejected owing to the proviso to Order 6 Rule 17, which mandates due diligence at the time of filing of the suit or immediately thereafter. The learned counsel for the petitioner submits that the application was preferred at the time when the trial was yet to commence, and therefore the concerned court ought to have permitted the application, ought to have allowed the application so filed as it would in no way change in the nature of the suit. The learned counsel appearing for the respondent, Sunil Rao, would submit that what the petitioner, the plaintiff is wanting to do now is completely do a volte-face with regard to the admission at paragraph 6. The said paragraph reads as follows, page 35. The amendment that is now sought by the petitioner in the application with for replacing para 6 with 6A is as follows, page 87. If the admission at paragraph 6 is juxtaposed with the replacement that is sought is that the petitioner plaintiff is doing a complete volte-face. Therefore, the said amendment would undoubtedly change the nature of the relief that is sought by the petitioner, as everything is now hinging upon a particular general power of attorney said to have been executed by the petitioner. Insofar as the other amendment with regard to replacement of paragraph 4 with 4A, the learned counsel for the respondent has no objection. In the light of the said consent, I deem it appropriate to allow the application filed under Order 6 Rule 17 only insofar as replacement of paragraph 4 with 4A. The submission of the learned counsel for the petitioner is that he is that the direction be issued to the respondent to place on record the general power of attorney that they are speaking of. The learned counsel Sunil Rao would submit that the very same issue was agitated by the petitioner in OS 7008 of 2022, which comes to be dismissed, against which the plaintiff has preferred an RFA before this court, which is pending consideration. Be those submissions of the plaintiff as they are. In the light of the aforesaid reasons, I deem it appropriate to pass the following order. The petition is allowed in part. The application, the order dated so and so, passed on order dated 28 March 2025 stands quashed only insofar as it does not permit amendment to paragraph 4 by replacing it with 4A. Insofar as the claim for replacement of paragraph 6A with 6 stands rejected. It is open to the petitioner to avail such remedy as available in law before the concerned court. Ordered,
2021.
21.
21 suit, yes.
Thank you.
Ordered according.
46.
Appearing for the petitioner in this case, Your Honor.
Go before the, who's you're representing? Nothing.
Your Honor, in this particular matter, there was an.
No representation, we have the petitioners.
Your Honor, there was a slight.
Slight?
Misunderstanding with the.
Miss with whom?
With the pendings, Your Honor. They had told us that it would be.
Misunderstanding with the pendings?
Pending
Yes.
branch, Your Honor.
All right.
Because they had told us it would be listed on 26th.
Oh, you go according to them, not the cause list, is it?
No, Your Honor. There was a slight mistake, error on our parts, that I'll admit.
Now, are the
affect
defendants
the-
represented there?
No, Your Honor. They haven't.
Suit for,
This is a suit for injunction, Your Honor, and
against whom?
against the respondents who were the owners of the property
They have
prior
sold
to
it to you.
1990. No,
They-
my predecessor in titles purchased the property from the respondents in the year 1990, Your Honor. And he has been the peaceful owner in possession without any
It's all right.
problem to
Petitioner
his.
shall serve on the
Your Honor,
respondents by way of hand summons.
Your Honor, in this particular matter.
1 minute, madam. By way of hand summons. The plaintiff petitioner said before this court on the ground that the concerned court has not granted any injunction, ex parte injunction as obtained, as sought for under Order 39, Rule 1 and 2. The counsel for the petitioner submits that the petitioners are in peaceful possession of the property for the last 35 years. Having
I have purchased the property in February this year, on 7th February 2025.
from whom?
From Gadiraju Kumar, who was the predecessor in title, G. Kumar, who has been in possession since the year 1990.
Where is the order of the court? Nothing is said?
No, Your Honor. The
No, no,
court.
no.
We have furnished the order of the certified copy of the order along with the memo.
So the vendor of the petitioner was in possession of the property since 35 years and the petitioner has purchased the same through a registered sale deed now in the month of February 2025. In that light, till the appearance of the respondents, status quo where the property be maintained by the parties.
Your Honor,
List on 18th.
Your Honor, if interim order could be passed.
ನಾನು ಏನು ಹೇಳಿದೆ ಸ್ಟೇಟಸ್ ಕೋ ಎಸ್ ಇಂಟರ್ಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟರೆ ಡೇಂಜರ್ ಆಗುತ್ತೆ ಎಸ್
47.
Now go before the court. Yes. The petitioner is before this court. The petitioner, the plaintiff is at the doors of this court calling in question an order dated 14/5, what's that? Order dated 16/5/2025 by which the concerned court does not grant a temporary injunction as was sought for in the application filed under Order 39, Rule 1 and 2, but issues notice. This court, to protect the interests of the petitioner, had granted an interim order of stay, interim injunction as was sought for. The respondents have now entered appearance and the application before the concerned court is still pending consideration. In the light of the interim order subsisting in the case at hand, I deem it appropriate to extend the same for a period of 3 weeks and direct the concerned court to hear the parties and pass necessary orders in accordance with law. Without being influenced by the interim order granted by this court, the application shall be answered in strict consonance with law.
My lord, one submission. See, this came into the vacation court, my lord. So, in OS number 8/2025, they came in front of the vacation court. I would just like to demonstrate the approach of the petitioners with
ಅಯ್ಯೋ ಪರವಾಗಿಲ್ಲ ಅಲ್ಲಿ ಮಾಡಿ
just 3 dates I want to mention, my lords.
To observe that now it's in the before the
Still,
regular.
it is
I want to mention 3 dates, my lords. The property,
ಈಗ ಅಲ್ಲಿ ಹೇಳಿ ಅದನ್ನ
my lords, ಈಗ ಅದ್ರದ್ದು 3 ವಾರದ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಕೊಟ್ಟರೆ we are assuming that lower court ಇವ್ರು ಮುಂದೆ ಬಂದು ಇನ್ನೂ ಹೇಳೇ ಇಲ್ಲ, my lords, ಅಲ್ಲಿ ಏನೋ
No problem.
Face the trial.
That's why I
We
said,
want a full-fledged trial in the lower courts. So let this not be prejudiced. The order in
I
our
already
prejudice
said
of
so. I've already said.
Let there not be a 3-week time frame for that, because
Then what's
anyways
that?
which we will be doing that.
No, before that, the court will pass orders. 3 weeks, I say.
Fine, my lords.
And merely because this court has granted or extended the interim order, it does not mean the concerned court is bound to grant an interim order. It shall answer the application on its merit after hearing the parties.
It's just one observation that it was filed before vacation judge. Now the suit number as well, the court has changed. If I'll provide that, I'll provide that.
Give that, yes. Next. Ordered according.
48.
Respondent 1, my lord.
Yes, sir. Jenidu.
This petition has been filed.
Domain name,
That transfer petition.
Transfer petition.
We had filed a transfer petition which came to be dismissed.
Transfer petition from where to where?
From one court hall to another court hall, my lords.
Why?
Because there is a specific direction from this court.
Page.
Not to grant any adjournment. So lordship may kindly.
Page.
Yes, my lords.
Page. Direction illida.
I think page number 75. My lords, at paragraph number 9.
Paragraph?
Paragraph number 9 of the order, my lords. 74.
If the parties are not cooperating, still court has to go ahead and pass appropriate above facts and appropriate dispose the writ directing court pending is not to grant unnecessary adjournments to either parties.
Yes, my lords. Now your lordship may kindly.
But necessary adjournments kodbodu.
Necessary adjournments for want of time I can understand, my lords. The court
For
is
ಏನು
unable to-
ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ?
You are now your lordship may kindly look at.
ಎಲ್ಲಿ where are the adjournments granted?
Yes, my lords. Lordship may kindly look at.
ಇವರೇ ಕೇಳಿದಾರಾ?
ಹೌದು.
Page 35, page 35. The last adjournment is 18/9. The very next day he files the transfer petition. ಇಷ್ಟರೊಳಗಡೆ INA ಡಿಸೈಡ್ ಆಗ್ಬಿಡ್ತಿತ್ತು.
Page 39.
Yeah, 35 minutes, 35 dates in the IA.
One moment, sir, one moment.
35.
This court directed ಯಾವತ್ತು? ಅಲ್ಲ, dispose ಆಗಿದ್ದ petition.
14th June 2024 was the direction by this honorable court.
14/6/24.
Much is observed against them. If your lordship should kindly have.
also been
the last portion.
Date ಹೇಳಿ sir.
14 June, my lord, is the order of this honorable court.
You are the plaintiff, huh?
I am the plaintiff.
I am the
Oh,
plaintiff.
you are the plaintiff, yes.
They filed, my lord, a 7/11 application
Oh, that's rejected.
long ago. My
No,
lord, it was
7
filed in
rule-
2017.
You know, 7 rule 14 application,
Oh.
7 rule 11, and also an application to modify the interim order, my lords. It is not
ಎರಡು ಒಟ್ಟಿಗೆ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ ಇಲ್ಲಿ?
because of the change circumstances, my lord, we filed, because my lord, subsequently what happened, my lords, the proceedings.
What
before
was the chain circumstance?
My lord, the register of companies, my lord, the matter was proceeding, my lords. By virtue of the orders in the portal website, my lords, certain interim order was granted, and also a charge sheet was quashed by this honorable court, my lords. Now the. ಹೌದು, ಇವ್ರ ಮೇಲೆ ಒಂದು ಚಾರ್ಜ್ ಶೀಟ್ ಪೆಂಡಿಂಗ್ ಇತ್ತು on the account of forgery and all those things, my lords. Now subsequently that was also set aside by the apex court, my lords, and it has been remanded back. The charge sheet has been survived. This is number 1.
ವಾಶ್ ಆಗಿರೋದು set aside
ಅಲ್ಲಿ
ಆಗಿದೆ.
set aside ಮಾಡಿದ್ರು. The apex court set aside the order passed by this honorable court, and the matter was remanded back, my lords. The charge sheet is survived now. This is number 1, my lords. Secondly, my lords, the register of companies set aside all their directorship appointments, saying that it is illegal, my lords. Because based upon all these.
ಅದೆಲ್ಲ ಆಯ್ತು, ಈಗ ಇದನ್ನ ಹೇಳಿ ಡೇಟ್ಸ್ ಅಷ್ಟೇ ಇರ 4 ಡೇಟ್.
4 ಡೇಟ್ ಅಲ್ಲ ಸ್ವಾಮಿ. On 5/7/2024, my lords, I conclude my arguments.
1 minute. Counsel plaintiff praise time ನೀವು to hear plaintiff praise time. ಎಷ್ಟು ಸರಿ praise time?
ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗ್ತಾ ಇತ್ತು. That's what, my lord.
ಆಗ್ತಾ ಇತ್ತು ಅಂದ್ರೆ praise time
ಇಲ್ಲ, ಮಾರನೇ ದಿನಕ್ಕೆ. If your lordships could kindly see, my lord, the last order.
See 29/7 praise time 6/8 12/8 28.
13th September heard the counsel for the plaintiff to hear further. Heard the plaintiff.
ಮುಂಚೆ ಎಲ್ಲ ಯಾಕೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಅಷ್ಟೊಂದು ತಗೊಂಡ್ರಿ?
That was, my lord, prior to the order. My lord, in fact.
What is the date of the order, sir?
14th June.
14/6.
ಹೌದು.
ಇದೆಲ್ಲ ಆಮೇಲೆ ಆಗಿರೋದು.
ಇದಾದ್ಮೇಲೆ
14/6 is the order. All these dates and events have happened after the order.
I shouldn't.
I will impose exemplary costs.
ಇಲ್ಲ, I shouldn't say that. But what happens? It's more about, my lord, the time in the court. It's my lord ಒಂದೊಂದ್ಸಲ but I don't know.
ಅದು ಬರ್ದಿಲ್ಲ ಇಲ್ಲಿ.
ಅದು ಬರ್ದಿಲ್ಲ but ಅದನ್ನ
ಪ್ಲೇಂಟಿವ್ ನಿಮ್ಮ ಮೇಲೆ ಹಾಕಿದಾರಲ್ಲ.
we generally my lord take blame because my lord we can't blame the honorable court for my lord paucity of time. Kindly my lord see the last order my lord, the matter was being argued. And the allegation is, and the allegation
is saying paucity of time. Sufficient time was given, my lords. They come at 5 o'clock deliberately to the court. They argue the matter, my lords. 5:15 should matter, 5:30 paucity of time agade.
ಈಗ ಇಷ್ಟಕ್ಕೆ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡಿರೋದಕ್ಕೆ ಒಂದು 2 ಲಕ್ಷ ಕಾಸ್ಟ್ ಹಾಕೋಣ.
ಅಲ್ಲ kindly my lord look at the
contrary to the order of the court. ಇಲ್ಲ I will send it to the same court.
ಅಲ್ಲ kindly look at the order of this honorable court. My lord 14 June order.
Yes.
What is observed? The last my lord, may I just take your lordships my lord to page number 110.
Yes. ಎಲ್ಲಿದೆ 110
page number 110 my lord, in the second petition.
ನೀವು ಐಪಾಡ್ ಇಟ್ಕೊಂಡು ಎಲ್ಲ ಮಾಡಬೇಡಿ. ಫಸ್ಟ್ ಪಿಟಿಷನ್ ಹೇಳಿ ಯಾವುದು ಅಂತ.
First petition ಅದರಲ್ಲಿ kindly my lord see what is the observation. Considering the manner in which the writ petition is pursued, this court is inclined to impose cost of around 50,000 to be paid by paid within a bit. Our ಮೇಲೆ 50,000 rupees cost ಹಾಕಿದ್ರು because they were the my lord was the ones who were dragging the matter.
ಈಗ ನೀವು ಮಾಡಿದಿರಲ್ಲ ನಿಮ್ಮ ಮೇಲೂ ಹಾಕೋಣ.
ಇಲ್ಲ ನಮ್ಮ ಮೇಲೆ ಅಲ್ಲ, in fact my lord after the matter was remanded we went every day. My lord I don't mind taking cost my lord if the error was actually
every day. Where have you gone every day?
Almost every day ಹೋಗಿದ್ದೀವಿ.
Almost ಏನಿಲ್ಲ.
But the entire idea
counsel
was
for the petitioner praise time.
The entire idea was this my lord, may I just be a little overt my lord. The honorable court expresses, the honorable court while hearing the matter expresses, ಏನಿದೆ ಇದರಲ್ಲಿ already the registrar of companies, the NCLT has passed an order that civil court only has jurisdiction ಅಂದಿದ್ದಕ್ಕೆ ಪ್ರಿಮಾನೇಷನ್
ಇಲ್ಲ ಅದಕ್ಕೆ ಏನು ಇಲ್ಲ ಅಂತ ಹೇಳಿರೋದಕ್ಕೆ ಒಂದಷ್ಟು ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿದ್ರು.
ಅಲ್ಲ ಅವ್ರ ಕೋರ್ಟ್ ಬಿಕಾಸ್ ಮೈ ಲಾರ್ಡ್ ಓವರ್ಟ್ಲಿ ಎಕ್ಸ್ಪ್ರೆಸ್ಡ್ ಏನಂತ, ಯಾಕೆ 711 ಇನ್ಸಿಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ, 711 ಬೇಡ ಬಿಕಾಸ್ NCLT has already held that the civil court has jurisdiction ಅಂದಿದ್ದಕ್ಕೆ they wanted my lord the change of
ಆಯ್ತು. ಈಗ ನೆಕ್ಸ್ಟ್ ಈಗ 89 ಆದ್ಮೇಲೆ ಏನಾಗಿದೆ,
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ದಾಗ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರು. ಪಿಟಿಷನ್ ಹಾಕಿ
89 ಒಂದು ವರ್ಷ ಆಗಕ್ಕೆ ಬಂತದ
ಅಲ್ಲ ಪಿಟಿಷನ್ ಹಾಕಿ ಏನ್ ಮಾಡಿದ್ರು ಅಂದ್ರೆ ಇವರೇ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡ್ರು.
ನಾವು ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡಿಲ್ಲ.
Petition haki, we have already filed a transfer petition, therefore adjourn the matter.
We did not even seek stay of the proceedings.
Kindly my lord see the order sheet. After filing the transfer petition, the judge wanted to go ahead.
Your lordship may kindly look at page number 26 of my petition, my lordship.
2017 7 rule application was filed. I'm sorry. After my lord filing the transfer petition, they would come and submit.
26 of para 17.
Wait, sir.
I'm sorry.
Yes.
The above noted factual aspects of the case indicate that in spite of a specific direction given by Honorable High Court of Karnataka in WP so and so consent application, is still pending disposal before the trial court. Further, the contents of the order sheet prima facie indicate that though consent court was ready to hear on the application and to dispose of the same, it could not do that because of non-cooperation of the side of the respondent number 1 herein.
ಆಯ್ತು ಆಮೇಲೆ
No, the conduct.
Transfer petition na?
Because there is a procedural unfairness which has happened.
ಈ ತರ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಕ್ ಹೋದ್ರೆ petitions then it will mushroom. ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಟ್ಟರು ಟ್ರಾನ್ಸ್ಫರ್ ತಗೊಳ್ಳಿ. ಈಗ 1 ವರ್ಷದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆಯಲ್ಲ ಇಲ್ಲಿ, ಏನ್ ಮಾಡಿದ್ರಿ ಅಲ್ಲಿ?
There is a specific direction.
1 minute ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ I was ready. The court said the miscellaneous petition ಇದೆ ನಾನು ತಗೊಳ್ಳಲ್ಲ ಅಂದ್ರು.
No.
ನಿಮಿಷ 1 minute sir. 13/9/2020 you filed this petition on 28 May 2025 ga.
19th. ಇಲ್ಲ.
Can I clarify my lord? Can I clarify my lord?
Yes sir.
Kindly see
29th May 25 ಹಾಕಿರೋ petitions.
13 I'll clarify my lord.
Yes,
13 September 2024 plaintiff argued. Then 18 September 2024 again plaintiff argued. The very next day, that is on 19th September 24, they filed the application. Kindly see my lord, page 36. Page 36 may kindly be seen. In the list of dates, heard the learned counsel so and so. Last 2 dates may kindly be seen. Heard counsel for plaintiff.
18/9/24.
Yes, the very next day they filed the application. Now 6 months are wasted.
This is 19/9/24.
Yes, the very next day they filed the 8 months are wasted.
So, ನಾನು ಅದನ್ನೇ ಕೇಳ್ತೀನಿ, ಇದಾದ್ಮೇಲೆ ಏನಾಗಿದೆ ಅಂತ.
ಮಿಸ್ಲೇನಿಯಸ್ ಹಾಕಿದೀವಿ, ನೀವು ಕೇಳಬೇಡಿ ಅಂತ.
ಇಲ್ಲ. We did not.
I will file an affidavit. I was personally present in the court. I will file an affidavit.
They came up with an impleading application. 2 impleading applications were filed before the court. The court said, okay, we will grant a time for objection.
By this time, the suit itself could have been
ಸರ್ ಒಂದ್
decided.
ನಿಮಿಷ ಟ್ರಾನ್ಸ್ಫರ್ ಪಿಟಿಷನ್ ಹಾಕಿ 1 ವರ್ಷ ಪೆಂಡಿಂಗ್ ಇದೆ, ಇಲ್ಲಿ ಏನಾಗ್ಲಿಲ್ಲ. ದಿಸ್ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಡೈರೆಕ್ಟೆಡ್ ಕನ್ಕ್ಲೂಷನ್, ಅಲ್ಲಿ 2 ದಿನ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಆಗಿದ್ದಕ್ಕೆ ಟ್ರಾನ್ಸ್ಫರ್ ಪಿಟಿಷನ್ ಹಾಕಿದ್ರಿ. ಇಫ್ ಯು ರಿಯಲಿ ಇಂಟರೆಸ್ಟೆಡ್ ಇನ್ ಕ್ಲೋಸರ್ ಆಫ್ ದ ಪ್ರೊಸೀಡಿಂಗ್ಸ್, you would not have waited for 1 year after filing this petition. This petition
Because
should have
if
been
it was
closed,
a mere-
should have been closed immediately. Ravi Shankar sir, will direct the court to pass to transfer petition. I am not entertaining.
Lords, I wanted to say this. Of course,
ಇದು ಅಲ್ಲ, ಈ ತರ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಟ್ರಾನ್ಸ್ಫರ್ ಪಿಟಿಷನ್ ಹಾಕ್ಬಿಟ್ರೆ ಯಾವ ಜಡ್ಜು ಇರಲ್ಲ ಅಲ್ಲಿ.
ಆಗಲ್ಲ. ಯೂಶುವಲ್ ಕೋರ್ಸ್ ನಲ್ಲಿ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ಕೊಟ್ರೆ ಸಮಸ್ಯೆ ಇಲ್ಲ. There is a mandamus. There is a direction to consider the dispose of the matter within a time bound frame. It is not for shortage of timings. The court adjourns the matter on the mere asking.
Shall I send it to the same court?
That's no difficulty. That's what I advise
Is it
them.
better? It's better, I guess.
That's no difficulty, my lords, because last thing which I would do, lords, is to make any comment against the judicial officer. That's the last thing. On that count, I am not the kind of person, my lords, who would come before lords. But what your lords may also have to take note of is the fact that if there is an earlier order directing the trial court to consider and dispose of this application within a time bound frame, isn't there an obligation on the judicial officer?
Correct. I am not on that at all. But
We did not have an interim order during the subsistence of the transfer petition.
1 minute.
Nothing
Sir.
prevented him from hearing the matter.
That is what I am asking. What has transpired after that?
Lords, the time is sought for and the time is granted.
Who seeks time?
Lords, the respondents have sought for the time.
Arre, who has filed this petition?
Lords, after filing this petition, my lords, my lords, the difficulty is this. The armchair with which your lords will have to assess.
Order sheet code is the latest order sheet as to who has taken time after that.
My lords, after filing
Otherwise,
this
if
petition,
both of you agree, I will direct the court to hear it in 2
within
hearings
15
and
days,
finish
my
it
lords.
off.
If your lords
Yes,
go to, it
that's
is
better
an earlier direction. Lords, we have, it is not that my apprehension is completely ill-founded. I will not say unfounded, it is not ill-founded. But when a direction is given and the learned judge fits the orders to this extent,
He has to
let
pass
us
an
assume,
order.
lords, that
3
there is-
dates, 3 dates he has given.
Yes.
Despite the order passed by this court.
Lords,
For those 3 dates, would you file a transfer
But
petition?
now this is something which I want. Lords, if the 3 dates expires the date which is fixed by the court to consider the application, Lords, then
So then
this
we'll do
is,
one thing. Then we'll direct the matter to be taken up before the same court, which had directed. So that
your
our,
lords may keep this writ petition pending, my lords. It's my request. My lords, we have a reason to say though, because in an earlier occasion, what happened was, there is a direction. The learned judge has not complied with the direction. My lords, I cannot come in contempt before the court saying that no, the learned judge has not complied with the
is
direction
why
for
I
disposal.
will post the matter before madam who had passed that order, and you place everything before the court.
May not be necessary, my lord. Now everything is over.
If all of you agree, I will direct the court to decide it in 15 days.
Yes, my lord, 15 days. In
That-
2
that-
hearings.
Otherwise, I will send it there.
15 days, if your lordship is directing, my lord, that's what I've advised them, that we are not going to press any of the contentions which you have raised in the petition. If your lordships were to direct that without fail, the matters to be disposed within 15 days.
That I will do.
Lordships.
Not a problem.
That's the end of it, my lords.
And
Nothing
I will
beyond
say,
it.
if it is not disposed, it will be viewed seriously upon the judicial officer.
Please, my lords.
What else you want?
Nothing more, my lords. ಅಲ್ಲ, ಅದು ಲಾಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಏನ್ ಬೇಡ. ನಮ್ಮ ಇನ್ಸ್ಟೆನ್ಸ್ ಆಯ್ತು ಅಂತ ಪಾಪ ಯಾಕೆ ಸುಮ್ನೆ. ಅಲ್ಲ, we understand ಅವ್ರಿಗೆಲ್ಲ.
No, he's a good judicial officer.
I understand, my lords. The first
Casting
statement, yes,
aspersions on him is not
should
correct.
not be necessary, please.
Yes.
ಏನಿಲ್ಲ, ಐ ಆಮ್ ಫೈನ್ ವಿತ್ ದಿಸ್. ರವಿಶಂಕರ್ ಏನ್ ಹೇಳಿದ್ರು ಅವರು
ಅವ್ರು ಏನ್ ಹೇಳಿದ್ರು you are fine ಅಲ್ವಾ?
ಹೇಳ್ತಾರೆ, ಅದಕ್ಕೆ
ಅಲ್ಲ, ಏನ್ ಹೇಳಿದ್ರು you are fine.
ಅಲ್ಲ, ಅವ್ರು ಊಟ ಮಾಡೋಗಿ ಅನ್ನೋದನ್ನು ಜೋರಾಗಿ ಹೇಳ್ತಾರೆ, ಊಟ ಮಾಡೋಗ್ರಿ ಅಂತ. So we are quite happy with whatever.
The matter is posted tomorrow, from tomorrow 15 days.
Yes, that I will do.
Please, my lords.
The petitioner.
Sorry, my lords, can I seek your lordship's excuse?
Yes, sir, ಅವ್ರು ಇದಾರೆ ಬಿಡಿ.
Great.
ಅವರು ನಿಮ್ಮಷ್ಟೇ ಗಲಾಟೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಇಲ್ಲ, ರವಿ ಹೋದ್ಮೇಲೆ ನಾನು ಗಲಾಟೆ ಮಾಡಲ್ಲ.
ನೀವಲ್ಲ ಸರ್, ಅವ್ರಿಗೆ ಹೇಳಿದೆ.
ಇನ್ಫ್ಯಾಕ್ಟ್ he was more than
ಯಾಕೆ
sufficient.
ನಿಮ್ಮ ಮೇಲೆ ತಗೊಂತೀರಾ?
ಅಲ್ಲಲ್ಲ, he was more than sufficient. He was more
ನಾವು
nuclear.
ಎಲ್ಲ ಗಲಾಟೆ ಆಗ್ತಿದೆ ಅಂದ್ರೆ ಅವ್ರು ಸಿನಾನಿಮ್ ಅಂತ ಅನ್ಕೋಬಿಟ್ಟಿದ್ದಾರೆ.
ಅದು problem
ನಾನು ಏನ್ ಮಾಡ್ಲಿ?
ಅಲ್ಲ. When he had a nuke with him, why my lord a cluster was necessary?
We'll see. Anyway, that is why he's moving away.
Yes, my lord. Nukes are required elsewhere also.
Yes, sir. Heard the learned senior counsel D.R. Ravishankar appearing for the petitioner. Learned senior counsel S. Basavaraj. ಯಾರ್ಯಾರಿಗೆ?
ಒಂದೇ ಫಸ್ಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅವರು ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ
S. Basavaraj and M.S. Shamsundar appearing, Senior Counsel M.S. Shamsundar appearing for the respondents. The issue lies in a narrow compass. It transpires that the coordinate bench, while disposing the petition concerning the parties, directed disposal of the application without granting unnecessary adjournments. Notwithstanding the same, it is the allegation, notwithstanding the same, on an allegation that the presiding officer has granted adjournments at the request of the plaintiffs, the defendants file an application before the concerned court seeking transfer of the petition to any other court, as it was in alleged violation of the order passed by the coordinate bench. The said application comes to be rejected. It is therefore the petitioners are before this court. The learned senior counsel appearing for the parties would submit that if a direction is issued to the concerned court to dispose the applications as was directed by the coordinate bench within 15 days from tomorrow being the date of next listing, it would suffice. In the light of the consensus arrived at between the learned senior counsels for the disposal of the petition within 15 days, as also noticing the breach of the order passed by the coordinate bench which had directed disposal of the petition, I deem it appropriate to direct the concerned court to dispose to comply with the orders.
Passed in my lord, writ petition number 14734 of 2022.
2023, within an outer limit of a fortnight from tomorrow. It is made clear that the order shall be adhered to it stricto sensu.
Grateful.
Yes. With the aforesaid observations, petition stands disposed.
49.
Okay, for the petitioners. We have served the copies of the.
Illa idaralla.
Only two applications that are pending. One is 711 and my lord, another one is.
Whatever the coordinate bench had directed. Yes, sir. Purchaser.
Purchasers, mandatory purchasers. Your lordship may kindly see the order passed by.
Now you want to implead in preliminary decree proceedings.
Yes,
come in final decree.
Yes,
come in final decree.
No, final decree only we are asking.
FDP.
PMLA. Other kindly come.
Lord, what's happened, Lord, this sales are not way back in year 1996. The suit, Lord, is 1989.
FDP idya.
FDP pending.
Purchaser yavaga?
1996, when the suit was pending.
Correct.
But
He is entitled to come on record in the FDP.
All these 33 years, Lord, they have not.
What? He is a purchaser after the institution of the suit.
Please, during the pendency of the suit.
If it was preliminary decree, he has stepped into the shoes of the vendor, so not necessary. Now in FDP, it is more of his right to come in. Yes.
What would happen, Lord, is
already nothing will happen. That's the law, sir.
That earlier the order passed by this honorable court in the earlier writ petition. It has been made very clear. Kindly go see page 345.
No, I thought it was preliminary decree.
No, final decree.
Final decree, yes.
Final decree, we have a right to, because pending.
Prior to orders, Lord, 2 times has come before the honorable court.
He is not an objector, but he is a necessary party there. 2197 application Allah tane.
Allah.
Yes,
you want to come on record. That application, in fact, has not been considered by the court below earlier also. We had filed a writ petition before this court earlier. And
this court is already observed.
Yes, in the earlier writ petition, this court has already observed.
It's not observed.
Kindly see page 345 minutes.
Kindly see the order.
We'll continue at 2:30.
Yes,
but Siddharth, if he is a purchaser, then final decree barde yavag barbeko.
Independent suit ಹಾಕೋಬೇಕಾಗುತ್ತೆ. ಇಲ್ಲಿ ಮಾಡೋದಕ್ಕೆ
ಇದೆ multiplicity problem ಆಗಿರೋದು.
Supreme Court has made it very clear that we are proper and necessary parties in final decree. In fact, I have passed on the judgment also.
That should be.
Lord, serial number 105, kindly seeking adjournment for 1 week.
Karat bidi madam. Matters.
Page wise adjournment.
Lord, 105.
Page wise karita. Yes.
Page 9, 49 to 51. Page 10, 52 to 59. Page 11, 60 to 64. Page 12, 65 to 68. Page 13, 69 to 74. Page 14, 75 to 79. Page 15, 80 to 84. Page 16, 85 to 89. Page 17, 90 to 96.
96, ಏನು?
If I have filed IA for LR application, Lordship, that objection will remove, Your Lordship. Kindly 2 days time.
Learned counsel seeks a week's time to do the needful. Yes, week's time is granted. Yes. Interim order subsisting. Yes.
Page 18, 97 to 102.
Madam, ಯಾವ್ದು ನೆನ್ನೆ 14% ಅಲ್ಲ ತಾನೇ ಅದು?
Page 19, 103 to 109.
105.
105 ಏನು?
My Lordship, respondents have filed the IA for vacating the interim order. So
Ah.
we file the necessary objections within 1 week, my Lord.
Learned counsel seeks a week's time to file objections to the application seeking vacation of the interim order. Objections, if any, be filed by the next date. List the matter on 16th under the caption hearing on interlocutory applications. Next.
Interim order has to be.
Interim order subsisting will continue to the next date of hearing. Next.
Page 20.
ಅಷ್ಟೇ, further hearing.
My Lord, serial number 1 pass over
One?
ಹೌದು, 1 pass over ಆಗಿದೆ.
ದೇವೇ.
Maybe
When?
taken up on Monday, my Lord.
ಮಂಡೇ ಮಾಡ್ತಾರ? ಮಂಡೇ ಸಾಯಂಕಾಲ 4:30 ತಗೊಂತೀನಿ.
Please.
Yes.
My lords, serial number 32, my lords. My sincere apology, my lords. I asked to call my senior, my lords.
Sincere apology.
4:30.
ಏನಾಗಿದೆ ಮೇಡಮ್? 1 week compliance with office objections.
Let's,
Comply ಮಾಡಿ ಬನ್ನಿ.
my lords, there is an reason, my lords. I filed an council
Reason?
submission, my lords.
ಸರಿ, ಅದಕ್ಕೆ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಅಂದ್ರೆ ಕೌನ್ಸಿಲ್ ಶುಡ್ ಬಿ ಹಿಯರ್ ಟು ಸಬ್ಮಿಟ್. ಮಧ್ಯಾಹ್ನ ಬನ್ನಿ. ವಕಾಲತ್ತೆ ಹಾಕಿಲ್ಲ?
ಹಾಕಿದ್ದೀನಿ.
ಯಾವಾಗ?
I filed with
That's the
petition,
objection,
Lord.
just check. Serial number? What do you want? Praise time. $84. Response interim order ಇದೆಯಾ? 17th IO extended, yes.
I'm appearing for the petitioner, my lord.
All right. Seal number 90. Yeah. All right.
The interim order may kindly be extended, my lord.
My lord, serial number
At the
85.
request. We'll adjourn it, don't worry.
My lord, serial number 85. I am the petitioner appearing as 14%.
Yes, sir.
In this petition, I have sought for the interim order of stay of further proceedings.
Correct. It will reach, don't worry. Yes. Huh. Then we'll release it.
My lord, one small submission with respect to item 10, my lord. In that, with respect to section 10(3), my lord, your lordship has said that you will consider later on, my lord. With respect to that, I have filed my written arguments in the registry today. Same may also be kindly considered while dictating the order, final order.
I already dictated.
My lord, your lordship has kept that portion of section 10(3).
Which portion? No portion I have kept. On the notification I have gone, I will only say it is pursuant to 10(3).
My lord, whatever, my lord, my
that's all.
submissions may be taken on.
Why it is gone against you, is it?
My lord,
Then-
not that, my lord.
Then?
My lord, later on, when the petitioner counsel lastly submitted after dictation of the order, that section 10(3) may also be considered. So your
All right.
lordship has said that he will consider that also.
No,
So
I'll
in
just
response
quote
to
that 10(3) and say that's all, nothing else.
My lord. So this may also be, my lord, considered. That's all. Madam.
Yes. What written arguments you have not filed?
My lord, I have filed it in the registry.
I will take it, don't worry.
Very good. Public.
90? Madam, cell number 99, 90. 90. At the request of the council appearing for the respondent. Respondent, less the matter after 2 weeks on date Kodi. Interim order subsisting will continue to the next date of hearing. Okay. Two 30. One. Admission books put on. Yes. Yes, Siddharth. Page. Switch on the mic.
That at page number 327. One previous round, my lord, it has come as the same matter traveled up to this honorable court, and then the para number 8, my lord, at page number 328.
Vardarajan.
Please, Mr. So-and-so learned counsel appear for the legal heirs of the sisters, owing Mr. So-and-so submission on the proceedings delayed because the petitioner's reliance on the last will and testament dated so-and-so. Submitted this honorable court, this court may consider the directing the civil court to draw final decree insofar as the claim of the other sisters in suit item numbers 9 property leaving open to the civil court decide on the claim between the petitioners and the first respondent insofar as their respective claims for the shares of so-and-so and parties have been in court from the year 1989, but without seeing the end of litigation in any fruitful manner. It must be recorded that neither Mr. So-and-so or so-and-so contesting the proposition that there cannot be multiple final decree, though there could be multiple preliminary decrees, while quite they on the possible delay on the final drawing up of the final decree because the inquiry on the petitioner's claim based on last will and testament dated so-and-so. Mr. So-and-so submits that the dispute is only amongst the petitioners and the first respondent, and the petitioners cannot in any manner impede delivery of 1/6 share in suit item number 9 property, the legal heirs of each of the 4 sisters. If there is a final conclusion
Conclude
on
the inquiry, decide on so and so 6 months.
Please, ma'am.
All right.
Thereafter, the order my lord, which says that disposing the, my lord, to file their respective reports and to hold inquiry on the petitioner's claim on the last will.
All right.
And also, my lord, to deliver that, my lord, these things.
But when did the application filed by him come
The
about?
application was filed much earlier.
When?
These applications are filed. In 2022, my lord. 6/6/2022. Apart from that, my lord, one more aspect is subsequent to this order which my learned friend read, there is a one more order passed by the same learned single judge.
Where?
Annexure, yes, your lordship may
Page?
kindly go. Page, my lord, 357. my lord.
357.
350, 340, 345. my lord. 10 of the. Para 10, your lordship got it.
Yes.
This court what happened was, after the earlier order was passed, a compromise was entered into among the persons who wanted an inquiry.
Correct.
That is between respondent number 1 and respondents 10 to 18, who were actually my predecessor, from whom I am claiming my title. Then, my lord, that compromise was accepted by the trial court, FDP court. That was questioned by the very respondents in this case, and I had also filed another writ petition. While considering that particular request relating to this compromise decree, Para 10 was passed. This court must also observe that the civil court, as it may not have due assistance from the learned counsels, must decide the merits of the application for impleadment filed by the concerned purchasers, and the decree to be drawn without constraints of completing the inquiry for drawing up of a final decree within a certain time frame. And that the civil court must also consider the 2nd to 25th respondent's contention that even if these purchasers are entitled to any interest in subject matter, they could claim their only such interest in those portions which are allotted to the petitioners and the first respondent. And if there is any shortfall in the respective portions in subject property, the same must be allotted in the other properties allotted to them. This is the order that was passed. But subsequently, what happened, even after this order was passed, my applications to implead ourselves as the parties in the final decree proceedings has been rejected by the impugned order. Holding that, I have got a separate. In fact, there is one more judgment of this honorable court, another learned single judge, following the judgment of the honorable Supreme Court in respect of the same file, may pass on the judgment.
FTPL ಬರ್ಬೋದು ಅಂತ ಅದೇ
FTPL ಬರ್ಬೋದು ಅಂತ.
ಕೊಡಿ.
ಸಾಕು. Relevant portion of the order, Miller. Para 13. If the final decree court is of the opinion that there are no other properties where the petitioner cannot be accommodated, then it is open for the petitioner to take such other measures as are available in law. However, if the final decree court is of the opinion that the properties that are sold by respondent number 4 could be appropriated against his share, the final decree court is bound to consider the claim of the petitioner.
No doubt about
this. That's what. So in this background, the order passed by the court below is patently erroneous. Contrary to
if the purchaser during the pendency of the suit is not permitted to come in the final decree proceedings, another suit ಹಾಕ್ಬೇಕು, another 20 years ನಡಿಬೇಕು.
Only submission, my lord, is they kindly send to my lord pay annexure P, that's a compromise petition. Insofar as item number 9 is concerned, my lord, all these
Inquiry is restored at page 345.
My only endeavor, my lord, is item number 9 is, my lord, the schedule out of which, my lord, the sites have been purchased. Nine properties.
Yes.
Insofar as 9, my lord, let them restrict, my lord, insofar as inquiry is concerned, 9.
My only submission is this, my lord.
No, 1 minute. You have a claim against whose share and what properties?
Respondents 10 to 18.
You have purchased from all of them?
No, I have purchased the property from the predecessor in title of respondents 10 to 18 by name Chandrasekharaya, and also his son's respondents 16 to 18.
How many properties?
Only one survey number 68. Sites have been found and sold to me.
You have purchased all the sites?
We have already purchased the sites. My only submission is this, no doubt. I can proceed against.
You can't expand your.
No. I cannot expand my right. My only submission is this, I may be permitted to make only one small submission. I am not expanding my rights at all. What I am submitting is only against the properties which are allotted to my vendors.
Correct. That's all.
Not only survey number 68. Other properties also are allotted to him.
No. Yes, your vendor may have got 100 properties.
No, not
1 minute.
Yes,
illustration, 100 properties.
Yes,
he has sold 2 to you.
Correct.
So you want to contest all the other 98?
Submitting is this.
Then
he had an undivided share in the property.
Correct.
Survey number 16.
Yes.
But he gets a particular share in the property.
Now, after, in the
Up to
FDP,
what
he
I'm
has got a
submitting is-
particular
no,
share.
That's,
No,
that is why I have-
purchase is when it was undivided share.
Correct.
Now in the FDP, it is divided.
That's
He
right.
has got a particular portion of the
I
property.
understand.
You have purchased that particular portion of the property or the undivided share then.
No, at that time. he
Are
had
you
an-
aware or not aware of
not
where?
aware- We were not aware that.
Then you were not aware, sir. Now are you aware, where do you stand?
No, we were under the impression at that time that the entire property belonged to my vendor. We were not even aware of this partition suit is our respectful submission. No, that's why, Milord, I read to your lordships, the judgment of, the order passed by this honorable court in the earlier proceedings, wherein, Milord, this honorable court has said, not only against the property, the other properties allotted to the share of the vendors.
That is para 10.
Para 10. Otherwise, I will note there, that is referred to there actually. Kindly see that.
Entitled to any interest in the subject property, they would claim interest in those portions which are allotted to petitioners and the first respondent. If there is any shortfall in the
Yes.
respective portion.
That's correct. That's what I'm asking.
No, he will restrict his claim only to the purchase of the property through his vendors and whatever vendors have been allotted.
Yes.
Practical difficulties will come.
Now
into
that
play. I'm
the
not really opposing the-
coordinate bench has already held those
No,
practical
I'm not
difficulties.
really opposing the question is this. There are ample number of decisions which say a subsequent purchaser can step into the shoes of his aliener and work out his remedy in equity. There is absolutely
In FDP.
no issue as far as the legal this thing is
Yes.
concerned. Now here is a case where that's his vendor is allotted about 8.5 guntas of land in the survey number.
All right.
ಅದನ್ನ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ದಾರೆ ಬ್ಲಾಕ್ ನಂಬರ್ 1 ಅಂತಾನೋ ಬ್ಲಾಕ್ ನಂಬರ್ 2 ಅಂತಾನೋ ಐಡೆಂಟಿಫೈ ಮಾಡಿದ್ದಾರೆ. ಇವರು ಲೆಟ್ಸ್ ಇಫ್ ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್ ಒಂದು ಸೈಟ್ಗೆ ಒಂದು ಶೆಡ್ಯೂಲ್ ಹಾಕಿ ಕೊಂಡ್ಕೊಂಡಿದ್ದಾರೆ. ವೇರ್ ಡಸ್ ಹಿ ಗೆಟ್ ದಟ್ ಇಫ್ ದೇರ್ ಇಸ್ ಅನ್ ಅಪ್ರೂವ್ಡ್ ಲೇಔಟ್ farmed in this particular?
No, this 8.5 guntas in its entirety is sold to him.
8.5 guntas. He has a claim against his vendor. I am not disputing.
Correct. Yes.
That's how the
No, the coordinate bench has already held that he is entitled to claim interest apart from the property that is purchased from the vendor.
that's right, which is allotted to Chandrasekhara.
Correct.
The other property.
Other property ಅವರೇನು ಕೇಳ್ತಾನೆ ಇಲ್ಲ. He is restricting it to vendor, and if that is left over in the property that
allotted to the share.
allotted to Chandrasekhar.
That's correct.
That's all.
That's all.
That's right.
ಚಂದ್ರಶೇಖರ್ ಬಿಟ್ಟು ಬೇರೆ ಯಾರ ಮೇಲೆ ಕ್ಲೈಮ್ ಇಲ್ಲ.
Respondents 10 to 18 ಬಿಟ್ಟು ಯಾರ ಮೇಲೇನು ಇಲ್ಲ.
ಅವ್ರ ಅಷ್ಟು ಕ್ಲೇಮ್ ಸರಿಯೇ, ಬಟ್ ಇವಾಗ ಕಮಿಷನರ್ ರಿಪೋರ್ಟ್ ಫೈಲ್ ಆಗಿದೆ.
ಹೌದು.
ಯಾರ್ಯಾರು ಏನೇನು ಅಲಾಟ್ ಆಗ್ಬೇಕು ಅಂತ ಇಯರ್ ಮಾರ್ಕ್ ಆಗಿದೆ.
ಕರೆಕ್ಟ್.
ನಮಗ್ ಬಂದಿರೋದ್ರಲ್ಲಿ ಅವ್ರಿಗೆ ಏನ್ ಕ್ಲೇಮ್ ಇಲ್ಲ.
ಇಲ್ಲ ಅಂತ ಅವರೇ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಒಪ್ಕೊಂಡಿದ್ದಾರೆ. ಅದನ್ನ ನಮ್ ಫೈನಲ್ ಡಿಗ್ರಿಗೆ ಇನ್ ಎಷ್ಟು ದಿನ ನಾವು ವೇಟ್ ಮಾಡ್ಬೇಕು?
ಓ ಹಾಗೆ ಅದನ್ನು ಬೇಕಾದ್ರೆ ಡೈರೆಕ್ಟ್ ಮಾಡೋಣ. ಬಟ್ ದಿಸ್ ಹಿಸ್ ರೈಟ್ ವಿಲ್ ಬಿ ರೆಸ್ಪಾಂಡೆಂಟ್ 10 to 18 ಕ್ಲೇಮ್ ಮಾತ್ರ.
Law entitles him to work out his remedy minutes. I am nobody to say no.
Yes.
Dismiss his, I am not.
Correct.
But the question is, how long should we wait?
No, that we will fix a time limit. That you don't worry. Yes. ಅಷ್ಟೇ ಅಲ್ವಾ? Yes, Siddharth.
So far as item number 9 is concerned, and their shares are 30-40 sites.
The whole difficulty is, ಅವಾಗಲೂ ಒಂದು ಕಾನೂನಲ್ಲಿ ಹೇಳಿದ್ರು, in respect of one property, there can be only one final decree ಅಂತ. Because that is staring at me. ಇಲ್ಲ ನಮ್ಮ ಶೇರಿಗೆ ಒಂದು ಫೈನಲ್ ಡಿಗ್ರಿ ಮಾಡಿಕೊಟ್ಬಿಡ್ಲಿ ಕೋರ್ಟ್ನವರು.
ಅಲ್ಲ ಮಲ್ಟಿಪಲ್ ಫೈನಲ್ ಡಿಗ್ರೀಸ್ ಆಗಲ್ವಲ್ಲ.
That's my difficulty. That's why it's staring at me. That's why I am fervently requesting.
Yes, we will.
ಕಾಯ್ಬೇಕು.
ಈಗ ಅದಾದ್ಮೇಲೆ we will direct the court to conclude it.
Yes, ma'am.
1989 ಇದು.
89 suit.
1989 suit.
We are ready. In fact, we are anxious to protect our rights from beginning.
Third generation litigants.
After the earlier order was passed, they entered into a compromise.
3 months.
The court passes a final decree.
3 months.
Outer limit of 3 months.
3 months.
If it is practically possible, yes.
It is possible. Only you have to, your share has to be determined qua Chandrasekhar, that's all.
Yes.
ಅದು ಎನ್ಕ್ವೈರಿ ಏನ್ ಬೇಕೋ ಮಾಡಿ ಒಂದು ಫೈನಲ್ ಡಿಗ್ರಿ.
ಅಲ್ಲ, there is already an order of inquiry. I will not tinker with that. I will only observe his rights.
The earlier inquiry was only in respect of what had happened was this. The earlier inquiry.
No, para 10 I will quote.
Para 10 you are not. What the earlier inquiry which this honorable court had held.
We say whatever is going to be allotted to his vendor's share. I am happy with it. ಅದನ್ನ ನೀನು ಫೈಟ್ ಮಾಡ್ತೀನಿ ಮುಂದಕ್ಕೆ ಅದನ್ನ ಯಾವುದು ಹೇಳದೇ ಇರಲಿ, ಅಲ್ಲಿಗೆ ಕ್ವೈಟಸ್ ಕೊಡಿ ಅಂತ ನಾನು ಕೇಳ್ತಾ ಇರೋದು.
ಅದೇ ನಾನು ಕೇಳ್ತಾ ಇರೋದು.
That in terms of the order of the coordinate bench, quietus will be given. I can't tinker with this because this has become final. ಅದು ಬೇರೆ ಬರೆಯಕ್ಕಾಗಲ್ಲ.
Court should also be interested in giving a quietus to this.
Definitely. ಅದಕ್ಕೆ 3 months will direct to conclude the final decree proceedings because it's suit of the year 1989. Yes.
ಅಲ್ಲ ಎನ್ಕ್ವೈರಿ ಅಷ್ಟು ಮಾಡೋದಾದ್ರೆ 3 months ಬೇಕಾಗಲ್ಲ ಅಂತ ನನ್ನ ಪ್ರಕಾರ.
Outer limit if not earlier.
ನನ್ನ ಪ್ರಕಾರ ಅಷ್ಟು ಬೇಕಾಗಲ್ಲ ಅಂತ.
ಅಲ್ಲ 3 months ಮಾಡ್ಬೇಕಾಗಿ ಬರ್ಬೋದೇನೋ, ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹಾಕ್ಬೇಕು, ನಮ್ಮನ್ನ ಪಾರ್ಟಿ ಮಾಡಬೇಕು.
2 months ಅಂತ
My applications have to be.
Really practical difficulties iದ್ರೆ.
I have no problem, your lordship may fix any time. But only thing is let them not be in a hurry, let them not deny my rights. That is the only request.
If there is any practical really difficulties, the court can extend.
I leave it to your lordship.
Yes. The petitioners proposed respondent 36, 37 and 38 in final decree proceedings 4 of 2021 are at the doors of this court.
Proposed respondents 36 onwards.
ಎಷ್ಟು?
36 to 43 million.
ಎಲ್ಲಿದೆ ಅದು?
ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಅಲ್ಲಿ ಅವರು
ಓ, ನೀವು ನೆಕ್ಸ್ಟ್ ಪೇಜ್ಗೆ ಹೋಗಿದ್ಯಾ? 36 to 43 are at the doors of this court calling in question an order dated 21/4/2025 passed in FDP 4 of 2021 by which the applications filed by these petitioners to implead themselves into the final decree proceedings is turned down. Heard so and so. The issue in the list has a history. On 15/5/1989, it transpires OS 134 of 1989 is preferred by one Muniratnam. The suit is then decreed on 31/5/2002. A regular appeal filed thereon also comes to be rejected on 18/11/2006, and in 2007 an RSA filed, in 2019 the RSA preferred against the order passed in the regular appeal and the original and the OS 134 of 1989. Pursuant to the dismissal of the regular second appeal at the hands of this court, the final decree proceedings are instituted in the year 2021. On 6/6/2022, after the institution of the final decree proceedings, the petitioners herein file applications to implead themselves in the said FDP in order to protect their rights. The rights of the petitioners that they wanted to protect was the sale that has taken place during the pendency of the original suit from the hands of one Chandrasekharaya, from the hands of one Chandrasekharaya to these petitioners.
And also his sons.
Chandrasekharaya and sons to these petitioners. They are respondents 10 to 18 in the FDP proceedings. Alla illa.
Ee proceedings.
10 to 18 in the subject proceedings. The application comes to be rejected by the concerned court by the impugned order. The learned counsel, Sri Madhusudan Rao, would submit that he can have no claim beyond what the claim of Chandrasekharaya and sons would be, who are respondents 10 to 18, from whose hands the petitioners have purchased the property in 8.5 guntas of land in survey number?
In survey number 68.
Sorry, in 8.5 guntas of land, which has now fallen to the share of Chandrasekharaya or his sons. The learned counsel would further contend that they would not stake any claim with regard to the other properties allotted to others, as the right of the petitioners would flow only from the right that is accrued in favor of Chandrasekharaya and sons, respondents 10 to 18. The learned counsel Siddharth Varadarajan and Siddharth, representing the respondents, would accept the position of law that the petitioners who are purchasers during the pendency of the suit have a right to get themselves impleaded in the final decree proceedings once the undivided share would become a divided share appropriately in the final decree proceedings. The learned counsel would further contend that suit is of the year 1989, therefore the suit should see a finality. The the learned counsel would accept the submission of the petitioners of the learned counsel to Madhusudan Rao that they would not claim any other property beyond Chandrasekhara and his sons respondents 10 to 18. In that light, I deem it appropriate to allow the application filed by these petitioners before the concerned court in FDP 4 of 2021 and permit them to claim their right in the light of the observations made in the course of the order. The learned counsel, as submitted by the learned counsel for the respondents, the suit is of the year 1989, and the 1989, 36 years have passed by. Therefore, I deem it appropriate to infuse finality into these proceedings, into the impugned into the subject FDP 4 of 2021, 4 of 2021. Yet another factor needs to be noticed is the order passed by the coordinate bench, which had directed inquiry to be conducted in writ petition 8756 of 2022. The coordinate bench has held as follows. They said, page 345, 346. The said order has become final. In that light, the inquiry by the concerned court must ensue, and the order of the petitioners impleading into those proceedings also must ensue. In that light, I deem it appropriate to dispose the petition by the following order. The order dated, order impugned so-and-so stands quashed. The application filed by the petitioners seeking impleadment into the FDP proceedings 4 of 2021 stands allowed. The concerned court shall conclude the inquiry as is directed by the coordinate bench in the order quoted supra and pass necessary orders in accordance with law. In all and in the light of the suit being of 36 years vintage, the concerned court shall conclude the final decree proceedings with an outer limit of 8 weeks, if not earlier.
Only request is that the final decree court shall confine its inquiry as far as this claim is concerned to the extent of land in the commissioner's report allotted to his
ಮೇಲೆಲ್ಲ ಅದನ್ನೇ ಹೇಳಿದ್ದೀನಿ ಅವ್ರಿಗೆ 10 to 18 ಬಿಟ್ಟು ಬೇರೆ ಏನು ಕೇಳೋದೇ ಇಲ್ಲ. ಏನಾದ್ರು ಇದೆಯಾ?
ಅಷ್ಟೇ ಸರ್.
ಎಸ್.
finishing the inquiry, they should draft the final decree in respect of all the shares.
ಅಲ್ಲ ಇದು ಮಾಡಿ conclude the final decree proceedings outer limit of 8 weeks and take and generate all consequential actions in accordance with law.
One rule 10 application is dismissed, Lord.
ಯಾವುದು ಸರ್? Serial number
50, please.
ನೋಟಿಸ್ ತಗೊಳ್ಳಿ.
Lord,
ನೀವು ಯಾರು ಅಂತ ಗೊತ್ತಾಗಬೇಕು. ಒಂದು ನಿಮಿಷ ಸ್ಟೇ ಅಂತ ಕೊಡಲ್ಲ ಇದು.
Lord, my submission is, Lord, now the matter is posted for ADR, Lord. Let the trial court not to precipitate a matter, Lord. Once the compromise.
You serve on the council, I will take it next
Lord,
week.
5th is the date. ಅಲ್ಲಿ
ಯಾವತ್ತು ಡೇಟ್?
my instruction is 5th, Lord. ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅಂತಂದ್ರೆ ನೀವು ಸ್ಟೇ ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ ನಾನು ಕಾಂಪ್ರಮೈಸ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡ್ತೀನಿ. That was the Lord, the trial court has expressed. ಒಂದು ವಾರ ತಗೊಂಡಿದ್ವಿ, we could not move it.
No, sir. Your impleading application is rejected, sir.
Lord, my submission is, Lord, the property.
ಒಂದು ನಿಮಿಷ. ನೀವು ಯಾರು ಸರ್?
Lord, we are the owners of the item number 9 of the suit property, Lord.
Suit is for partition.
Suit is for partition and separate possession, Lord. Their claim is not their grandfather, plaintiff's grandfather has purchased 2 acre and 2.5 acre, Lord.
Correct.
So that property is already sold by virtue of annexure F1 and
whom,
F2.
sir?
Lord, one
Sold
is,
to whom, sir?
Lord, one property
Sold
is
to whom?
gifted to me. Lord, another property is sold to third person. They have retained only 9.5 gunta, Lord, whereas the suit property that is described 1 acre 28 gunta, when the property itself is not available.
Which is the one that is gifted to you?
Lord, that is annexure F1, Lord, in the 1970, please, Lord.
Is that also a subject matter of the compromise now?
Lord,
is that a subject matter of compromise now?
Yes, my Lord. Suit item number 9, Lord.
Suit schedule property go.
Lord, item number 9, that is page number, Lord, 9, Lord, 198/2.
Page number 9.
Lord, sorry, page number 38, item number 9, that is 1 acre 28 guntas, please, Lord.
Of survey number 198/2.
198/2.
Take me to the gift deed.
Lord, the gift deed, my lord, that is at annexure. Annexure F1, please, my lord.
Page.
Lord, page number 56, please, my lord.
50?
56.
Schedule ಇದೆ gift deed ಅಲ್ಲಿ.
I'm sorry.
Where is the schedule?
Lord, the schedule is, my lord, ಪೂರ್ವಕ್ಕೆ ಮಂಟನ ಕುರ್ಚಿ ಮೈಲಾರಯ್ಯ ಜಮೀನು, ಪಶ್ಚಿಮಕ್ಕೆ ಇದೇ ಊರಿನ ತಿಮ್ಮಯ್ಯನವರ ಜಮೀನು, ಉತ್ತರಕ್ಕೆ ತಿಮ್ಮಯ್ಯನ ಜಮೀನು, ದಕ್ಷಿಣಕ್ಕೆ ನನ್ನ ಸ್ವಂತ ಜಮೀನು, ಪ್ಲೀಸ್.
ತಿಮ್ಮಯ್ಯ ತಮ್ಮಯ್ಯ ಎಲ್ಲಿದ್ದಾರೆ? ಐಟಮ್ ನಂಬರ್ 9 ಅಲ್ಲಿ ಸ್ವಲ್ಪ ನೋಡಿ, 38 ಅಲ್ಲಿ.
Lord, my submission is, Lord.
Anything else?
Lord, only one submission, Lord. In so far as, Lord, their claim is, Lord, they have purchased.
Petitioner to serve set of papers upon the counsel representing the plaintiff. ಬೇರೆಯವ್ರಿಗೂ ಬೇಕಾ? Plaintiff and the remaining defendants before the concerned court and file an acknowledgement by Monday. List the matter next Friday.
Please.
Yes.
C1.
I appear for the respondent. I filed another petition challenging another order.
Unnecessary. Your objections are
Please.
very neatly done. Anything else, Prithvi? ಶುರುನೇ ಮಾಡಿಲ್ಲ ಮಾಡಿ. Yes.
It's, the lordships kindly turn to the award, cost title in the award and the petition. Now your lordships kindly turn to the order sheet which I have produced. On 29/10/2024, the petitioners herein files 3 applications.
Yes, sir.
On the very same day, those 3 applications are disposed of. The lordships kindly turn to the observation made by the executing court at page 69.
How many proceedings you lose and how many things you want to do? Ultimately, implement ಆಗ್ಲೇಬೇಕಲ್ಲ.
ಅಲ್ಲ, implement ಆಗ್ಬೇಕು, but not in this manner, your lordships. What I am trying to submit is that, your lordship.
And whatever you have done is in appropriate.
No, I'm not saying that, your lordships. Here, the award has been challenged by petition number 2 and that is pending for consideration. And on that premise, I have filed this application for seeking for stay of that execution proceedings. All these 3 applications were disposed of, giving a finding in my favor and without hearing those applications, a finding is.
Giving a finding in your favor.
Yes, your lordship.
Without hearing you.
On the very same day, your lordship kindly turn to page 69.
Why are you aggrieved by it?
No, not by this, your lordship. I am not aggrieved by this order.
Then what?
Now, the very same court, your lordship kindly turn to page 69. It starts from page 68, last paragraph, your lordship. Heard IA number 2 to 4. IA number 2 is to implicate the objector in present TP. Said IA is superfluous since the objector Subramania Kodanur is already JDR number 2 in present TP and accordingly IA number 2 is disposed of. IA number 3 is to stay proceedings in present EP till the claim of objector is adjudicated. The claim of objector is raised in IA number 4 on the premise that the properties of objector cannot be attached in execution of the award since he is only former MD of JDR number 1 company. In this regard, perusal of records discloses that arbitral award is passed only against JDR number 1 company and the direction in the award is to the respondent, namely JDR number 1 company, to pay a sum of rupees so and so. The law is settled that company is separate legal entity from its directors and shareholders and therefore there is no question of executing award obtained against the company against its directors. In any event, no attachment has been issued in this petition subject to this observation and making it clear that decree holder can execute the award only against.
On 8/4/25 contrary orders are passed?
On 8/4/24.
Where is that?
Your lordships will get at page 75. That your lordships kindly turn to last portion of that.
First order ಏನು ಕೇಳದೆ ಮಾಡಿದ್ರಲ್ಲ ಅದು ತಪ್ಪು.
That is what I.
That is wrong.
ಅಲ್ಲ, ಅದನ್ನು ನಾನು ಹೇಳಿದ್ದೆ.
ಹಾಕಿದ ದಿನಾನೇ ಎಲ್ಲ ಬರ್ದ್ಬಿಟ್ಟು ಕ್ಲೋಸ್ ಮಾಡಿದ್ರಲ್ಲ, in your favor. That is the biggest mistake committed. So another mistake is that recalling the order.
ಅದಕ್ಕೆ ನಾನು
Or passing contrary orders.
So my
You are the
respectful.
beneficiary of slipshod orders.
No, but here lordship, here The other continuation which I have raised before the trial court, executing court is that.
Suit number code. Which is the suit you have filed? Sorry, petition you have filed.
It's WP 18947 of 25.
Tag this petition along with WP
18947.
18947 of 2025. List them both on Monday.
Great.
Let them serve a copy, Your Lordship.
Please, if they are appearing, I'll serve a copy right now.
No, because these
He will
petitioners-
appear.
Please.
He is the beneficiary of same day orders. So he will appear, yes.
But the other thing is that, Your Lordship.
Nothing,
No, the
that
possible.
application ಹಾಕಿದ ತಕ್ಷಣ ಬೆಳಗ್ಗೆ ಹಾಕಿದ ಸಾಯಂಕಾಲ ತೀರ್ಮಾನ
ಅಲ್ಲ,
ಮಾಡೋದಲ್ಲ,
ಅದನ್ನ ನಾನು
ಅದು
ಒಪ್ತೀನಿ.
ಪ್ರಾಬ್ಲಮ್.
ಅಲ್ಲ, ಅದನ್ನು ಮಾಡಿದ ತಪ್ಪೇ ಅದು.
ಅದು
ಯಾಕೆಂದ್ರೆ
ಮಾಡಿದ ತಪ್ಪು.
My right of hearing has been taken away now by virtue of this impugned order, Your Lordship.
ಅದು ಮಾಡಿದ ತಪ್ಪು, ಈಗ ಮಾಡಿದ ತಪ್ಪು.
ಅಲ್ಲ, ಎರಡು ತಪ್ಪೇ ಇದೆ. But the other thing is that, Your Lordship, other suit is filed by the petition number 1 as against this respondent here. ಅದು money suit.
ಆಯ್ತು ನೋಡೋಣ. ಎಷ್ಟು 32 lakhs is it? 32 lakhs and 50,000.
ಅದ್ರೊಳಗೆ 28 lakhs ನಾನ್ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅವ್ರ ವಿರುದ್ಧ ಹಾಕಿದೀನಿ, ಅದು ಪೆಂಡಿಂಗ್ ಇದೆ. ಸೊ ಇದು ಅಲ್ಲಿಗೆ ವಯ ಮೀಡಿಯಾ ಮಾಡಿ ಅವ್ರು ಮುಗಿಸೋದಾದ್ರೆ ಅದನ್ನು ಅವ್ರು ಮಾಡಬಹುದು.
ಮೀಡಿಯಾ ಮಾಡ್ತೀರಾ?
Those are companies and the one he's referring to are individuals.
All right, we'll see.
Another
Monday.
important aspect is affidavits were filed by them undertaking any liability of the company on themselves
Monday.
before the ROC.
We'll take it on Monday.
Please.
52.
Lord, for the petition in this case, I'm challenging the tender that is called for by the BDA. Tender call for ಮಾಡಿದ್ದಾರೆ. So
What for?
After executing the sale deed in my favor.
Page.
My lords, the impugned tender.
Page.
Page 14, my lords. The tender is at page 14. Invitation for tender.
Sale deed in your favor is 4/7/2015.
12, my lords. 2012 is the sale deed in my favor. 15 is the subsequent sale deed in favor of the present petitioner, my lords.
Now what happened?
My lords, subsequently they go ahead and do a unilateral cancellation, cancelling the 2012 sale deed, which I challenged before this honorable court. This honorable court cancels the unilateral cancellation, my lords. They failed to carry out the cancellation of the cancellation deed. I prefer another writ petition. My lord's order itself has directed them.
Where?
My lord's order is at page 43, my lords. Operative portion at page 48.
BDA, when I was sitting BDA. Now what happens?
After that, my lords, on 6/7/21, on the date of the order itself, they go ahead and they revoke the cancellation deed, my lords.
That's challenged here?
So that's not challenged.
Then
The cancellation deed, the sale deed it gets restored. In the
All
meantime, they file a suit to declare that the sale deed is not binding on them. That suit is continuing. When the suit is continuing, I file my additional written statement, my lords, so demonstrating that there are 44 such sale deeds in the same layout. Subsequently, they go ahead and now call for tender of the same site. So e-auction it.
Auction.
E-auction it, my lords.
Yes. Learned Counsel Ajay Kumar is directed to accept notice for respondent BDA, petitioner to serve set of papers upon the aforesaid counsel. The auction, when is the auction?
My lords, the auction was called for on 29/3.
That I know, when?
E-auction, same day, my lord, it is an e-auction.
ಆಗೋಗಿದ್ರೆ ಏನ್ ಮಾಡೋದು?
My lords, they may be directed not to confirm the auction, my lords, because the sale deed is still in force in my
All
favor.
right. All further, there shall be an interim order of restraint on the BDA to take any action pursuant to the auction conducted on 29/3/2025, if not already concluded as on date, including the confirmation of sale. Yes. Copy ಇವತ್ತೇ ಕೊಡಿ ಅವ್ರಿಗೆ. List the matter on 17th, 24th July. Yes, next.
53.
Appearing for respondent.
No, I am filing a memo.
Withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ, to dispense with the notice to R3 to R8 minutes. No, at the stage of the cross-examination of DW1, it is the petitioner herein, sixth defendant in the suit.
Yura?
Plaintiffs.
Sixth defendant.
Objection to the petition on following photos.
Photo?
I am in possession of the property. He is not in possession of the property. I am cultivating the land. The two sale deeds.
Again, 39, what is the application?
Application for amendment of the plaint was filed.
617.
Annexure
11
L,
and 12.
11 years after the suit was filed. And this case
WS date, issues date.
Yes. Written statement, I got myself implicated, I was not a party. And I filed the written statement. And
Date.
Yes, I'll give the issues were framed on 28/4/17.
28/4/17.
Yeah, PW1 gave evidence and she was cross-examined. Then I also gave evidence, page 139, on 21/10/2019. The matter was at the stage of the my further cross-examination. My cross-examination. Annexure L is the application for amendment filed on 3/1/2024. Suit is filed in the year 2013. In this amendment, the sale deed said to have been made by defendants 1 to 3 on 28/5/2001, 12 years before the suit was filed, is sought to be challenged.
By the amendment?
By way of amendment. After 23 years. And we filed our objections to this application because
suit for
partition by the daughters.
Partition a problem. Partition ಅಲ್ಲಿ ಸ್ವಲ್ಪ ಕಷ್ಟ ಅದಕ್ಕೆ.
ಅಲ್ಲಿ ತಾವು ದಯವಿಟ್ಟು ಇದನ್ನ ನೋಡಬಹುದು. ಅವ್ರ ಪ್ಲೇಂಟ್ ನೋಡಬಹುದು. Plaint at page 68, para 4. Para 4 at page 68, plaint nalli. They are aware of this transaction before filing the suit.
How do you demonstrate that?
Their averment itself says so.
Page 68.
Page 68, para 4 of the plaint. The first defendant is also Archak and has sufficient means to maintain the family. He is not managing the properties as.
So where do they mention about the sale of 2001?
In the middle of that. Plaintiffs and documents.
Land bearing survey number
43. In the last week of May 13, the plaintiff came to know that the defendants 1 to 3 colluded together and have executed certain documents in favor of 4 defendants. Immediately, the plaintiffs applied for copies of the said documents on 2/5/13 and obtained the same. The plaintiffs surprised to know that the defendants have executed sale deed in favor of the 4th defendant. The 4th defendant is a stranger and is not entitled to joint possession. This is the claim made.
Sale deed 2001 ಗೊತ್ತು ಅಂತ ಹೆಂಗೆ ಹೇಳಿದ್ರಿ?
ಅಲ್ಲ ಅವರು ಅದೇ ಹೇಳಿದ್ದಾರೆ ಸೇಲ್ ಡೀಡ್ ತಗೊಂಡಿದೀವಿ ಅಂತ. 4 defendant sale deed.
4 different sale deed. 4th defendant stranger so and so.
4th defendant
executed a sale deed in favor of the 4th defendant. Plaintiff surprised to know. This is the sale deed dated?
There they don't mention the sale deed. Now the sale deed by way of amendment page 140.
This is the same sale deed they're referring to.
Because I entered into an agreement to purchase that property before the suit was filed.
Yes, Leeladhar.
Yes. ಅಲ್ಲ ಇನ್ನು ಫುಲ್ ಎಲ್ಲ ಹೇಳ್ಬಿಡ್ಲಿ ಅವ್ರು ಇನ್ನೇನಾದ್ರು ಹೇಳೋದು.
ಪಿಕ್ಕಿದ್ ನೀವ್ ಹೇಳಿ, ಪಾರ್ಟ್ 2 ನೀವ್ ಹೇಳಿ.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಹೇಳ್ತೀನಿ. ಡ್ಯೂ ಡಿಲಿಜೆನ್ಸ್ ಬಗ್ಗೆ ಒಂದು ಸೆಂಟೆನ್ಸ್ ಇಲ್ಲ ಅವರ ಅಫಿಡವಿಟ್ ಅಲ್ಲಿ.
ಇನ್ ಪೇಜ್ ನಂಬರ್ 68 ಪ್ಯಾರಾ ನಂಬರ್ 4 ತಗೊಳ್ತೀವಿ. ಇನ್ ಪೇಜ್ ನಂಬರ್ 68 ಪ್ಯಾರಾ ನಂಬರ್ 4.
ಅಲ್ಲೇ ಇದೀನಿ.
ಅಲ್ಲ ಅದನ್ನೇ ಹೇಳ್ತೀನಿ ಒಂದು ನಿಮಿಷ.
ಅವರು ಅದನ್ನೇ ಓದಿದ್ದು.
ಅದನ್ನ ಮುಂದಕ್ಕೆ ಓದಲಿಲ್ಲ ಅವರು ಅಷ್ಟೇ.
ಅದಕ್ಕೆ ನೀವು ಓದಿ ಅಂತ ಹೇಳಿ.
ದಿ ಸರ್ವೆ will read it. He is not managing properties as the prudent man misusing the joint family property to deprive the right of the plaintiff. The land bearing survey number 43, measuring 1 acre 34 guntas, is a garden land. There are stone rivert well with pumps at 5 HP. Joint family has planted 30 coconut trees, 300 betel nut trees, and 200 plantain trees. It is continued to be in possession and enjoyment of the plaintiff and the defendant. This is what my statement. Then your lordship, take the written statement of the defendant number 1 and 2. That is in page number 94. That he has claims to have executed a sale deed in the form of a security for the loan he has been raised. That has been incorporated as the defendant number 1 and 2. Then your lordship see the return statement filed by the sixth defendant, petitioner here. That is your lordship is.
ಎಲ್ಲ ಯಾವಾಗ?
ಹೇಳ್ತೀನಿ ಎಲ್ಲ ಹೇಳ್ತೀನಿ ಸ್ವಾಮಿ.
ಅಲ್ಲ ಎಲ್ಲ
During
ಹೇಳ್ಬೇಡಿ.
sale deed
ಡೇಟ್
ಆಗಿದೆ.
ಹೇಳಿ ಸಾಕು ಯಾವಾಗ ಅಂತ.
ಅದಕ್ಕೋಸ್ಕರನೇ your lordship.
ರಿಟರ್ನ್ ಸ್ಟೇಟ್ಮೆಂಟ್
Yes,
ರಿಟರ್ನ್
your
ಸ್ಟೇಟ್ಮೆಂಟ್
lordship. What your
ಯಾವಾಗ?
lordship submitted is true, your lordship.
19614.
ಒಂದೇ ನಿಮಿಷ.
19614.
ಒಂದೇ ನಿಮಿಷ.
Annexure F page 100.
617 filed on 2025 4 or 5?
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ.
617 application filed when?
24, January
Your lordship see
2024.
that. Your lordship see that internal page. Internal page 224. 224. He got the sale deed registered on 29/8/2024.
ಯಾರು?
You
29/8?
2024. Ink page number 24.
What sale deed is that?
Annexure R.
But before the suit was
So
filed.
that this made us to file the amendment.
One second.
Amendment.
One ನಿಮಿಷ. What sale deed?
Before this suit was filed, I had entered into an agreement to purchase item 1 property from the fourth defendant.
When?
But that was in the 28.
That suit
30,
is
yeah, 3713.
Agreement 3713.
How? Then this
3713.
13.
ಹನ್ನೊಂದು ವರ್ಷ ಯಾಕೆ ತಗೊಂಡ್ರಿ ಸೇಲ್ ಡೀಡ್ಗೆ?
ಅಲ್ಲ ನಾನು ಸೇಲ್ ಅಗ್ರಿಮೆಂಟ್ ತಗೊಂಡಿದ್ದೆ.
ಕರೆಕ್ಟ್. ವೈ ಸೇಲ್ ಡೀಡ್ 11 years?
ಸ್ಪೆಸಿಫಿಕ್ ಪರ್ಫಾರ್ಮೆನ್ಸ್ ಸೂಟ್ ಹಾಕ್ಬೇಕಾಯ್ತು ನಾನು.
ಹಾಕಿದ್ರ?
ಹಾಕಿದ್ರು 2016 ಅಲ್ಲಿ ಹಾಕಿ
ಏನಾಯ್ತು?
ಡಿಕ್ರಿ ಆಯ್ತು. ಆಮೇಲೆ ಅದರಲ್ಲಿ ಎಕ್ಸಿಕ್ಯೂಷನ್ ಅಲ್ಲಿ ಸೇಲ್ ಡೀಡ್ ಆಗೋದಕ್ಕೆ 2024 ಆಯ್ತು. And now lords, this present application filed to challenge lords the first transaction which was already 12 years old before the suit came to be filed. And otherly due diligence ಬಗ್ಗೆ affidavit ಅಲ್ಲಿ one
right, but this appears to have become a necessity for him.
No, kindly appreciate
the subsequent event.
ಅಲ್ಲ subsequent event ನಾನು 20 ಈಗ first amendment on the face of it when it was suit was filed, the sale was 12 years old. And kindly see.
No, correct. Suit was filed. Sale was 12 years old. Which is the agreement you are now talking of, which has connection with this property?
This property.
Correct.
Is
all right. Now you enter into agreement of sale with.
Before the suit.
Correct. Before the suit.
Yes.
But after the filing of the suit, the sale deed is executed, on which they also have a claim.
Based on that,
correct.
Lords, based on my suit, I filed an application to implead myself in this case in 2014 itself. Then I filed my return statement saying that I am an agreement holder. And Lords, I had to file a suit for superior performance against D4 in the suit, and Lords, I succeeded. And the execution, and in the execution, they filed a 2197 petition. That was dismissed, and RFA is filed by them. So therefore, my submission to Lordship is the first prayer which they sought in January 2024 itself, Lords, could not have been granted by the trial court. In the plaint itself, they say.
No, generally, yes, 617 at this stage is not permissible.
But
proviso to 617 will be hit. He will be hit by proviso to 617. All that fine. But here, the amendment became a necessity because of this event.
My transaction was earlier, but
but that culminated into a sale deed only now.
Correct. But as long as they cannot challenge the first sale deed.
No,
first sale deed, they can't challenge it. Lords, kindly appreciate.
Amendment generally I would not permit, but here I guess it is necessary.
No, kindly appreciate. So what happens is, in the effort, they were aware of this sale deed before the suit was filed, as you lordships have seen. They have obtained the certified copy of the document.
They were aware of a particular sale deed prior to the suit.
Yes.
After that, you enter into an agreement.
No. My agreement was prior to the suit. My agreement was prior to the suit. Therefore, Lords, I filed an application to implead myself, and my return statement was of 2014. And my specific performance suit was filed in 2016. And Lord's execution
that's not against them.
Correct, only in respect of that property only.
Yes.
Now, therefore, Lords, what happens is, whether the sale deed of 28/5/2001 could be assailed as on the date of the suit, first question, which I would like to address. As on that date itself, it was more than 12 years old. Articles 58 and 59.
No, that's all right. If it is a necessity, it become a necessity because of your action.
The futility of the whole thing, the exercise is,
as on the date of the suit itself, my lords, their remedy in respect of this property or this sale deed was already time barred. And the suit is.
When is the next date?
14/7.
I'll take it on 9th, we'll see. List the matter on 9th.
The interim order may kindly.
Interim order subsisting will.
Documents are already completed.
ಈಗಲೂ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ 9th ಅಷ್ಟೇ.
Much of.
List on 9th. Interim order subsisting will continue to the next.
Interim order may kindly.
ಹೇಳಿದ್ನಲ್ಲ. Yes.
ಅದು
ನಿಮಗೂ
dispensation
ಇಂಟ್ರಿ
order.
ಮಾಡಿದ್ಯಾ? ನಿಮಗೂ ಇಂಟ್ರಿ ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ.
ಅವ್ರಿಗೆ ಮಾತ್ರ ತಾನೆ.
ಅವರಿಗೆ
ಅದು dispensation. Dispensation ತಾವು ಆದೇಶ ಮಾಡ್ಬಿಟ್ರೆ. ನಮ್ಮ ಮೆಮೊ.
Dispensation?
Respondent 3 to A. I'm requesting for dispensation of the notice to them. Because the registry has
3 to 8 memo ಕೊಡಿ.
ಕೊಟ್ಟಿದ್ದೀನಿ.
ಕೊಟ್ಟಿದ್ದೀರಾ?
I have given.
In
Just
terms
now I
of
passed
memo.
on the memo.
Dispensed at the risk of the petitioner.
54.
I appear.
For the respondent number 1.
This
Yes, sir.
petition, my lord, is by the defendant number 1. We made an application for production of some documents. The lower court, my lord, allowed production of only one document. Agreed by that, my lord, the present petition is filed. My lord, the suit is for eviction and recovery of arrears of rent. And the lease deed came to be executed in 2016. Later on in 2017, I assigned it in favor of.
Which is the document not allowed?
Yes, Lord. Kindly see the application.
Page. Serial number 7 ಮಾತ್ರ ಕೊಟ್ಟಿದ್ದಾರೆ. ಮಿಕ್ಕಿದ್ದು ಯಾವುದು?
97, page 97.
Settlement. Building ಖಾತಾ extract, ಖಾತಾ certificate, OC, fire safety ಇದೆಲ್ಲ ಬೇಕಾ?
ಅಲ್ಲ ಅದರಲ್ಲಿ BBMP approved plan, occupancy certificate, ಖಾತಾ certificate ಇದ್ರೆ fire safety. Because the lease deed says that if statutory clearances are there, then only.
Who is the owner of the property?
Owner of the property is the plaintiff. He has filed a suit seeking for eviction and as well as recovery of arrears of rent.
You are the defendant.
Yes, I am for the first defendant. Now in the suit, my lord, in the evidence at page 85, he says that I have the documents, I will produce it. Kindly see page 85.
All these documents?
He says approved sanction plan, commencement and completion certificate will be produced. Page 85.
I am there.
About
Yes.
10 lines from
It
the
is
top.
suggested.
If necessary, the approved sanction plan, commencement and completion certificate issued by this shall be produced by the court. It is
ಅದನ್ನ
our-
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ಅಷ್ಟೇ.
Lords,
ನೀವೇ ಒಪ್ಕೊಂಡಿದ್ದೀರಾ?
Lords, if necessary, my lords.
Now it is necessary.
It is not so, my lords, in my humble submission. This, my lords, the suit is for, it's a commercial suit, my lords, for eviction and arrears of rent, my lords.
Correct.
The respondent, the first defendant, my lords, this suit has expired, the term has expired as on 2021 itself, my lords. So, my lords, now, in the guise of the cross-examination, firstly, my lords, the respondent has not filed his written statement, my lords. It has been forfeited. In the guise of the cross-examination, my lords, he makes these unnecessary questions, my lords, regarding the title to the property, my lords. And my lords,
No,
these
title,
documents,
occupancy certificate of the BBMP and completion certificate by BBMP ಅಷ್ಟೇ.
my lords, these, at this stage, my lords, when,
Why did you accept that you are going to give?
my lords, if necessary, my lords, it is stated,
ಇದು ಆ
the
ತರ
question,
ನೀವು if necessary ಅಂದ್ರೆ ಅವ್ರಿಗೆ necessity ಬಂದೇ ಬರುತ್ತೆ.
there is no necessary, my lords, that is.
That you can't say after saying if
My
necessary.
my submission is this, my lords. For the purpose of deciding the issue, the purpose of the suit itself, my lords, these documents are not necessary.
Now
because
who is the tenant?
that is a defendant number 2, my lords. Defendant number 1 and 2 is my submission, my lords, because the lease was firstly executed in favor of the defendant number 1. Subsequently, my lords, 1 year after.
ಯಾಕೆ ನಿಮ್ಮ ಹತ್ರ ಇಲ್ವಾ ಅದು? Occupancy certificate ಇಲ್ವಾ?
No, I don't have the occupancy certificate with me, my lords.
Then how did you lease it out?
My lords, I have leased it out, my lords. Whatever documents were there, I have produced it. I have handed it over to the defendant number 1 at the time of the lease deed. He's accepted it, and then, my lords, he's taken on lease. And then after 1 year, my lords, he assigns it to the second defendant. They are still in possession. They're running a bar.
Who is the first defendant?
He's the first lessee, my lords.
He's not, you are the second defendant, is it?
Second, I am the first defendant.
Oh, you are the lessee.
I took the property on lease.
ಆಮೇಲೆ sublease ಕೊಟ್ರಾ?
Subsequently, given it to second defendant. But the lease deed says that if clearance, statutory clearance are not there, then I am not liable to pay the rent.
In fact, my lords, the
For
lease
that
deed also
purpose.
says, my lords, that the lease stands automatically terminated, my lords. May I kindly see
That
page
is a
53?
matter there, sir.
Illa, Swami.
Now we are only on documents.
My lords,
In your cross-examination, you have said you will give it.
my lords, if necessary, my lords, I have stated that these documents
Now
are
necessity is told by the senior
My
counsel.
lords, the necessity, my lords, for the adjudication of the suit, it is not so, my lords, in my respectful submission. Because, my lords, it is a matter simpliciter for eviction, my lords. The defendant number one, my lords, may I just
Eviction,
complete this?
recovery of money.
Yes, my lord. The defendant number one, first of all, my lords, asks specific questions regarding the liability to pay rents, and in yours that the lease having been assigned in favor of the second defendant, there is no liability on the part of the first defendant to pay the rents, my lords. So in one breath, my lords, he says that the lease stands assigned, and then, my lords, ask questions about the sanction plan,
Why
the
did you
occupancy
answer?
certificate.
Why did you
Lord,
answer?
it was asked, the witnesses answered, my lords. The necessity for deciding the suit in question, my lords, does not arise at all, because the defendant, who doesn't in any way have a defense, he is only stating this, my lords. In the same breath, he is asking
Correct.
contradictory
In one
submissions.
breath, he asks that. In another breath, he is asking that.
Please, my lords.
Why you did not hold your breath there?
My lords, I have, my lords. In fact, if the cross-examination is perused, my lords, I kindly see. Yes, sir. He has also stated that he has to verify and submit. Please. Now, my lords, the necessity for of these documents.
OCCC ಇದೆಯಾ ಇಲ್ವಾ ಅಷ್ಟೇ ಇದೆ ಅಂತ ಹೇಳಿದೀರಾ ಕೊಡಿ.
My lords, I
ಬೇರೆ
have
ಎಲ್ಲ
filed-
ಡಾಕ್ಯುಮೆಂಟ್ ವಿಲ್ ಲಿವ್
I
ಇಟ್.
have, in fact, my lords, I have
All
filed
other
specific-
documents, fire safety ಅದೆಲ್ಲ ಬೇಡ.
My lords,
OCCC.
I have filed, may I just produce my written submissions, my lords, where I have categorically stated that these documents are not with me, my lords, in my possession. That I have stated, my lords.
Why did you say this, sir? Written submission li ಏನ್ ಬೇಕಾದ್ರೆ ಹೇಳಿರ್ಬೋದು. While deposing in cross examination, why did you say I have it, if necessary I will produce it?
My lords, the reason is this, my lords. These documents, the sanction plan,
You should never get caught in cross examination.
No, no.
That's the whole problem.
the issue is this, my lords. The question is asked to me about these documents. I have given these documents to the defendant at the time of the lease deed, my lords. Otherwise, there's no cause for him to enter into the
That
lease
is
deed.
not your answer.
Fair enough, my lords. The fact remains so that because if they are relying on the lease deed, my lords, if I may submit, if they are relying on the lease deed, which is already expired, my lords, by effects of time, then, my lords, there are also specific clauses stating that if there is no license given to operate the premises, then the lease stands automatically terminated. So, my lords, essentially what the defendant is asking is for specific performance of a lease of a document that is already expired, my lords, wherein that particular document is not even relevant to decide the suit. In fact,
That's according to you.
No, that is also, my lords,
According to them,
I
that-
will just rely on the document.
Because the senior counsel just now said, if there are no statutory clearances, he would not become liable to pay the amount that you are demanding.
In my respectful submission, my lords, that is a matter that they ought to have taken in defense. They have not filed the written statement, my lords, beyond 120 days.
Sir, not filing of written statement does not preclude them from cross-examination.
They are not, they have.
They have elicited something in cross-examination. The elicitation has caught you now.
My lords, the relevance of it, in fact, that is the language of Order 11, Rule 14, my lords.
No problem, sir.
So, my lords, it is not that the
The
party.
cross-examination does not, right to cross-examine does not go away, and cross-examination, what
saying
is
that.
elicited cannot be washed
No,
away.
my lords, I'm not. In fact, the language of Order 11, Rule 14, if
Oh,
it is
please,
seen,
sir. Yes,
please,
sir.
my lords. Production of documents. It shall be lawful for the court at any time during the pendency of any suit to order the production by any party thereto upon oath of such of the document in his possession or power relating to any matter in question in the suit, as the court shall think right. And the court may deal with such documents. In fact, my lord, the court has exercised its discretion. That is also seen from the impugned order, my lord.
Exercise discretion
Please, my lord.
and permitted 7.
Yes, my lord.
We will permit OC and CC now.
No, my lord, the relevance also has to be looked at, my lord, of these documents. In the
Relevance
state-
is just now said.
But it is not justified, my lord. The relevance is,
That is before the court will come. Sir.
the
mere-
relevance to
1 minute.
produce.
Mere production of a document will not be all and end all of this suit. It will have to be tried. It will have to be tried. ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ ಇಲ್ವಾ ಅಷ್ಟೇ?
ಅದು ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ, ಅದು ಇಲ್ಲ ಸ್ವಾಮಿ.
ಇಲ್ವಾ?
That, it is not there, my lord. I have stated that. I have stated that before the
I
court.
will record it.
Please.
And whatever inference that can be drawn by the court will be
That's
drawn.
all I am stating, my lord.
ಅವ್ರ ಹತ್ರ ಇಲ್ವಂತೆ ಬಿಡಿ ಸರ್. ಸೊ ರೆಂಟ್ ನೀವೇನ್ ಕೊಡ್ಬೇಕಾಗಿಲ್ಲ.
ಅದನ್ನೇ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನಮಗಿಲ್ಲ ನಾವು ಕೊಡಕ್ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ ಆಗಿರೋದು.
ನಾ ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ, written arguments ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಹೇಳಿಲ್ಲ,
I
trial
will produce
court
it also, my lords.
ಅಲ್ಲ ಈಗ ಇಲ್ಲ ಅಂತ ಐ ವಿಲ್ ರೆಕಾರ್ಡ್ ಇಟ್ ನಿಮ್ಮ ಹತ್ರ ಇಲ್ಲ ಅಂತ. ಸೊ ಆ ಇಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ಏನ್ ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಫ್ಲೋ ಆಗುತ್ತೆ ಹೋಗ್ಲಿ.
ಏನ್ ಪರವಾಗಿಲ್ಲ.
ಮ- ಏ, ಆ, yes.
ಅಲ್ಲ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 1 to 6 is what we have sought.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ನೀವು OCCC ಬಿಟ್ಟು ಬೇರೆ ಎಲ್ಲ ಅನ್ನೆಸರಿ
ಯಾವ್ದಿಲ್ಲ ಅದನ್ನಾರು ಹೇಳಿ.
ಅಲ್ಲ ಈ OCCC ಇಲ್ವಂತೆ, ಬೇರೆ ಎಲ್ಲ ಇಲ್ವೇ ಇಲ್ಲ ಬಿಡಿ.
ಪ್ಲಾನ್
ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್ ಇದೆಯಾ?
Sanction plan ಇದೆ ಸ್ವಾಮಿ.
ಈಗ್ಲೂ ಇದೆಯಾ?
My lords, it's not in my possession, my lords. That is what I have stated.
ಎಲ್ಲಿ ಬೇರೆ?
I don't have it, my lords. I have also searched. I have whatever I have searched, my lords. It is a property that was constructed nearly 20 years ago, my lords. It is not there.
ಯಾಕೆ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಟ್ಕೊಳಲ್ವಾ?
It is not, my lords. That's all I'm stating, my lords.
ಸ್ಯಾಂಕ್ಷನ್ ಪ್ಲಾನ್ ಇಲ್ಲ.
Sanction plan OC and CC is not there, my lord. You will have to be recorded.
SP OCCC ಮೂರು ಇಲ್ಲ. All inferences can be drawn by the court because of
The court, in fact, my lords, analyzes that, my lords, on the question of relevancy, my lords. That is evident from the impugned order itself. Whether it is
will
necessary.
answer. Relevancy, the learned senior counsel says that if statutory clearances like this are not available, his payment of rent becomes a doubt.
Because that in any way, the submission is that because the lease stands assigned in favor of the defendant number 2, he is not liable to pay rents. So it is both. It is both, my lords.
One more submission ಮಾಡ್ಲಿ ಬಿಡಿ.
One more ground to, my lords, not to submit, although they do state in the petition that they are in possession, my lords. So they have stated everything, my
ಅಷ್ಟೇ.
lords, altogether.
ಅವ್ರ ಹತ್ರ ಇಲ್ಲ, ಅಲ್ಲೇ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೇಳಿದ್ರೆ ಇಲ್ಲಿ ಬರ್ತಾನೆ ಇರಲಿಲ್ಲ ಅವರು.
ನಾ ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ, written submission, I can file it also, my lords.
ಅಲ್ಲ ಪಾರ್ಟಿ ಹೇಳ್ಬೇಕು, ಇವ್ರು ಲಾಯರ್ ಹೇಳಿದ್ರೆ.
ಅಲ್ಲಿ ಈಗಲೂ ಲಾಯರ್ ಹೇಳ್ತಿರೋದು.
ಅಲ್ಲ ಇಲ್ಲಿ your lordship would be recording it.
ಓ ಹಾಗೆ, yes. We'll close it then. Yes, Prasanna. The petitioner, the first defendant, is before this court calling in question an order dated to June the 2nd, 2025, passed in commercial OS 418 of 2024, answering an application filed under Order 11 Rule 14 of the CPC, seeking production of certain documents. The ಏನು ಅಲ್ಲೇ ಹಾಕ್ಬಿಡಿ. Yes, the learned heard sounds. The suit is for recovery of money and delivery of vacant possession of the property. The petitioner is said to be the lessee from the hands of the respondent plaintiff. After the lease deed executed in favor of the present petitioner, transpires as the present petitioner, defendant number 1, has executed a sublease with defendant number 2. The issue in the list is with not with regard to the rights of the lessee or the respondent. An application is filed before the concerned court by the first defendant, the petitioner, seeking production of documents as described in the application. The documents that the petitioner sought to produce from the respondent are as follows. Page 97, madam. Mark portion.
May I make one submission, my lords? These documents, but they have never asked it before, my lords. Only in the cross-examination this is specified.
Written statement ಹಾಕ್ಲಿಲ್ಲ, ಎಲ್ಲಿ ಕೇಳ್ತಾರೆ? ಅದಕ್ಕೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಕೇಳಕ್ ಸಾಧ್ಯ.
Before that also they have not asked, my lords, in any communications.
A defendant can first project his defense in written statement. ಆಮೇಲೆ through this. ಈ written statement ಹಾಕಿಲ್ಲ, ಟೈಮ್ ಬಾರ್ ಆಗೋಯ್ತು. Only through this.
Yes, my lords.
ಅಷ್ಟೇ.
Stating even before the written statement, in any communication they have not asked for it, my lords.
Before written communication,
Any
before the
communication,
suit.
they have never, yes, my lords, they have never. They are in
We'll-
default
we'll
of payment
record,
of rents
yes.
for the last
So
5
and
years.
so. The learned senior counsel, Shri Ashok Harnalli, submits that the concerned court has erred in allowing an application at serial number 7 while declining all other 6 applications quoted supra. The learned senior counsel would further emphasize on the fact that the sanctioned plan, occupancy certificate and ಇನ್ಯಾವುದು?
And completion, sir.
And completion ಅಲ್ಲಿ ಕೇಳಿಲ್ಲ ನೀವು?
ಅದು ಇಲ್ಲಿ completion ಇಲ್ಲ, ಅದರಲ್ಲಿ building ಖಾತಾ
The
occupancy.
The building khata extract, the approved sanction plan and occupancy certificate were imperative to be produced to determine the liability of payment of rent at the hands of the petitioner to the respondent.
As per the lease, terms of the lease.
As in terms of the lease deed appended to the petition entered into on 16th April 2nd April 2016. The learned counsel appearing for the respondent, the learned senior counsel takes this court through the cross-examination of the respondent. The cross-examination reads as follows. The relevant portion of the cross-examination reads as follows, page 83, 84. In the cross-examination, the respondent PW1 has admitted the fact that the completion certificate, sanction plan, occupancy certificate are all available and would be given at the appropriate time if need arises. The learned counsel for the respondent now lays emphasis on the fact that those are not necessary documents.
Case law.
Not necessary documents, and would seek to place reliance upon certain reliance upon the judgments. Citations. Certain judgments of which court?
Bombay High Court.
Judgments of other high courts to contend that documents that are necessary alone should be directed to be produced. The cross-examination of the petition of the PW1, the respondent, is as quoted herein above. If it is his case that those documents were available and those documents were necessary to determine the amount of rent that is payable, they become on the face of it necessary documents which are germane for consideration of the issue in the list before the concerned court. The learned counsel for the respondent now submits that he does not have those documents. The documents would be the sanction plan, OC and CC. If those documents are not there, the order of the concerned court permitting production of document number 7 would stand to reason. And it is for the petitioner to take advantage of the fact that no, those documents are not available and project his defense before the concerned court at the appropriate time in the appropriate stage. With the aforesaid observations, the petition stands disposed while sustaining the order. With sustaining the order. But with the aforesaid observations, the ಬೇರೇನು ಮಾಡಕ್ಕಾಗಲ್ವಲ್ಲ. 7 ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದಂತೂ ಇರಲೇಬೇಕು. ಇನ್ಯಾವುದಿಲ್ಲ ಅವ್ರ ಹತ್ರ.
ಅಲ್ಲ, ಬೇರೆ ಯಾಕೆ ಕೊಡೋಕ್ಕಾಗಲ್ಲ ಅಂತ ರೀಸನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. That reason will stand.
The reason so rendered by the concerned court while declining to accept serial item numbers 1 to 6 would on the face of it become illegal, as the real reason is on the actual reason is on the submission of the learned counsel for the respondent that they are not available. Yes. In that light, with the aforesaid observation, petition stands disposed. The reasons so rendered are thus contrary to law. The aforesaid observation, the petition stands disposed.
55.
Really?
Case law specifically says, what I've relied upon, my lord, is
Relevance.
yes, my lord, relevance
That is
also.
too rudimentary for a case law to be seen on that. Production of documents cannot be that you will ask anything under the sky. There should be some relevance.
Admissibility is also that's something that the judge has to decide, my lord, which is what the trial judge has done.
ಡಾಕ್ಯುಮೆಂಟ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅಡ್ಮಿಸಿಬಿಲಿಟಿ ಏನ್ ಡಿಸೈಡ್ ಮಾಡ್ತಾರೆ ಸರ್? ಅಲ್ಲೇ ಹೇಳಿದ್ರೆ ಅದೆಲ್ಲ ಆರ್ಡರ್ ಬರ್ತಾ ಇರ್ಲಿಲ್ಲ.
Like petition refusing ex parte injunction despite 3 judgments, my lord, is the matter.
The petitioner shall serve on the counsel who petitioner shall serve on the respondent by way of hand summons and file an acknowledgement of such service by the 8th of July 2025. List the matter on 23rd July. Till such time, temporary injunction as sought by the petitioner before the concerned court shall ಏನ್ ಕೇಳಿದ್ ನೀವು?
Not to interfere with the
there shall be a temporary injunction as prayed for before the concerned court. Yes, next.
56.
There are 3 judgments of this court. Even then, PI is not granted.
Petitioner counsel also. An application for impleading has been rejected, my lords.
What is rejected?
An application for impleading.
Leave is granted.
Lords,
92 proceeding, leave is granted.
Lords, section 92, my lords, we are the petitioners and the application for leave is being under consideration. Now, the only question is this, my lords, in respect of the property for which the present respondent who is to be the tenant, my lords, is a tenant in respect of this temple property.
Leave grant ಆದ್ಮೇಲೆ ಎಲ್ಲ ಕೇಳ್ಕೊಡಿ.
Leave grant. lease is
Agila
not-
andmele it is still a scheme plaint and not a scheme
That's true, my
suit.
lord. That's a well settled. The recent judgment, your lordships have pronounced that it is not a, it's a stillborn plaint.
Legally inert.
Yes, it's a stillborn, no difficulty, but not, that's, the question is something else. May I just pass on this judgment, my lords?
For what, sir?
So far as the question as to whether we are required to be implemented or not in a matter of this nature.
Amele.
Yes.
Who has instituted the suit?
Not the suit is filed by a person who is related to this temple, claims himself to have executed a lease deed in his personal capacity for a tenant who is in occupation under the temple for over several years. Now, the person says that now that I have executed the sale, I will take possession of the property. But this is a property belonging to the temple. He cannot come and say that he wants to take possession of the property.
Who is wanting to take possession of property?
No, it's a person who is related to the temple in his capacity as a trustee, executes a lease document in favor of a tenant who is existing for over 60, 70 years under the temple, saying that now that I have executed the document in respect of this property in my name, I will take possession of the property. That is the suit.
That becomes an urgent need for grant of an interim order there.
Lords, that's the reason, Lords. The law is the parameters, yes. The parameters under Order 1 Rule 10 is distinct in respect of.
Order 1 Rule 10 is fine.
Yes.
The court answering section 92, unless the suit is, leave is granted in the suit, it still remains. But there is one play in the joint. That is where there is urgent interim order to be granted.
That can be done.
That can be granted despite the bar of granting of leave. All right. Now you want to implead to protect that property.
Yes.
Which is now wanting to be taken away or
Taken away by an individual who is none other than the trustee of the temple.
You serve on him. When is the next date there?
5th, my lords, it is. For judgment, it is posted on 5th.
Judgment.
By rejecting this application, matter is posted for judgment on 5th, my lords.
Leave grant agde judgment. Yavadr mele?
The suit, my lords, we are the petitioners in a section 92 application. Leave is pending. Lords, now this is a suit for ejectment which is filed by a trustee saying that since the name in the lease deed is my name, I will take possession of the property in an independent suit.
This is a separate suit.
Separate suit.
Sorry,
my lords, I love.
Yes. The petitioner shall serve on the respondent. Respondents, huh?
Please, respondents.
ಎಲ್ಲ ಅರ್ಚಕರನ್ನು ಒಟ್ಟಿಗೆ ಕೂಡಿಸ್ಬಿಟ್ಟಿದ್ದೀರಾ ಇಲ್ಲಿ ಇಲ್ವಾ? Yes. Heard the learned senior counsel D.R. Ravishankar appearing for the petitioner. The respondent, the petition counsel for the petitioner will serve on the counsel who represents the respondent number 1
Respondent
and 2.
number 1 and 2.
1 and 2 before the concerned court in OS.
Lords, commercial OS 955.
Commercial OS 955 of
2023.
2023 and file an acknowledgement of such service before by the 8th of July 2025. There shall be an interim order of stay of further proceedings in the commercial OS 955 of 2023 till the next date of hearing. List the matter on 23rd. Yes. You separate suit anta helilla.
Lordship said 8th of
July.
We shall file
Serve
it.
ಮಾಡಿ 8th of July.
Very well, my lords. We shall file it.
ಇಲ್ಲಾಂದ್ರೆ interim order ಬೇಕಾಗ್ತದೆ.
I understand. Yes.
57.
For the different number 1 and 2, my lord, are the
TI concurrent.
No difficulty, my lord. Your lordship says, my lord, page 134. Annexure P, my lord, page 134.
134,
my lord, 134. There, my lord, Mahalingappa is the propositus. He had 4 sons. The 2 sons, suit for permanent injunction, bare injunction, my lord. Now, plaintiff comes, my lord, in the branch of Murugendrappa, first branch. Plaintiff number 1 and 2. Then I come, my lord, in Tiperudrappa's branch. Last branch, my lord, Umapati, different number 1. The 2 brothers, Murugendrappa and Maheswarappa, separated, my lord, prior to 1961. So the other 2 brothers continued jointly. There was a registered partition, my lord, in between these 2 brothers as early as on 16/11/1961. In the registered partition dated 16/11/1961, my lord, the suit schedule property which the present plaintiff claims has been allotted to the share of Sangaram Basappa and Tiperudrappa. Later, my lord, again a partition in between ourselves in our branch, that is, my lord, on 20th 10/1986. This is also registered partition date. Partition, my lord, in between the sons of Tipir Darpa Ras branch. The suit schedule property, my lord, in between ourselves, it.
No, you serve on the respondent. Now plaintiffs, you are the defendant.
Yes.
Plaintiffs
My lord,
injunction.
there was no interim order, my lord.
There
ex parte.
was.
There was no ex parte interim order in the trial court.
Correct.
Then
After hearing you, the application is allowed.
First appellate court, my lord, said, I will hear. It reserved the judgment within 1 month, my lord, from the date of filing the appeal, pronounced 3 months later. Whatever it is. Appellate court said, my lord, I will hear and pass the judgment. It has passed the judgment. What the first appellate court says is, no documents need to be looked at this stage. We will go to the defendant's possession or not will have to be decided at the trial. So, my lord, the first appellate court doesn't.
Immediate problem agide.
Police protection ಕೇಳಿದ್ದಾರೆ ಅವರು. Trial court has issued police protection. If they are in
Injunction ಇದ್ರೆ police protection ಕೊಡ್ಲೇಬೇಕು, ಕೊಡ್ತಾರೆ.
Possession ಇದ್ರೆ police protection ಬೇಕಾಗಲ್ಲ sir. Injunction ಸಾಕಾಗತ್ತೆ. If these police protections are always, my lord, backdoor methods of getting into the property. My lord, 63 years prior to the filing of the suit, my lord, this property had fallen to our share. 32 years prior to the in the second registered partition.
Sir, one, the petition heard the learned counsel G. Balkrishna Shastri appearing for the petitioner. The
even status quo, my lord, would serve my purpose.
Yes. The learned counsel for the petitioner shall serve on the counsel for the plaintiffs. Counsel for the plaintiffs forthwith. List the matter on 23rd. Till such time, parties to maintain status quo as obtaining today.
Please.
Yes.
58.
Yes, sir. Queen City litigation agle banta?
Malad, this is a logistic park.
Yes.
Even before preliminary notification.
Possession ತಗೊಂಡಿದಾರಾ?
ಇಲ್ಲ, allotment is completed.
ಬೆಳಿಗ್ಗೆ somebody told me, I asked him, is that possible even?
That is how, Malad.
Yes, sir.
I wanted to make a submission to your lordship.
48.
No, if it is for a PPP, Malad, public, consent is a mandatory under the act.
PPP is public-private partnership.
Yes. Where the central government also has got some share. Under section 2(2), Malad, it is only through consent. They can only exempt state governments over social impact assessment and the other chapter 3. But consent they can't, Malad. That's your position.
ಅಲ್ಲಿ ಎಲ್ಲಿ ಕನ್ಸೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ ನಿಮ್ದು?
ಅಲ್ಲ, ನಂದು ಕನ್ಸೆಂಟ್ ತಗೊಂಡಿಲ್ಲ, ಏನು ತಗೊಂಡಿಲ್ಲ.
ಪ್ರಿಲಿಮಿನರಿ ನೋಟಿಫಿಕೇಶನ್ ಯಾವತ್ತು ಮಾರ್ಚ್ ಅಲ್ಲ?
ಹೌದು. ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್, preliminary notification, both have been issued.
ಎರಡು ಇಶ್ಯೂ ಆಗಿದೆ.
ಹೌದು. In fact, I suggested my learned
compensation.
Now under the 2022, my lord, so far as the Karnataka Act, they incorporate the provisions of the Central Act with effect from 1/1/2014. And even under section 26C, my lord, that the compensation is also in terms of the
correct determine ಮಾಡಿದಾರಾ?
ಮಾಡಿಲ್ಲ. Consent ತಗೊಂಡಿಲ್ಲ.
Yes, sir. What is all this?
Their composition. Let me seek instructions, my lord.
No, 2019, there is one more rules have been framed and received the assent of the president. Under that, only chapter 2nd and the 3rd can be exempted, not by consent.
Allotment ಯಾರಿಗೆ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಈಗ? KDB ಇದೆ.
KDB notification ಆಗಿದೆ. ಯಾರಿಗೂ ಅಂತ
ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಾ?
They just informed me. So
Learned heard the learned senior counsel V. Lakshmi Narayan appearing for the petitioner. The I forget the name. Vasudev, alla? Learned counsel Vasudev is directed to accepts notice for respondent
2 and 3.
2 and 3. Learned HCGP for the first respondent. The learned senior counsel submits that preliminary notification is issued on 2/3/24. Objections are filed without considering the same. Final notification is issued on 6/6/2024, and even before determination of the compensation, the allotment has already begun to all this, begun to the second and third respondent board. Therefore, the learned senior counsel submits that there is gross procedural aberration in taking away the lands of these petitioners In that light, status quo in that light, status quo as obtaining today be maintained by the parties till the next date of hearing. Petitioner to serve set of papers upon the state and the council appearing for the KIDB, list the matter on 18th.
My lord, status quo for further proceedings. They will
All status quo, adbada. Therefore, all further proceedings pursuant to the final notification shall remain stayed till the next date of hearing. Yes.
The same thing is going on even in Devanhalli. Everywhere, my lord.
Is in Greater Bangalore?
Illa. No, they are trying to evict these farmers and they wanted to give it to the North India.
Devanhalli farmers idara?
ಅಲ್ಲಲ್ಲ ದೇವನಹಳ್ಳಿಯಲ್ಲಿ ಅಲ್ಲಿ ಈಗ ಗಲಾಟೆ ನಡೀತಾ ಇದೆ.
ಅಲ್ಲ ದೇವನಹಳ್ಳಿ ಎವಿಕ್ಟ್ ಫಾರ್ಮರ್ಸ್ ಅಂದ್ರೆ ಯಾರು ಫಾರ್ಮರ್ಸ್ ಇದಾರೆ ದೇವನಹಳ್ಳಿಲಿ? ನೋ ಫಾರ್ಮರ್. ಫಾರ್ಮರ್ ಅಂಡ್ ಫಾರ್ಮಿಂಗ್ have become farm houses ಅಷ್ಟೇ. Yes.
Admission 59.
For the respondent. Seventeen years ಇಂದ ಇದರ ಪ್ರಾಪರ್ಟಿ ಎವಿಕ್ಷನ್ ಆಗಿದೆ.
ಅದೇ ಯಾವಾಗ? ರೆಂಟ್ ಎಷ್ಟು ಉಂಟು?
Rent 7,000.
7,000 ಕೊಡ್ತಾರೆ.
Arrears?
No arrears.
No arrears.
In fact, order is that they have to.
ಯಾವಾಗ ಬಿಡ್ತೀರಾ? ಯಾವಾಗ ವೇಕೇಟ್ ಮಾಡೋದು?
Last time, of course, this question was put to me.
Exactly. ಅವ್ರು ಇರ್ಲಿಲ್ಲ ಅವಾಗ.
ಅವ್ರು ಇರ್ಲಿಲ್ಲ. ಅವ್ರನ್ನ ಕೇಳೋಣ ಅಂದ್ರೆ ಬೆಳಗ್ಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ ನನಗೆ. My lord may grant 1.5 years. It's a shop premises doing business in Xerox, and that is the livelihood for that man. Therefore, keeping this in mind, I am making this request. I leave it to my lords.
ಅಂದ್ರೆ 18 months ಜಾಸ್ತಿ ಆಯ್ತು. ಎಷ್ಟು ದೇವ್? ನೀವು ಒಂದ್ ತಿಂಗಳು ಅನ್ಬೇಡಿ.
ನಾನು ಒಂದ್ ತಿಂಗಳಂತೆ ಹೇಳೋಣಂತ ಇದ್ದೆ.
ಅದೇ ಅದೇ ಹೇಳೋದು.
ಅಲ್ಲ ಒಂದ್ ನಿಮಿಷ 17 years ಇಂದ ಇದ್ದಾರೆ.
17 months.
ಅಲ್ಲ 17 petitioner number 1 is married. Petitioner number 2 is unmarried.
Unmarried go Xerox shop.
Father is an ex-service man. ಬೇರೆ ಯಾವ್ದಿಲ್ಲ ಬಿಸ್ನೆಸ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳಿ 17 ವರ್ಷದಿಂದ ಆಲ್ರೆಡಿ ಇದಾರೆ ಅವರು. ಆಮೇಲೆ ಅವ್ರು ಜೆರಾಕ್ಸ್ ಶಾಪ್ ಓಪನ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಅದು ಬಂದೇ ಇದೆ. ಅವ್ರು ಏನ್ ಬಿಸ್ನೆಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ. ಮತ್ತೆ ಫಾರ್ my lord,
no photocopy.
Business ಮಾಡ್ತಾ ಇದ್ರೆ why should I pay the rents and all that, my lord? And the order is that.
ಎಲ್ಲಿ ಇದು?
ಮಲ್ಲೇಶ್ವರಂ.
ಮತ್ತೆ you need not do business there.
You need not do business there.
ಮಲ್ಲೇಶ್ವರದಲ್ಲಿ.
Yes sir. ಯಾವಾಗ 1.5 ವರ್ಷ ಜಾಸ್ತಿ ಆಯ್ತು.
Up to the end of the next year. My lord may say it
9 months ಒಂದು affidavit ಹಾಕಿಸ್ತೇನೆ, ಆಮೇಲೆ ಎಲ್ಲ ಕ್ಲೋಸ್ ಆಗ್ಬಿಡುತ್ತೆ ಇಲ್ಲ.
9 months ಹೇಳಿದ್ರೆ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಮೇಕ್ 6 months ಮಾಡು. ಅಲ್ಲ ನಾನು ಬಿಸ್ನೆಸ್ ಮಾಡೋ ಅಲ್ಲ
ಅವ್ರು 18 ಅಂದ್ರು, ಅರ್ಧಕ್ಕೆ ಕಳಿಸಿದ್ದೀನಿ.
6 ತಿಂಗಳು ಮಾಡು.
3 ತಿಂಗಳು ಕಳಿಯೋದೇ ಗೊತ್ತಾಗಲ್ಲ.
ರೆಂಟ್ ಅಂದ್ರೆ ರೆಂಟ್ at least ರೆಂಟ್ ಆದ್ರೆ ಏನೇ ಸಾಕು 7,000 ಕೊಡ್ತಾ ಇದ್ದಾರೆ ಮಲ್ಲೇಶ್ವರಂ.
ಅಲ್ಲ
ಏನ್ ಡೈಮೆನ್ಷನ್?
According to order itself
11 by 15 feet.
11 by 15 ಸ್ವಲ್ಪ ದೊಡ್ಡದೆ.
11 by 15 is a bigger one ಅಂತ ಅಂತ.
ಮಲ್ಲೇಶ್ವರ ಮಾರ್ಗಸೂರ್ ರೋಡ್ ಅಲ್ಲಿ.
Order is
10,000 ಮಾಡಲ್ಲ.
In addition to 7,000 which I am paying now, order said I had to pay damages also at the rate of ₹2,000.
And 12,000 order is 2,000 ಕೊಟ್ಟಿದ್ದಾರೆ.
ಈಗ ಒಂದು ಕೆಲಸ ಮಾಡಿ.
Order is quite vague, I know.
ಅಲ್ಲ, forget about the order. You pay 10,000 for the remaining 9 months. Remaining 9 months, you pay 10,000, vacate in 9 months, file an affidavit here, we'll record it and close the suit itself.
ಅಲ್ಲ suit
ಕ್ಲೋಸ್ ಆಗಿದೆ.
ಸರಿ ಬಿಡಿ, ಮತ್ತೆ ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡ್ಬೇಡ.
My lord may make one request instead of
11,000 ಕಟ್ತೀರಾ?
9 months.
12 months and 10,000 worships, please.
1 year ನಾನು ಕೇಳ್ತೇನೆ.
9 ತಿಂಗಳು ಸಾಕು. ಅದ್ರಲ್ಲಿ ಏನು ಇದಿಲ್ಲ. No bargain in that.
2,000 ಕಡಿಮೆ ಮಾಡಿ. At least
9 months. Yes ದೇವಿ.
We will pay 10,000 at least.
ಆಮೇಲೆ ನೀವು ಬಿಸ್ನೆಸ್ ಎಲ್ಲ ಪ್ಲಾನ್ ಮಾಡ್ಕೊಳ್ಳಿ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ. 9 months
ಮಾಡ್ಬೇಕು, ನನಗೆ ಬೇರೆ ಇನ್ಕಮ್ ಇಲ್ಲ. ನಾನು
ನೀವು ಪ್ಲಾನ್ ಶುರು ಮಾಡಿ. ಈಗ 9 ತಿಂಗಳಾಗುತ್ತೆ ಪ್ಲಾನ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡೋಷ್ಟು.
ನೋಟಿಸ್ ಅಲ್ಲ ನೋಟಿಸ್ 2022 ಅಲ್ಲಿ ಒಂದ್ಸತಿ ನೋಟಿಸ್
ಆಗಿದ್ದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ ಸರ್.
ಅವ್ರು ರಿಪ್ಲೈನೇ ಕೊಡ್ಲಿಲ್ಲ. 2000
ನೀವು ಆಗಿದ್ದು ಬಿಟ್ಬಿಡಿ, ಇವಾಗಿಂದ ಹೇಳಿ.
There are some technical points, but they are not
technical points.
Trial court ಅಲ್ಲಿ ಅರ್ಜಿ ಮಾಡಿಲ್ಲ. Therefore, I am not in a position to submit that. Otherwise, the question of jurisdiction is also there because having regard to the measurement.
ಈಗ ಈ ಕೋರ್ಟ್ jurisdiction ಇದೆ ಅಲ್ವಾ? ಸೊ ಇಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡಿ. ಅಲ್ಲ ಇಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡಬೇಡ ಇಲ್ಲ.
ಆಗ್ಬೋದು.
ಯಾವಾಗ ಹಾಕ್ತೀರಾ ಅಫಿಡವಿಟ್?
My lord, 9,000 my lord may make it somehow.
9 months 9,000. damages 2000 ಕೊಟ್ಟರೆ ಸರಿ ಹೋಗುತ್ತದು.
ಅಲ್ಲಿ ಸರಿ ಹೋಗುತ್ತೆ 7
ಡ್ಯಾಮೇಜಸ್ ನಾವು ಕೇಳಿದ್ದು 12,000 ಕೊಟ್ಟದ್ದು 2,000. ಇನ್ಫ್ಯಾಕ್ಟ್ ನಾನು ಅಪೀಲ್ ಹಾಕ್ಬೇಕಿತ್ತು. 12,000 ಕೇಳಿದ್ದೆ.
ಈಗ ಆಯ್ತು. ಈಗ that will end every litigation. ಈಗ ನಾನು ವಾಪಸ್ ರಿಮೈಂಡ್ ಮಾಡಿದ್ರೆ
ರಿಮಾಂಡ್ ಮಾಡೋ ಕೇಸ್ ಇಲ್ಲ ಇದು.
ಅಲ್ಲ ಏನೋ
ಆಯ್ತು ಸ್ವಾಮಿ ತಮ್ಮ ಬಿಟ್ಟು.
ಅಫಿಡವಿಟ್ ಹಾಕಿ I'll take it on Friday, file an affidavit.
10,000 rate.
10,000. No 9.
9,000 and 9 months, my lord.
No 10,000 and 9 months.
As it is more, my lord, that's the reason.
Photocopy, Malleshwaram. Yes.
Next Friday, my lord.
ಒಂದು ವಾರ ಬೇಕಾ?
ಹೌದು ಮತ್ತೆ ಒಂದು ಕಳಿಸಿ.
ಆಯ್ತು next Friday 11th.
Please.
ಏನು ರೆಕಾರ್ಡ್ ಮಾಡಲ್ಲ, but I won't forget. Don't worry. Yes.
Interim order is there, it may kindly be.
Interim order subsisting will continue to the next date of hearing. ಏನಿದೆ ಲಿಸ್ಟ್ ನಂಬರ್ 2? ಹೌದಾ, ನೋಡಿಲ್ಲ ಮೇಡಮ್. ಅಯ್ಯೋ ಯಾವ್ದು ನೋಡಿಲ್ಲ ಇನ್ನು. List number 2 cases will repeat day after tomorrow.
List 1, B group matters, 60.
Yes.
Your petition.
60 melon.
ಅಲ್ಲ, further hearing matters ಇಲ್ಲ. ಒಂದು ಮಂದಿ ಸರ್
Further hearing matters.
But in this case, the petitioners are office bearers of a society, my lord, president, secretary, treasurer and all. They're all father, son, wife and daughter, my lord. They're all family members. They are the office bearers of the society, which runs about 17 educational society, my lord, institutions in Sulia. Undisputedly, my learned friend cannot dispute that we are the office bearers of the society, which are running 17 institutions. My lord, it so happened that my brother at one point of time was the secretary of the society. My lord, he ceased to be, then AGMs were held, all other office bearers have been elected from time to time, my lord.
Yes.
My lord, what happened is the society is being run by the newly appointed office bearers, which even the Honorable Supreme Court has observed. I can take your lordship, they can't dispute it, in his own SLP. He was, my lord, arrested in a matter for having committed the murder of our registrar. This Honorable Court sentenced him to life imprisonment, my lord, on 5th. I'll read the complaint. 6th, we office bearers have gone to our own institution. His contention is, during one point of time, there was an agreement entered into where management of the institution, my lord, society cannot be partitioned like a joint family property, my lord. It is a society, you can't partition as if it is a joint family. There was some understanding that I will manage some institution, you will manage some institution, is his case, my lord, which, my lord, in the plaint filed by him, he says no such, he himself admits, no such MOU and so was acted upon, which your lordships will get, my lord, at page number 60 of that paper book. Para 22. I'll just read for your lordship's reference, even need not have to even para 22, my lord. Plaint, our Hakiro plaint. Number of suits are going on, my lord. Litigation before the party.
Plaint, complaint ಹೋಗ್ಬಿಡಿ straight up.
One, very well, very well. Complaint given. Kindly, my lord, take page 39. Complaint given. This complaint, my lord, is filed by Jyoti R. Prasad.
Who is that?
She is the wife of my brother, my sister-in-law, who was the secretary. Means not the person who was convicted by this court, his wife. And she writes there, police came and took my husband and went away. These people killed them. But I was in complaint.
Now,
it not
one more clarification. Now, who are the accused?
President, secretary, treasurer, vice president of the society.
Correct. President, secretary, vice president On the date of the complaint, you
Yes,
were,
yes, even much before till today. there-
you are all office bearers,
Yes, yes,
elected
surely.
office bearers.
No doubt about it.
Yes.
And that, my lord, that's why I said, even the Supreme Court decision, I can just read out where they have clearly said, we are the office bearers and he was once upon a time a secretary.
All right, now.
My status, my lord, they are thinking it is a partition suit, that something like that MOU it's trying to say. Kindly
No, one
turn to
moment.
page number 30.
Now, 1 minute. Complaint, I saw the complaint, FIR.
FIR, my lord, is on top.
Page.
My lord, page 31. That's all. That's all is the FIR.
One moment, sir, 1 moment.
Same complaint, my lord, they say in the FIR.
So 448, 506, 34.
All right. FIR. The question, my lord, in fact, if I have to commit a trespass, it has to be somebody else's property.
Now, Supreme Court judgments.
Supreme Court.
Yes.
Page 748. 778. 748. ನೀವೇ ಕಾಪಿ ಕೊಡ್ರಿ ಅದು ಯಾಕೆ ಅಂಡ್ ಕಾಪಿ 748. And also a judgment by this honorable court, my lord, by the
Justice Srinivas Harish Kumar.
No, that is conviction, convicted him for murder, my lord.
Yes.
Justice Sachin Magdum ಅವರದೊಂದಿದೆ.
748, apex court's order.
My lord, page number 748. Your lordship's got, my lord?
Yes.
Supreme, can I pass on here?
Ile, 748.
ಆಯ್ತು. This is filed by him, Renuka Prasad.
Correct. Adralli ಏನು
Complainant's husband. ಈಗ this
We are
order is.
sanguine that the dispute in question will be stands.
Let us come to the next page, my lord, 749. Petitioner and the first, your lordships get that, man.
Our real brothers were as responded.
Real brothers ಅನ್ನೋಕ್ಕಿಂತ natural brothers would have been a, whereas respondent number 2 to 6 are family members of respondent, close relatives of the above stated society runs 17 educational. So kindly note, we are running 17 educational institution, including the technical college, whatever it is, where I have supposed to have committed the trespass.
Which is Justice Magdum's order.
Justice Magdum's order, my lord, your lordships will get at page 697, where he says, my lord, that we are all the president and this thing, that your lordships will get at page 746. Page 49. Trial court had told us that we should not conduct a meetings at all, like your lordships will get at page 746, page 49. Bande. Page 49. Or if these significant are looked into, then it would find that the first defendant, who is the president, that is myself, first petitioner before your lordships. Other defendants are found to be governing and power to govern the meetings. My lord, this is undisputed, my lord. That we are even today, that time, and he never even contested for the AGM, my lord. That also your lordships will get, that he never even contested, and that your lordships will get at page number. Office bearers, we were elected, my lord, your lordships will get it at page 31. Page 30, para 31. When we were elected. And he did not even contest for the election, para 31.
Yes.
Let me read that, my lord. IR number 25, the plaintiff sought. He sought, my lord, plaintiff was my learned friend's client's husband. He filed annual general meeting itself should not be held on 4/3/2022 the injunction kelidro.
Yes.
That no, under the said meeting, annual report was presented and so and so. Under resolution number 5, budget, under resolution number 6, is important. The members were unanimously elected as first defendant, as the president, defendant number 4, as these are all petitioners 1 to 4. And we continued, my lord, and we are continuing to run. Even this AGM, we all have been elected. Now let us come to
charge sheet hakidara. Charge sheet is filed.
Illa.
FIR ಅಷ್ಟೇ. Stay ಇದೆ.
ಹೌದು, stay ಇದೆ. Now let me take your lordships to the complaint which your lordships have.
Yes, sir. Yes, sir.
Not so far as the statements made by the learned senior counsel, to the effect that there is no dispute relating to the petitioners before your lordship. No, let me, because since he has made those submissions, it is my duty to bring out before your lordship, what is the correct state of affairs. The contention that there is no dispute about the petitioners being office bearers is not completely correct, because so far as petition number 1 and 2 are concerned, there is no dispute. that they are the president and secretary, vice president. So far as other members are concerned, in OS 12 of 2021, which has been filed, wherein there was an order of injunction granted by the trial court, which was subsequently modified by this honorable court, which I have produced. I have produced the order copy recently along with my additional objections. On 24/10/2024, in WP number 29473 of 2023 and connected matters, including the MFAs filed by the petitioners before this honorable court. But this honorable court has made certain observations. I have produced those documents also. Now coming to the complaint that is filed, kindly see the complaint. The contention that I am nobody and they are the office bearers, they have a right to enter into the premises and all that. That is patently incorrect for one simple reason. Kindly see the written statement filed by the petitioners in the suit which has been filed, wherein they have categorically, page 98 of the paper book. Kindly go to the page.
Yes.
I will just only state few facts. I will not take much of your lordship's time.
Yes.
Page 98 of the first volume.
90?
98, in page 98. Lordship got it.
Yes, sir.
Your lordship got it. Para 10. Accordingly, on 2/9/2008, your lordship gets it. The governing body of Academy of Liberal Education so and so convened a meeting. In the said meeting, all the above directors were present. In the said meeting, after discussions, a resolution was passed to form 2 executive committees, both under the chairmanship of Dr. Kurinji so and so. And these 2 committees are named as Committee A and Committee B. Coming down for the mirror. Committee A is consisting of Dr. Kurinji Venkatramana Gowda, he is no more. Dr. Chidananda, who is the present chairman of Group A committee. Then Group B committee, Kurinji Venkatramana Gowda was the chairman. And Dr. Renuka Prasad is the present chairman of the committee. And then kindly come down further. Under the terms of the same meeting dated so and so, the governing body also allotted the following institutions for its management by Committee A. That is, these are the institutions which are given exclusively to Committee A. Then next page, page 99. The following are the institutions allotted to the management of Committee B. That is, one of the institutions is number 3, KVG Polytechnic. Committee B consists of Dr. Renuka Prasad, who is the chairman, Dr. Jyoti Prasad, who is the complainant before in the trial before the police, and your lordship may kindly see what is specifically stated in the written statement is, kindly see para 15, para 14 and 15. The defendant further submits that it was also decided in the meeting dated 2/9/2008 that the respective A and B committees shall open independent bank accounts to be joint operated by the respective chairman and vice chairman jointly. The founder president shall also transfer a sum of rupees 7.74, etc., etc. Now, thereafter, down below, plaintiff number 3, being the head of the Committee B, has been running and managing the institutions allotted to him. This is what the resolution said. I have produced a copy of the resolution also along with my objections. But what had happened was this, after the conviction on 5/9/2008, conviction had happened on 27/9/2008. On 5/10/2008, sentence was imposed. On 6/10/2008, we have been managing the institutions as per the resolutions dated 2/9/2008 and 23/3/2009, as admitted by the plaintiffs themselves. We are in exclusive management. And the document which you have produced, along with the objection statement, that is 2/9/2008, specifically says these committees should manage these respective institutions exclusively, including banking operations. That is being done. In fact, he himself has admitted in the letter which he has addressed. Kindly see the objections which you have filed. 2 minutes. Objection.
Page.
1 minute. First objection, sir. Illegal. In the objections that were filed on 9/9/2024, let's kindly go to document number 2. Page 17, 17.
Line 625.
On 9/9/2024, first objections. Your Lordship, document.
Page.
Page 17,
Hmm.
document number 2.
Hmm.
This is a letter addressed by petitioner number 1 to Dr. Renuka Prasad.
This is the person in, this is the person who is convicted?
He was convicted and the Honorable Supreme Court has set aside the judgment of this Honorable Court and he has acquitted him. I have produced that judgment also along with the additional.
Acquitted when?
On 6/5/2025. I produced the judgment.
6/5/25.
Yes.
Not on the date of the complaint.
No, not on the date of the complaint. I don't, I'm not saying so. What I'm saying is the fact that he was convicted is no more a factual situation because he has been acquitted.
Then the crime so registered should be no more.
Yes.
Yes.
So in that background,
Yes,
he's-
sir.
I'm not disputing.
yes.
Yes.
But
I'm not
unfortunately,
superior
what
to
happens
Supreme
is,
Court.
unfortunately, what happens is, despite the Honorable Supreme Court judgment acquitting my client, the learned senior counsel is not acquitting my client. That is what is happening. In every time.
That's all right.
That's what I am submitting.
See, if all would be ending well
I
if
understand.
this crime was not there. Simple.
No, I'm only drawing your lordships to para 17, page 17. Kindly go to second paragraph in the letter.
Hmm.
It is a fact born out from the undisputed resolution of 29/2008 that even during the lifetime of our esteemed founder president for smooth continuation of the several education institutions founded by him, the institutions which you desire to take over were made over to you. Ever since 2008-2009, you have been exclusively managing all such institutions, which include the dental college and engineering college.
No, there's no qualm about this.
what
They
I'm
don't dispute
submitting-
this communication.
What they are disputing is, their case is, I am nobody. That's what they say in the petition.
ಅದು nobody ಬೇರೆ ಕಡೆ agitate ಮಾಡ್ಕೊಳ್ಳಿ.
No, what I am saying is.
Nobody, somebody
No, no.
will.
No, what I am,
Other-
kindly
other
see the
places.
averments of the complaint. What is stated in the complaint? In the complaint, this is what is stated. As per the resolution dated 29/2008, we have been managing these institutions, including Polytechnic Institute. So I am in management of the institutions as on that day.
No problems.
So question is, they come here
Hmm.
on the basis of some resolution which they don't even disclose
Whatever
to
it is,
anybody.
some Allah, there is a resolution.
That-
They are
no,
office bearers.
No, no.
They are
Let-
entering
let-
into
no.
their office.
What I am
Where is the
submitting-
question
no,
of trespass?
What I am submitting is this, Miller. In view of the
ಈಗ ನೀವು
resolution,
ಅಕ್ವಿಟ್ ಆಗಿದ್ದೀರಲ್ಲ ಆರಾಮಾಗಿ.
not only that,
ಇದೆಲ್ಲ ಯಾಕೆ?
not only that, forget about that. Apart from those aspects, I am not bothered about that. But what I am saying is this, Miller. Ultimately, this is the situation. Miller, 29/2008 resolution was passed. On 5/10/2008, they passed a resolution. In the civil
So
suit,
is this the same judgment by the apex court where 161 statement was the foundation for conviction?
no. How's
Prosecution evidence was taken into consideration.
Yes.
161 statement
That is the
was
judgment.
taken as foundation for conviction.
Conviction,
And
that's
it is
correct.
set
That is
aside.
the judgment.
It is rightly set aside.
That is the judgment. But what I am submitting is,
161 cannot be the foundation. for
that is how it has happened.
Witnesses became
Only,
hostile.
not only that, only based on prosecution witnesses evidence, the conviction has been ordered. That is what has happened.
But
But apart from
could
those,
not have been done, yes.
apart from that aspect, what I am submitting is this. 29/2008 resolution is an undisputed resolution. Number one. On 5/10/2008, they claim to have passed the
No,
resolution.
ನೀವು civil
It took
ಏನಾರು
minutes.
ಮಾಡ್ಕೊಳ್ಳಿ.
2 minutes I will just submit it.
Yes.
5/10/2008, they passed a resolution. But after coming to know of it, in the civil suit which was pending, we filed an application for stay of that resolution, dated 5/10/2008 resolution. That was allowed by the learned senior civil judge. By its
5/10?
5/10/2008 resolution, by virtue of which they
When
came.
was it, injunction ಯಾವಾಗ grant ಆಗಿದ್ದು?
ಯಾವುದು?
Civils, ಅದೇ resolution stay
21
ಮಾಡಿದ್ದು ಯಾವಾಗ?
12/2008.
20?
1/12/2008. It was stayed. I have referred to everything, in my, this one, in fact, I
No,
produced
that's
the
all right.
documents also. What had happened was this, that order passed by the senior civil judge was challenged by the petitioners before your lordship, before this honorable court in WP number 474 of 2023. That read petition, along with another read petition filed by them.
Was allowed.
Well, no, it was disposed of. I have produced that order. The lordship may kindly see the order, which I have produced additional, Justice Krishna Kumar's order.
Sir, that is all right. As on the date of registration of the complaint,
My only submission is-
6/10/2023, they were also the office bearers.
They
of
were
the-
office bear, not all of them.
What office
According
bearers?
to us, Miller.
Office bearers.
No, according to
Supreme Court observes that they were office
No, no,
bearers.
Supreme, before
I
the
will
honorable-
not go beyond what the
Before
Supreme
the
Court has
honorable
observed.
Supreme Court, your lordship may kindly see the order for a minute. What had happened?
Now
was-
you had an axe to grind, you are convicted, conviction is set aside, you are now acquitted.
Not have any axe to grind. Somebody else had an axe to grind against me.
This is all right. Now,
Convicted and I've been.
whoever
fortunately-
had the access to grind have all, the axes have
is
become
this,
so blunt that it can't be ground again.
My
So
only
we will
submission
close
is-
this now.
My only submission is this, that your lordship may say, if at all, if your lordship want to quash the proceedings. If your lordship wants to quash the proceedings, let there not be any observations relating to their status as the office bearers or not. in
I
this
will not
order.
do, I will not say anything like
Yes,
that.
that's
I will order here itself. 5 minutes, I will finish dictation.
Yes, Mr.
Yes. Anything else?
No, that's it, my lord, because there is, after all, it's a quashing, it's a criminal petition. There is no question.
The petitioner.
Only one thing, if at all, if I shouldn't be not necessary, plaint na lavre ಹೇಳಿದ್ದಾರೆ, we have not acted upon.
ನಾನು plaint ಬಗ್ಗೆ
ಬೇಡವೇ ಬೇಡ,
ಹೋಗೋದು-
that's it. I didn't want to disturb
I
the
will
court.
go by the plain language of
Of the complaint.
house trespass.
That's it.
In the written.
It's not house trespass, it should have been 447. Act.
447, that was a mistake. That was a
448 is a mistake, yes. The petitioner accused 1 to 7 are at the doors of this court calling in question registration of a crime in crime number 115 of 2023, registered for offences punishable under section 448, 506 read with 34 of the IPC. Heard the learned senior counsel Anant Mandage appearing for the petitioner and the learned counsel Madhusudan Rao representing the complainant and the learned counsel for the state. The facts in brief germane are as follows. Sans details, facts in brief are as follows. The second respondent is the complainant, wife of one Dr. Renuka Prasad. It transpires Dr. Renuka Prasad along with the petitioners Renuka Prasad was the director, is it? What is it? Secretary of the institutions run.
His status, whether he is secretary or not, is still a matter in dispute.
Last alone observations made will not come in the way of anything.
Was andre
So illa andre
ಅಲ್ಲ was ಅಂದ್ರೆ
a
ಏನಾಗುತ್ತೆ?
was is get into last all ಹಾಕ್ತೀನಿ ಅಲ್ಲ. Yes. The second respondent, one Dr. Renuka Prasad is claims to be the secretary of the which society, which is this? Academy. AOLE.
Of learning.
Hello.
Liberal education, Academy of Liberal Education.
Academy of Liberal Education.
That is the name of
Which
the society.
which runs about 17 institutions of various disciplines in Mangalore, in Dakshina Kannada, in Dakshina Kannada district. Yes. The issue in the list relates to an incident that takes place on 26/10/2023. On 6/10/2023, the wife of Renuka Prasad, the second respondent, registers a complaint before the jurisdictional police alleging that the accused here in 1 to 7 have entered into the premises unauthorizedly and have criminally intimidated the complainant. This becomes a crime in crime number 115 of 2023, registered for offences punishable under section 448, 506 read with 34 of the IPC. The registration of the crime is what has driven these petitioners to this court in the subject petition. This court, by its order dated so and so, interdicts the proceedings and stays further investigation in the matter. Pursuant to investigation in the matter, the learned senior counsel appearing for the petitioner would take this court through the documents appended to the petitions, to the petition, to demonstrate that as on the date, the petitioners also were office bearers of the ALO. So, and had a right to enter into the institution to which they were office bearers elected pursuant to certain resolution. The complaint therefore cannot mean that they cannot enter into their own office or premises as the case would be. He would submit that the offences so alleged against these petitioners spring out of certain civil proceedings which are pending before the concerned courts between the parties. He would therefore seek quashment of the same. Per contra, the learned counsel Madhusudan Rao representing the complainant would dispute the claim of the petitioners that they are office bearers, as several Civil proceedings are pending between the parties on the said cause of action. He would submit that the husband of the complainant did get convicted or was convicted as on the date of registration of the complaint, but the conviction has been set aside by the apex court and is now acquitted of the offences. He would submit that the matter is still at the stage of investigation and further proceedings must be permitted to be continued as there are various disputed questions of fact in the case at hand. He would seek dismissal of the petition. The learned HCGP representing the state would also toe the lines of the learned counsel appearing for the complainant Shri Madhusudan Rao in seeking dismissal of the petition. I have given my source. The afore narrated facts are not in dispute. The link in the chain of events is what is narrated here in above. The entire issue gets triggered from registration of the complaint. Therefore, I deem it appropriate to notice the complaint page 39 to 41. The complaint is that the petitioners accused have trespassed into the property, trespassed into the institution, trespassed into the office of the institution on 6/10/2023 and criminally intimidated the complainant. Therefore, the offence would spring. The learned counsel, as submitted by the learned senior counsel for the petitioner, the matter between the two with regard to who is the secretary of the institution or office bearers had reached the apex court. The apex court in its order dated 9/1/2023 observes as follows, page 749, 750. The apex court observes, whereas the other family members' relatives are to perform the duties of general secretary, the petitioner used to perform the duties of general secretary and the other family members' relatives are also office bearers and members of the society. Unfortunately, dispute has arisen between them. Prior to the said, what was challenged there?
Was His Lordship Justice Magdum's order, my lord.
The apex court was observing, the apex court observed as quoted here in above, in a SLP preferred against the order passed by the coordinate bench in WP 11177 of 2022, disposed on 4th November 2022. The coordinate bench had observed as follows.
Para 7 of the order,
Page
739 onwards.
May make one
Ashton
submission.
Beda.
May make
739
one
last
before that.
sentence.
Before that, I want to make only one
Hey, why,
submission.
sir?
The Honorable Supreme Court, while disposing of the special leave petition, kindly see the para 7 in the.
I am not going into that. I am only quoting it. That's
No,
all.
that particular
The
order has
page-
been diluted by the Honorable Supreme
Page
Court in para
48,
7.
one ನಿಮಿಷ sir. Page 48 and 49 quote ಮಾಡಿ.
Para 7 also. kindly.
I have felt it appropriate to quote the judgment of the apex court and the coordinate bench only to observe that there are several disputes that are civil in nature between the protagonists of the crime. The issue now would be whether the petitioners are guilty of offense under section 448. 448 is wrongly alleged. It ought to have been section 447 of the IPC. Section 447 of the IPC reads as follows. Section 447 deals with criminal trespass. The ingredients of section 447 are found in section 441. If the ingredients of section, if what is found in 441 is pitted to the contents of the complaint, what would unmistakably emerge is that the petitioners are now being alleged of criminally trespassing into their own office, or which they claim to be their own office, as the case would be. But a trespass will be by the accused over the victim's property and not the accused again their own property. Therefore, the ingredients of section 441 for it to become an offense under section 447 for criminal trespass is not even found in its semblance in the case at hand. What is the other offense is the one punishable under section 506 of the IPC, which deals with criminal intimidation. Criminal intimidation as obtaining in 506 has its ingredients in 503 of the IPC. If section 503 is noticed, there is not even an iota of ingredient of what is necessary to be found in section 506 of the IPC. The apex court in the case of Muhammad Wajid versus so-and-so 2023 SCC Online SC page 951 has delineated as to what can become an offence under section 504 and 506 of the IPC while considering the purport of section 503. If the observations of the apex court or the elucidation of law of the apex court is considered where the complaint registered against the petitioners, the permitting further proceedings against them would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons allowed cost, it is made clear that the observations made in the course of the order is only for the purpose of consideration of the case of the petitioners, and 482 of the CRPC, it would not bind, influence any proceeding pending before any fora between the parties. Order declared.
Highly obliged. Highly obliged.
112.
It is more volume.
ಎಲ್ಲ ಕೇಸ್ಗಳಲ್ಲೂ 3 ವಾಲ್ಯೂಮ್ ಆಗ್ತಾರೆ. And all cases will have 3 volumes.
So 3 volume cases either.
All cases.
Become a fashion of the day, more or less.
Yes, sir.
My lord, this is a matter pertaining to that letter of apology. The letter is prepared, my lord.
Yav, sir?
112, my lord.
Settlement.
Yes, my lord.
Agidiya?
No, my lord. The letter is drafted due to some medical urgency. The
Medical
petitioner-
error?
Medical urgency, my lord. The petitioner could not be present.
Yavat? Friday?
Tuesday, my lord, Tuesday.
Next Tuesday?
Yes.
Next Tuesday, 2:30 PM.
Interim order may kindly be extended.
For reporting settlement, interim order subsisting will continue to the next.
Grateful, man.
113.
Next week. Next week.
Madam.
End out next week.
ಯಾಕೆ ಸರ್ ಇಲ್ವಾ?
Senior is ready in next matter.
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರ್ ಯಾವುದು? ಇಲ್ಲ ಇದಾರೆ.
ಅದಕ್ಕಿದ್ರಲ್ಲಿ ಬೇಡ.
ಆಯ್ತು. ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ, ಯಾವತ್ತು ರೆಡಿ ಇದ್ರೆ ಮಾಡಿ. ಹೀಗೆ ಒಂದೊಂದೇ ಮುಗಿಸೋಣ ಅಷ್ಟೇ.
Please. Interim order.
Then BDA fraud,
Yes, my lords. So far as the
Well,
government.
wanting to commit fraud.
Preparation. In the end of it, preparation, nothing which is fabricated. The allotment letters are genuine, no sale deeds that have taken place, property is with BDA.
ಅಲ್ಲ ಬಿಟ್ಟಿದ್ರೆ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ರಿ ಅಂತ.
ಹಾಗೆ ಬಿಟ್ಟಿದ್ರೆ, that is the whole case, my lords, whether for preparation.
ಅದೇ ಅಲ್ವಾ?
And my lords, and
creation to
public servants ಗೆ ಎಲ್ಲ quash ಆಯ್ತು.
ಅದು because of sanction.
And they did not even choose to prosecute it, my lords. They did not obtain sanction after that. And that has attained finality. Now these are private individuals. My lords, could I just give the gist of it?
I know everything. In the sense, I think 5th time I'm hearing it. Yes.
My lords, we have even given a chart segregating all the witnesses and the documents. My lords, in the.
Now he has to, ಈಗ ಒಂದು ಕ್ರೈಮ್ ಮಾಡ್ತಾರೆ ಅಂತ ಪ್ರಿವೆಂಟಿವ್ ಡಿಟೆನ್ಷನ್ ತರ ಆಯ್ತಿದೆ ಏನು?
ಇಲ್ಲ, ಅದು ಆ ತರ what has been done.
Why is the learned advocate general waiting?
119. I think Mr. Ashok Kannalli.
ಯಾವ್ದು?
My lord, this is a further hearing matter at 3:30.
ಇಲ್ಲ further hearing.
3:30, 119, my lord. My lord, this is the case where allotment was made, my lord, payment is not made within the.
2015.
Please, my lord.
5 ನಿಮಿಷ reach, sir.
Look, issue is that they create a document to show that the person has made the payment towards the allotment of a site. And my lord, they collect money from such individuals who are not entitled for an allotment of a site in order to give them a letter of allotment and allotment of a site. Such documents are created. Those created documents and the creation of those documents has taken place in the office of the accused number 1. Lord, the accused number 1 is also involved. There are statements to that effect that certain people who are, Lord, involved in this preparation and, Lord, allotment of the sites. Lord, those documents were seized.
These are accused
2, my lords.
Accused number 2 and?
My lords, there. 2, 3, 7, 9 and 21. Could I just give the synopsis, my lords? That will make it.
2, 3, 7, 9 and 21.
AG ಅವರೇ 5 o'clock ತಗೊಂತೀನಿ ನಿಮ್ದು. You can sip coffee and come. Yes.
Through the synopsis.
You wait. Yes.
My lords, if the synopsis is once noticed, my lords, I think the points for consideration is also there. It will become easier for them also.
ಅಂದ್ರೆ ಈಗ ತಗೊಳ್ಳೋದು ಬೇಡವಾ?
ಅಲ್ಲ ಅಥವಾ ಅದನ್ನ ನೋಡ್ಬಿಟ್ರೆ ಸಾಕು my lords, because they can answer that easily. 10
Okay.
points I have pointed out.
ನೋಡ್ಬೇಕಾ? ನಾಳೆ.
Please.
ಯಾಕೆ ಮೇಡಮ್? ನಾಳೆ ಆಗುತ್ತಾ?
Not if possible, day after.
Day after, fine.
Please.
ನಾಳೆ ಎಲ್ಲ ನೋಡ್ಬಿಡಿ.
ನಾಳೆ
ನಾಳೆ ನೋಡ್ಕೊಳ್ಳಿ ಅಂದೆ. ನಾಳೆ BDA day you have to be here, so don't. Day after tomorrow.
Please.
ಅಷ್ಟೇ, I have heard them at length, twice, thrice. Now you should answer ಅಷ್ಟೇ.
Yes, I'll point out.
But crux is preparation of a document to be executed for a purported fraud, purported making money would become an offense or not.
Preparation of a document which is genuine, that is relevant. The
not-
allotment
not
letters
fabricated.
are genuine. It is not fabricated. On the
So
basis.
there is no report of fabrication.
No, my lords. No. The document, the allotment letters are genuine. After the allotment letters, next stage would have been sale deeds, which never happened. The allotment letters, according to them, are genuine, my lords. That is what is seized. No FSL report on the,
Not that. The
and my lords,
No,
is based on the BDA resolution.
1 minute. Do you mean to say the officers of the BDA, without their connivance, this would happen? Why you did not pursue the sanction matter? Why?
state.
To protect them.
No, it was not a BDA employee.
Correct, sir. State only. Where? State will never do. State is known for its won't. WONT. Yes. Anyway, ನಾಡಿದ್ದು ಮಾಡಿ, ತೊಂದರೆ ಇಲ್ಲ. ಅಷ್ಟೇ ಇದರಲ್ಲಿ ಇರೋದು. ಅಷ್ಟೇ ನೋಡಿ, ಅಷ್ಟಕ್ಕೆ ಅಂದ್ರೆ ನೋಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ. Genuine document prepared and kept it somewhere. That's it. It was kept somewhere, but documents are genuine. ಬಿಟ್ಟಿದ್ರೆ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ರು. ಆಗ್ಲಿಲ್ವಲ್ಲ. ಇದು 399, 402 ಅಲ್ಲ, ಪ್ರಿಪರೇಷನ್ ಫಾರ್ ಡಕಾಯಿಟಿ
To attempt to ಅಲ್ಲ, 511 ಅಲ್ಲ, preparation.
ಅಷ್ಟೇ. ನಿಮ್ದೇನು ಇದ್ರಲ್ಲೇ ಇದ್ದೀರಾ? ನೆಕ್ಸ್ಟ್
115.
Trap case. Case of a trap. She was not named in the.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ. She was not named in the FIR.
No one need not be named in the FIR.
She was not named, and trap was done, and the A1 was arrested. And after 2 days, they recorded another Panchanama, wherein the complainant said to have given an audio record where my voice is there. Based on that, they
FSL.
Then subsequently, my lords, now they have been exonerated by the departmental inquiry.
ಅಲ್ಟಿಮೇಟ್ಲಿ ಅಲ್ಲಿಗೆ ಬಂದಿದ್ದು.
Please.
ಅದು ಯಾವತ್ತೂ ಹಾಕಿದ್ದೀನಲ್ಲ, ಇವ್ರದೇ 4 ಇದೆ. ಕೊಡಿ. ಎಸ್, ಯುವರ್ ಕೊಲೀಗ್ ಯಾವತ್ತು ಹಾಕಿದ್ದು? 15/7, ಸೇಮ್ ಡೇ. 15/7. ಈ ಕಂಪೈಲೇಷನ್ ಅದರಲ್ಲೇ ಇಟ್ಬಿಡಿ ಮೇಡಮ್. ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಲ್ಲ, ಇನ್ನೊಂದ್ರಲ್ಲಿ ದಟ್ ಅಬ್ರಾಮ್ ಮ್ಯಾಟ್ರಲ್ಲಿ ಮುಗಿಸ್ಬಿಡ್ಬೇಕು ಇವಾಗ.
116.
7 or 13?
7, Lord, it is successful trap.
Successful?
Please. He had accepted 30,000 and demanded by accused number 2. And there was a conference call.
Color?
This tested positive.
Positive.
Please. And there was a conference call, Lord, in which this petitioner also demanded the bribe. I'll pass on the synopsis, Lord. It's covered by Lord's.
Kodi. Now I have written something.
Yes, Lord.
Covered by one of that Kodi.
Yes, 8776/25.
ಯಾವ್ದು ಮನೆ ಟೀಪಾಯಲ್ಲಿ 2 ಲಕ್ಷ ಇದ್ದಿದ್ದದ ಕೊಡಿ.
Order copy. I'll sir.
Number ಹೇಳಿದಿರಾ
ಇದರಲ್ಲಿ? 8776/25.
ಇದು ಫ್ರೈಡೆ ರಿಪೀಟ್ ಮಾಡಿ ಮೇಡಮ್. No representation by the petitioner list on Friday. Yes, Abraham.
117.
Synopsis ಹಾಕಿದ್ದೀರಾ?
Let's
ಕೊಡಿ.
synopsis, right?
ಕೊಡಿ.
Let's the The day before yesterday, Mr. Abraham has taken.
You're not well, ant.
I was
You're
not
okay now?
well. I'm well.
You're not well.
But my submission is, now the investigation is completed.
Charge sheet hakidira?
Charge sheet we are
Ready idya?
obtained, yes.
Where is charge sheet material?
No, I'll place it, no,
Place the
lordship
material.
permits, not, I'll place it. on
Place
it.
the that's necessary. I ಹೇಳಿ ಏನು ಅಂತ?
Please, members. Well, so basically, essentially, I am on 3 points on which I am assailing. Well, a private complaint was filed Amal with all the making out a case for all the offences even under the PMLA. Well, the court constituted under the PC Act will not have the jurisdiction to entertain the complaint insofar as the PMLA is concerned. On the other hand, well, the PMLA court has the power to entertain.
Eradu sessions court.
Well, no, it is a specially constituted.
I know.
Court.
Both are court of session.
Court of sessions. However, my lords, the special court, when it has no jurisdiction to entertain the complaint, should have exercised the power under section 202 instead of straight away referring the matter for investigation. My lords, may kindly see the section 202.
I'm aware, sir. No problem. 2006 amendment admit it is mandatory.
It's a mandatory. And my lords, it's covered by the decision of the apex court also, where the apex court says if the irregularity has been committed by without the returning the complaint, if the court which has no jurisdiction to entertain the complaint, that cannot be rectified or set right by the same court, which has to be done only under 482, only under 482 or 226 of the court. Whereas the PMLA, so far as the PMLA offences are concerned, the court had no jurisdiction at all. It could not have entertained the complaint. The complaint should have been returned.
Will quash PMLA offences. Will quash PMLA and retain the liberty to institute proceedings in accordance with law.
Whether
forget about PMLA.
Whether that will the set right the wrong committed by the.
No, 482, sir. I will set right everything. I will set right the wrongs committed by the court.
Please, my lord.
I will set aside PMLA. PMLA, it could not have taken or even referred the matter. Straight away, I will close that, reserve liberty for PMLA later, sustain all the offences under the Prevention of Corruption Act.
Now, the question of the quashing the PMLA is concerned may not come.
It was not referred in the PMLA. Just reference under 156. That's all.
All offense.
Offences are not.
Very reference.
Yes, ma'am.
Crime yaduk register madidira?
Only the PC Act.
PMLA and madilva?
No.
Yes, sir.
Let's say it's a pick and choose.
No pick and choose. Reference for investigation.
I am not for a moment on the ground that the police have committed a mistake. No.
Then who has committed?
No, it is the court has committed a mistake. It has
refer a model wala bidi PMLA.
It has the entire complaint has been as it is referred.
If crime had been registered under PMLA, you could have had a hue and cry.
My basic question about the argument is the court could not have even proceeded.
We'll remove that, sir.
Proceeded.
PMLA tagade bana.
Even irrespective of removing the PMLA, that will not inure to anybody's benefit because now they have not registered.
Then don't worry, why are you worried? It will not inure to your benefit.
That's why I am not going for a FIR stage. Now I am at the stage of referring the matter for investigation when the court has no jurisdiction at all. No jurisdiction at all. That could have been immediately returned to the complainant to present it before the appropriate court under section 202 of CRPC.
Don't worry.
Yes. Now, in that connection, that's one point. On that point, may kindly see the judgment of the apex court on this. 2-3 judgments I have enclosed along with my.
No problems.
Now, the second point.
Avasti. Judgment Avasti's case.
One is Devendra Dagalia. That is one judgment. The another judgment is in fact in this court, our High Court, when they wrongly exercised the jurisdiction and convicted a person, this court has allowed the appeal and directed it has to be presented before the court which has the competent jurisdiction. This I have compilation I have given along with my.
No problem. It's too rudimentary to say. Definitely yes.
Yes.
The court which has no jurisdiction cannot pass any orders.
Yes.
It becomes quorum non judice. But
please.
Illi refer agilla PMLA.
Well,
ಇವ್ರು ಎಲ್ಲ offense ಆಗ್ತಾರೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅವ್ರಿಗೆ ಏನ್ ಮನ್ಸಿಗೆ ಬಂದಿದೆ ಎಲ್ಲ ಹಾಕಿದ್ದಾರೆ. ಸೊ ಅದನ್ನ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ ಅಷ್ಟೇ ಅವರು.
My lords, may
ಏನ್
kindly
ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಅದ ಹೇಳಿ.
kindly see the order, my lords, for a moment.
ಅಲ್ಲಿದ್ಯಾ PMLA ಅಂತ?
My lords, may kindly see the order for.
Page, sir.
My lords, at page number 9. Page number 9. My lords, at page number 10, the complaint, regarding the complaint, the court has discussed what all the, for the offences for which the complaint has been filed. Then ultimately, my lords, I can understand if the court says the PMLA has no application to the case on hand, I am referring the matter.
ಅಯ್ಯೋ
only for-
ಒಂದ್ ಅಕ್ಷರನು ಬರ್ದಿಲ್ವಲ್ಲ PMLA ಬಗ್ಗೆ.
My lords, may kindly page number
10 ಅಲ್ಲಿ ಇವ್ರು ಏನ್ ಕೇಳಿದಾರೆ ಅದ್ ಹೇಳಿದಾರೆ ಅಷ್ಟೇ.
yes, my lords.
ಅದ್ರ ಬಗ್ಗೆ ಒಂದ್ ಅಕ್ಷರ ಬರ್ದಿಲ್ಲ.
ಯಾವ offense ಬಗ್ಗೆನೂ ಬರ್ದಿಲ್ಲ, as it is.
ಇಲ್ಲ ಬೇರೆ ಎಲ್ಲ ಬರ್ದಿದ್ದಾರೆ, ಬಟ್ ನಾಟ್ ಅಬೌಟ್ PMLA.
My lords, none of the offences, my lords, may kindly see. The court has not referred to any
Sir,
of the offences
It
alleged in the
has
complaint.
it has simply referred to the ACB,
Ultimately, the entire.
not to the enforcement directorate.
My lords, the complaint as it is entertained by the referred, my lords, the moment, my lords, your lordship may kindly see.
Any other ground, sir?
If I make a complaint before the magistrate court invoking the jurisdiction under the SC/ST Act, whether the SC/ST Act will have an application or not, whether the magistrate can proceed in one step ahead, he cannot.
ನಿಮ್ಗೆ ಯಾಕೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ PMLA ನ ಹಾಕಿದ್ರಿ?
He cannot.
Why do you want everything?
No, money laundering was there.
Was there?
The activity
It is
was
somewhere
there.
else.
The
Why do you want to bring
That's
in all this?
It's there. Activity was there. It's there.
ಅದಕ್ಕೆ ಇದು ಓವರ್ ಆಕ್ಟಿವಿಟಿ ಯಾಕೆ?
That's the point. I realized it little later.
That's what.
My lords, that's why my fundamental and primary submission is the court could not have entertained. It was for the complainant to take appropriate decisions thereafter. It is my first submission.
Next ground.
The second submission is, my lords, the Priyanka Srivastava's case. My lords, may kindly see the complaint. Complaint has been accompanied with verifying affidavit. Verifying affidavit.
ಎಲ್ಲಿದೆ?
My lords, may kindly page number 40. A verifying affidavit.
Where is the verifying affidavit?
Page number 40 of my petition.
Petition. Objections. Yes, sir.
It's a verifying affidavit.
Verifying affidavit. ಎಲ್ಲಿದೆ? affidavit ಅಂತಾನೆ ಇದೆ?
ಹೌದು, affidavit. It's verifying the contents of the complaint. It is only affidavit. That is absolutely nothing. Your lordship may kindly see the question of the purpose of filing the affidavit was only to make the complainant accountable in case if the court feels that there is a wrong declaration.
Will hold him accountable.
That has been made mandatory. My lords, that has been discussed, my lords. This court, my lords, His Lordship Justice Srinivas Harish Kumar Sahibar judgment.
ನೀವು ವೆರಿಫೈಯಿಂಗ್ ಅಫಿಡವಿಟ್ ಆಗಲ್ಲ, ಅಫಿಡವಿಟ್ ಆಗ್ಬೇಕು ಅಂತ ಹೇಳಿದಾರೆ ಅದರಲ್ಲಿ.
Reasoned affidavit in terms of the, my lords, the Oath Act. Oath Act. My lords, once again, this is a violation.
Next ground. Judgment Babu Venkatesh.
My lords.
Judgment Babu Venkatesh.
My lords, the case of
Priyanka Srivastava.
Priyanka Srivastava.
ಅದು ಹಳೇದಾಯ್ತು.
ಯಶವಂತ್ ಸಿನ್ಹಾ ಅವ್ರದ್ದು ಹಾಕಿ.
ಅಯ್ಯೋ ಅದು ತುಂಬಾ ಹಳೇದಾಯ್ತು.
ಸಾರಿ ಪ್ರಿಯಾಂಕಾ ಶ್ರೀವಾಸ್ತವ ಅಂಡ್ ತಮ್ಮದು
ಡಾಕ್ಟರ್
ಬಾಬು ವೆಂಕಟೇಶ್ ಸರ್. 2022 SEC ಆನ್ಲೈನ್ SC page 200.
ಸತ್ಯಸಾಯಿ ಸೆಂಟರ್ ಇದ್ರದ್ದು ಅದನ್ನು ಹಾಕಿದ್ವಿ. ಸತ್ಯಸಾಯಿ
ಗೊತ್ತಾಯ್ತು, ಅದು ಜಸ್ಟಿಸ್ ಹರೀಶ್ ಕುಮಾರ್ ಅವರು.
ಹರೀಶ್ ಕುಮಾರ್ ಆಯ್ತು. My lords, the third point on which I am harping upon is, my lords, whether the section 17A is required in this case or not. Section 17A.
It is now there.
No, my lords.
ಇದೆ ಅಂದ್ರೆ
Section 17A ಇಲ್ಲ.
17 order.
No.
17 order to register. 17A ಇದೆ ಅಂದ್ರಲ್ಲ.
17 order is there.
Not 17A.
No. Disproportion, the allegation of disproportionate.
13 ಇದೆ allegation.
Yes.
13 ಬೇಕಾಗಿಲ್ಲ. Yes. ಆಮೇಲೆ.
No, my lords. The allegation, your lordship may kindly see it. It's not only the 13E. Your lordship may kindly see the offenses.
Page.
My lords,
39.
Page number.
FIR ಎಲ್ಲಿದೆ?
20. Page number 20 is the FIR. Section 7, 8,
ಯಾರ್ ನೀವ್
9,
ಹಾಕಿರೋದು?
10,
Yes,
11,
Latif.
12,
ಏನ್ ನಂಬರ್ಸ್ 1 to 10, 7, 8, 9, 10, 11, 12.
15.
ಏನ್ ಹೆಂಗ್ ಹಾಕ್ಬೇಕು ಅಂತ
On the
7, 8, 9, 10, 11, 12, 13, 14.
on the complaints allegations they made.
What complaints
registered.
allegations?
No, my lords, may kindly see the, why I am saying.
Was this a trap or disproportionate assets?
Yavdu?
Idu case disproportionate.
Proportionate asset. We investigated in the line of this.
Now they are confining it for, according to them, it is only for 13E we are investigating. That's what they
13E.
say. But the FIR is amalgam of all the offences of the PC Act. Plus the 17A, why I am seeking for this, invoking section 17A. My lords, may kindly see the page number 26 at para number 8 of the, para number 8. That the said person have also brought to the knowledge of the complainant that the accused number 1, who was the land acquisition officer in BDA, being the in charge of the Nadaprabhu Kempegowda layout and Vishweshwara layout, HRBR layout, Jnanabharati layout, etc., had been allegedly collecting illegal gratification bribes from the owners persons relating to the files that come before her for consideration to pass the awards for the lands acquired for the approval of those files. And my lords, paragraph number 32, para 32. It is reliably learned that accused number 1, with the knowledge that the connivance of one deputy secretary of the BDA has allegedly sold large tract of the government lands in survey number so and so, measuring 150 acres in Bimankuppe of so and so, and allegedly created a bogus documents in favor of the various persons, and the accused number 1.
Where is the charge sheet material? Kodi?
This is what
investigation you have conducted?
Lordship is permits, Lord, I'll place it in next date.
Place it in a sealed cover only, no
Please,
problem,
please,
but place it.
Please.
32, na?
Yes.
I will see what angle they have investigated into.
Yes. And the last one, my lords, when I filed a petition, the statement of objection was filed. One of my averments was section 70, the 17 order is not there in the file.
Supreme Court now says not.
What they have done is, my lords, they did not controvert that my statement.
All judgments of the coordinate benches are reversed.
This is how the court has been, the judicial process has been misused.
Abused.
Or abused. Abused.
ಯಾವಾಗ ಕೊಡ್ತೀರಾ?
Next week you need.
Wednesday.
Please.
Next Wednesday.
Please.
Next Wednesday, 4:30. Produce the charge sheet material.
Please.
Please.
And FIR was registered in the year 2020 and petition was filed after 4 years of registration.
What is the stage? But investigation 3 ವರ್ಷದಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಿ ನೀವು?
Lord, I explained my filing in affidavit.
Produce ಮಾಡಿ ಅಂತ ಹೇಳಿ.
Please, Thursday.
Yes. Thursday.
Please.
18.
ಕಾಂಪೌಂಡಿಂಗ್ ಆಫ್ ಅಫೆನ್ಸಸ್ ತಾವು ಕನ್ವಿನ್ಸ್ ಆಗಿ ಮದುವೆ ಮಾಡಕ್ಕೆ ರಿಜಿಸ್ಟರ್ ಮ್ಯಾರೇಜ್ ಮಾಡ್ಕೊಂಡ್ ಬರಕ್ ಹೇಳಿದ್ವಿ. ಮ್ಯಾರೇಜ್ ಇಲ್ಲಿ
16 ವರ್ಷ.
ಇಲ್ಲ 16
16
16 years 6 months. ಮಗು 2.5 years ಮೇಲೆ ಅದೇ
ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದ್ರ? ಜಸ್ಟಿಸ್ ಓಕ್ ಅವ್ರದೇ ನೋಡಿದ್ರಲ್ಲ.
ಮದುವೆ ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ ಹೇಳಿದ್ವಿ, ಮಾಡ್ಕೊಂಡು ಬಂದ್ವಿ. ರೀಚ್ ಆಗ್ಲಿಲ್ಲ 3-4 ಡೇಟ್.
ಏನ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ರೀಚ್ ಆಗ್ಲಿಲ್ವಾ?
ಅಲ್ಲ ಅದಾಯ್ತು ಕೋರ್ಟ್ ಅಲ್ಲಿ.
ಕೋರ್ಟ್ ಅಲ್ಲ
ಇಲ್ಲಿ 4-5 ಸಲ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ. ಕೊನೆಗೆ ನಾನು ಸಬ್ಮಿಷನ್.
ಪರವಾಗಿಲ್ಲ, ಈಗ ಎಲ್ಲಿ ಕಸ್ಟಡಿಲಿ ಇದ್ದೀರಾ?
ಇಲ್ಲ,
ಸ್ಟೇ ಇದೆ ತಾನೆ? ಹಾ, ಮತ್ತೆ ಇರಿ. ಎಲ್ಲ ಹೈಕೋರ್ಟ್ಸ್ ಎಗನೆಸ್ಟ್ ಬರೀತಾ ಇದೆ. 16 ವರ್ಷ ಸೆಟಲ್ ಮಾಡಲ್ಲ.
ಅಲ್ಲ ಈಗ ಶಿ ಇಸ್ ಅಟ್ ಮೇಂಟೆನೆನ್ಸ್. ಅಲ್ಲ
ಈಗಲ್ಲ ಸರ್, ಡೇಟ್ ಆಫ್ ದಿ ಇನ್ಸಿಡೆಂಟ್.
ಶಿ ಇಸ್ ನಾಟ್ ಅಗ್ರೀಡ್ ಪಾರ್ಟಿ. ಡಾಕ್ಟರ್ ಚೆಕ್ ಮಾಡ್ಸಕ್ ಹೋದಾಗ ಡಾಕ್ಟರ್
ಯಾವಾಗ್ಲೂ ಹಂಗೆ ಆಗೋದು. ಪ್ರೆಗ್ನೆನ್ಸಿ ಟೆಸ್ಟ್ ಹೋದಾಗ್ಲೇ ಗೊತ್ತಾಗೋದು ಏಜ್ ಏನು ಅಂತ. ಬರ್ಲಿ ಒಂದು ಲಿಸ್ಟ್ ಆನ್ 25th. Entry order subsisting will continue to the next date. Thursday. 4:30.
19.
ಎಲ್ಲಿ ಏಜ್ ಅವರು ಕಾಫಿಗೆ ಹೋದ್ರು ಬರಲೇ ಇಲ್ಲ? ಏನದು? ಹಾ, ಮಾಡ್ಬಿಡಿ. ಇನ್ನು ಕಾಫಿ ಕುಡಿತಾ ಇದ್ದಾರಾ?
ಇಲ್ಲ, ಇದು ಚೇಂಬರ್ ಕಮ್ಮಿ.
ಎಸ್ ಸರ್, ನೀವು ಸ್ಟಾರ್ಟ್ ಮಾಡಿ.
Blood, I given a list of days.
He was allotted, petitioner was allotted about 3 acres of land. And initially we made a deposit of total amount to be deposited was 5 crores. We paid about initially 1 crore, then 30 lakhs was paid. By that time, the government issued a notification fixing the lease period instead of 10 years to 99 years.
Correct.
So thereafter, well, after some time, the government again restored it back. In the meanwhile, on 23/5/2015, allotment was cancelled and we filed the writ petition. In the writ petition, the interim order was passed, allowing us to make the payment. Pursuant to that, we made a payment of 2 crores. By that time, the KDB said that because your case is
ಎಷ್ಟು ಎಕರೆ ಇದು?
3 acres.
3 acres.
KDB said when the case is pending, we cannot consider your request. So we withdrew the petition.
ಗೊತ್ತಾಯ್ತು,
back.
ಆಮೇಲೆ ನಾನೇ ರೆಸ್ಟೋರ್ ಮಾಡಿದೆ.
Then we paid another entire amount totally more than
ಈಗ ಎಷ್ಟು ಪೇ ಮಾಡಿದ್ದೀರಾ?
ಎಲ್ಲ pay ಮಾಡ್ಬಿಟ್ಟಿದ್ವಿ.
ಎಲ್ಲ ಅಂದ್ರೆ?
Full amount, whatever they demanded, more than that we have paid.
ಹೌದಾ? ಮತ್ತೆ ಏನು BB Patil was saying nothing is paid?
The Lordship may kindly see, my lords, allotment is of the year 2013. Payment is made recently. After appreciation, when the matter is pending, they have made the payment.
Recently ಅಲ್ಲ, 2022 is not very recent.
3 ವರ್ಷ.
24, my lords. I think
22 now listed.
We have returned the money in 2024 also.
List of dates ಕೊಟ್ಟಿದ್ದೀನಿ ನೋಡಿ.
ಎಲ್ಲಿದೆ? ವಾಪಸ್ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Please, my lords, in 2024. The Lordship, there are two basic matters. Is covered by your Lordship judgment.
ಕಮಲಾಲಯ.
Please, my lords.
Yes.
Which totally covers this issue, my lords.
ಅದೇ ತಾನೆ ಕಮಲಾಲಯ.
Please, my lords, and one more judgment, my lords. Following imperial. The question is interpretation of clause 6, my lords. Within, if the amount is not paid, my lords, it automatically stands cancelled is the legal position. 2013 admittedly.
ಮುಗಿಸ್ಬಿಡಿ ಸೀನಿಯರ್.
I'm sorry.
ಅಷ್ಟೇನಾ ಸರ್?
ಅದರಲ್ಲಿ Justice Veerappa in identical circumstance.
ಕೊಡಿ.
Now the judgment which my learned friend is referring is on a different circumstance. They say they challenge the
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಏನು
condition.
ಪೇಮೆಂಟ್ ಮಾಡಿರಲಿಲ್ಲ.
Yes, no payment was made and they challenge the condition which says that it will be cancelled. In this case, my lord, we could not make the payment because the government itself altered this period of lease. That is why we could not make. An interim order was made. Pursuant to that, they received the payment. Not that, my lord, somebody went and made the payment. Everything they have acknowledged in the records. Joint Director Ruju ಇದೆ. After taking entire amount, they said, no, because the court has said we will return the money. Then your lordship said, I have never said something. Then
ಅದಕ್ಕೆ I have observed that return the money.
and then we have paid it back. Now the total amount, entire amount has been paid. Now we filed the writ petition on the understanding because they said we cannot consider it when a writ petition, but we withdrew it and went back and made that another 2 crores has been paid. So having regard to this, my lord,
ಈಗ ಪ್ರೆಸೆಂಟ್ ಮಾರ್ಕೆಟ್ ವ್ಯಾಲ್ಯೂ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು?
No, my lord, they paid the amount was as in 2013.
What is the present market value?
My lords, they are not calculated the current. What 5 crores 4 lakhs was in 2013. Admittedly, my lords, my learned friend says he has paid it in 2022 was 4 lakh 68. That means 90% of the money is paid nearly after 11 years.
11 years.
he'll pay reasonable interest
No,
for the period.
Question is, then if that
Here, ultimately, industry needs to be established.
Let them.
This is not a case where they are doing a commercial transaction.
ಅಲ್ಲ ಅಲಾಟ್ಮೆಂಟ್ ನೀಡ್ ನಾಟ್ ಬಿ ಎಸ್ಟಾಬ್ಲಿಷ್ಡ್. ಇಂಡಸ್ಟ್ರಿ ಈಗ ಅಲಾಟ್ಮೆಂಟ್ ಎಸ್ಟಾಬ್ಲಿಷ್ ಆಗ್ತಾ ಇದೆ 10 ವರ್ಷ. ಎಸ್.
So therefore, the writ petition interim order. So therefore, interpretation of clause 6, which your lordship has already
these
done.
two judgments.
These two judgments.
ಅಲ್ಲ ಇದು ಡಿವಿಷನ್ ಬೆಂಚ್ ಅಲ್ಲಿ ಏನಾಯ್ತು?
Confirm, my lords.
ಎಲ್ಲಿದೆ ಇದು?
That's the division bench judgment.
No, this my order, sir.
They withdrew. They went on writ appeal and withdrew the writ appeal. I will place that before your lordship. I will place that. By end of another 10 minutes, we'll place it before your lordship.
Yes.
Lord, this identical circumstance.
That Ganapati Enterprises. That is Veerappa ಅವರದು.
Ganapati. The identical circumstance.
ಅಲ್ಲೂ ಲೀಸ್ ಚೇಂಜ್ ಮಾಡಿ 99 ಇಂದ 10 ಮಾಡಿದ್ರು, 10 ಇಂದ 99 ಮಾಡಿದ್ರು.
That is a totally different issue.
No, that's this Veerappa is on the identical footing. Whether that is applicable or not, we'll see. ಅದೊಂದು ಆರ್ಡರ್ ಕೊಟ್ಬಿಡಿ ಡಿವಿಷನ್.
We'll give it right away.
ಅಷ್ಟೇ ಅಲ್ಲ ಸರ್?
ಈ ಕಾಂಟ್ರಾಕ್ಚುಯಲ್ ಮ್ಯಾಟರ್ ಅಂದ್ರೆ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ
ಕೊಡಿ
ಸೆಂಟ್ರಿ
ಸರ್.
ಪವರ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್.
ಸುಮ್ಮನೆ ಇರೋದೇ ಇಲ್ವಲ್ಲ ಅಭಿನಯ.
82 on. Para 82.
ಸಾಕಾ? 200 ಪ್ಯಾರಾ ಜಡ್ಜ್ಮೆಂಟ್.
ಅದು ಬೇಡ, para 82 ಒಂದ್ ನೋಡಿದ್ರು ಸಾಕು.
We may call out the conclusions.
Yes, yes. Writ jurisdiction is a public law, a matter which lies entirely within a private realm of affairs and may not lend itself for being dealt with under writ jurisdiction. The principle laid down in Bareilly development that in the case of a non-statutory contract, right, bound only by the terms of the contract, decisions which are perpetrated, including Radhakrishna Agarwal, may not continue to hold good in the light of what has been said in ABL and followed in the recent judgment. So the mere fact that relief is sought under a contract which is not statutory will not entitle the respondent state in a case by itself to ward off scrutiny of its action or inaction under the contract. If the complaining party is able to establish that the action is per se arbitrary. This entire thing, Lord, has been summarized in relation to the contract.
Yes, sir.
This para.
If we had not cancelled it, it would have been arbitrary.
In original records, Lord, this signature is found. Their signature in accepting the amount is found at page.
ಅವ್ರು RTGS ಮಾಡಿದ ನಮ್ಮ ಅಕೌಂಟಿಗೆ. We have returned the money.
RTGS.
RTGS.
ಅಲ್ಲ ಅದು ವಾಪಸ್.
No, RTGS. Your Lordship may kindly see. They sent a RTGS.
RTGS ಅಲ್ಲಿ acceptance ಏನಿಲ್ಲ.
DDD 1 RTGS which you have paid it back.
Yes, sir. We'll consider. Heard reserved.
Grateful.
ನಾವು ಇದೆಯಾ ಕೊಡಿ.
230 mood matter. Order number 1. Siddharaju S.
Madam. Friday ಗೆ Siddharaj.
For the petition matters.
Really, sir.
My Lordship, in the present case, a commercial execution has been filed based on a commercial OS, which is decreed in favor of the respondent. My Lordship, subsequently on the OS, we had filed, we had approached this honorable court in a commercial appeal, appeal number 500 of 22.
What happened?
Which was settled in Lok Adalat, my Lordship. In that, settled, my Lordship, for the amount of 1 crore 40 lakhs that was to be paid to the respondents by the petitioners, my Lordship, within 6 months from the date of order.
You have not paid?
My Lordship, we had delayed the payment, but if my Lordship can kindly come to page number 48, my Lordship. We have filed a memo of calculation. In that, the entire principal amount of 1 crore 40 lakhs has been realized, my Lordship.
Entire decree amount ಕೊಟ್ಟಿದ್ದೀರಾ?
Decree amount.
ಮತ್ತೆ
Now the matter is, the proclamation is issued for the default interest, my Lordship.
Correct. ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
My Lordship.
ಎಷ್ಟಿದೆ ಇಂಟ್ರೆಸ್ಟ್?
43 lakhs, my Lordship.
ಎಷ್ಟು ಡೆಪಾಸಿಟ್ ಮಾಡ್ತೀರಾ?
My Lordship, 20%, my Lordship.
ಸರ್ಫೇಸ್ ಅಲ್ಲ ಸರ್ ಇದು. Judgment.
My Lordship, I need some time. I have already paid almost 1 crore 40 lakhs, my Lordship.
That's you bound to pay, sir. ಮೆಹರ್ಬಾನಿ ಮಾಡ್ದಂಗೆ ಹೇಳಿ, sir.
But I need some time, my Lordship.
Yes. You need some time, but
my Lordship, I am ready to pay 10 lakhs, my Lordship. My Lordship. Humbly, my Lordship, I am really tight right now. I'm
really tight. Andre
to arrange funds, my Lordship.
Funds.
Till 10 lakhs I can arrange within 3 weeks, my Lordship. Please, my Lordship.
10 ಇಲ್ಲ 15 lakhs.
My Lordship.
I will grant you 4 weeks time.
12, my Lordship.
12 weeks, sir.
12 lakhs, my Lordship.
12 lakhs. Yes. You appear to be tight. 12 lakhs. Yes. The petitioner is before this court calling in question an order of the concerned court dated 5/8/2024.
Yes, my Lordship.
ಇಲ್ಲಿವರೆಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
They recently approached us for this.
ಇವಾಗ ಗೊತ್ತಾಯ್ತಾ ಎಫೆಕ್ಟ್ ಆರ್ಡರ್ದು?
We were paying and then they were postponing the proclamation.
All right. Before this court on a proclamation issued by the concerned court on default of payment of interest by the petitioner. They learned there shall be an interim order of stay of further proceedings of the order and further proceedings before the concerned court, subject to the petitioner depositing 12 lakhs before this court in the next 4 weeks. List the matter on 4th August.
Deeply grateful. My lordship, may the order be delivered by hand, my lordship.
By hand.
The matter is still pending in the commercial court.
Pending ಅಲ್ಲಿ ಓಡ್ ಬಂದಿದ್ದೀರಾ ಇಲ್ಲಿ?
Your date ಕೊಟ್ಟಿಲ್ಲ my lordship. Kept by.
ಆಯ್ತು ಹೇಳಿ ಅಲ್ಲಿ. ಎಸ್ ಮೆಮೊ ಕೊಡಿ.
I will furnish.
Number 2, Vyas Kiran.
This is that matter, my lord, where High Court has, my lord, 5 orders. They have held the time they own another property. Property itself, my lord, was acquired for me. Please look at, my lord, page 29. Notification, my lord, we have been running a factory. Please come to, my lord, page 29. Mysore's third line. Mysore stone pipeware and pipes and potteries. Petitioner.
ಏನಾಗಿದೆ ಸರ್ ಈಗ? What has happened now?
Now, my lord, if your lordship recollects, day before yesterday, my lord, this similar matter had come up.
Yes.
He, my lord, gave, my lord, 28 crores to somebody. Now 60 crores, my lord, the other properties.
Yes, the 28 crores distribute ಮಾಡಿದಿದ್ರಲ್ಲ.
ಅದರಲ್ಲಿ same
out of 130 crores 102 was remaining.
ಇದರಲ್ಲಿ ಇದು 60 crores ಇದ್ದು same, my lord, there are 5 orders of
ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ already.
ಇಲ್ಲ, ಅದಕ್ಕೆ ನಾವೊಂದು interim order ಕೇಳ್ತಾ ಇದ್ದೀವಿ.
Yes. ಅದು ಯಾರು ಅಪಿಯರ್ ಆದ್ರಲ್ಲ ಅವತ್ತು?
ಅಶೋಕ್ ನಾಯ್ಕ್, my lord.
Ashok, learned counsel Ashok Naik is directed to accept notice. ಅಲ್ಲ ಇವ್ರಿಗೆ Ravishankar had appeared for the respondent.
ಅಲ್ಲ, ರವಿಶಂಕರ್ senior counsel ಅಲ್ಲ.
Senior counsel advocate
For the
beneficiary, that's what. Yes.
ಅದು ಬೇರೆ ಪಾರ್ಟಿ ಸ್ವಾಮಿ.
ಪಾರ್ಟಿ ಬೇರೆ, ಬಟ್ 28 ಕೋಟಿ ಅವರ ಅಕೌಂಟ್ ಇತ್ತು.
ಅದು ಹೌದು, ಬಟ್ ಇಲ್ಲಿ ಅವ್ರು ಇಲ್ಲ ಇದರಲ್ಲಿ.
The petitioner
ಅಂತ ಹೇಳಿ
heard the learned senior counsel Shri Uday Holla appearing for the petitioner, AG HCGP 1 to
Ashok Patil, sir.
Ashok Naik.
Ashok Naik.
To Ashok Naik. Rail infrastructure yaru?
I will give them.
Emergent notice to the remaining respondents returnable by the 25th. The amount of compensation, if not dispersed as on today, shall not be dispersed till the next date of hearing to any of the beneficiaries.
Please.
Yes. And delivery bill.
Saturday we had filed that other writ petition. Monday morning ಇಲ್ಲಿ ಬರುತ್ತೆ.
ಗೊತ್ತಾಗಿದೆ.
Number 3, Shri Ranjan Kumar.
Anjay. Yes, Ranjan.
Lord, IA for production of documents and my lord, IA for recalling the evidence. I number
1817.
18
ಏನು?
is rejected on the ground, my lord, that there were several suggestions were made, my lord, during the course of the cross examination to DW1.
ಆಯ್ತು, ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಹಾಕಿದ್ರಿ recalling?
Recalling, my lord, at the time after the
ಎಷ್ಟು ಸರ್ತಿ opportunity ತಗೊಂಡಿದ್ದೀರಾ?
first time.
First time?
My lord, what happened is, my lord, after closing of my evidence, DW1's evidence, my lord.
Petitioner to serve on the counsel representing the plaintiff before the concerned court and file an acknowledgement. List the matter on acknowledgement by 8th. List the matter on 23rd. There shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing.
Yes.
Pastor matter. Till number 14.
In this case, not
Where were you, madam?
morning.
ಈಗೆಲ್ಲ DRT ನಾ? ಹೈಕೋರ್ಟ್ ಬಿಟ್ಬಿಟ್ಟಿದ್ದೀರಾ?
DRT this. Lord, I had to make
ಅವ್ರು
payment.
ಇರ್ಬೇಕಲ್ಲ, ಅವ್ರ ಅದು ಮಾಡಿಫಿಕೇಶನ್ ಗೆ.
Was directed by this.
ಬೆಳಗ್ಗೆ ನೀವಿರ್ಲಿಲ್ಲ, ಅವರಿದ್ರು.
Redelivery ಕೊಟ್ಟಿದ್ದ ಸ್ವಾಮಿ. Regularization ಕೇಳಿದ್ದೆ.
ನೀವೊಂದು ಅಫಿಡವಿಟ್ ಹಾಕ್ಬೇಕಾಗಿತ್ತು ಅಷ್ಟೇ. ಎಲ್ಲಿದೆ? ಅವ್ರು ಕಾಪಿ ಕೊಟ್ಟಿಲ್ವಂತಲ್ಲ? ಕೊಡಿ ಅವ್ರಿಗೆ ಕಾಪಿ. ಈಗಿಲ್ಲ ಬಿಡಿ, ಬೆಳಗ್ಗೆ ಕಮ್ ಆನ್ ಫ್ರೈಡೆ.
Please.
38 ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ?
My apology, Lord, I was missing.
You are missing. Found at 5:15. Difficult.
Lord, this is that injunction regarding the car.
Innova.
Innova.
He said you are traveling in the Innova and coming, ಅದಕ್ಕೆ ಸುಮ್ಮನೆ. Temple property ಆಗೋಯ್ತಾ Innova?
Lord, it is all the property, Lord, which was purchased by Lord, the father, Lord.
We'll decide it, sir. We have better things to do other than Innova car. Yes. List on 23rd. You are here?
I'm here.
Yes.
Obliged.
Now, big group matters, all on 23rd.
One request.
Entry models will continue. ಯಾವ್ದ್ರಲ್ಲೂ ಇಲ್ಲ, ಎಲ್ಲದರಲ್ಲೂ continue ಆಗುತ್ತೆ.
Serial number.
Nandu,
One minute. Just one moment. This B group matters which are all of 2012-14. This LABDA. 60 in the 15. One minute. 1574 up to 76 will come on Tuesday. At the top.
Please. Let's let them.
Sir, VC, one nimsha. I'll get back. Yes. See, no problem. It come on Tuesday. B group will be at the top. So we'll go on disposing them. All old matters. All right. Thursday. Tuesday there is the Twitter matter. It will take the whole day. Yes. Thursday, B group will come at the top. We'll post it on Thursday. Entry model will continue. 77 to ನಾಡಪ್ರಭು ಕೆಂಪೇಗೌಡ ಎಲ್ಲ ಅವತ್ತೇ ಹಾಕಿರೋಣ. Objection ಹಾಕ್ಬೇಕಾ? No, from 77 to 94. We'll take it on 10th, 17th.
In that mode, one request I wanted.
77 to 17th.
May I make one request? At 86, Lord, you directed me to keep at 80 ready. I have
80?
kept it 8.
For what? Yeah, the weight. We're talking of LAPD. 85 and 86 weight.
Other side is here. 86.
GMCPC weights. I'm only talking of except 85, 86. Madam, mute body, madam. 1 minute, sir. 85, 86, I'm not. 85 and 86 bit to all other matters from 77 to 94 on 17th. All right. Interlocutory applications, wherever vacating stay applications are there, they are on the 16th.
107 maybe.
16th, entry models will continue, don't worry. They are on the 16th.
Serial number 93, my lord, needs to be accepted.
107 for
107 also.
But it's for extension of an entry.
Perola.
Yes, 108 also.
GM police wait, sir. Other wait. I'm only talking of GMCPC. ಅದೇ 16ಕ್ಕೆ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಲ್ಲ. ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? Yes. List on 16th ಇರೋದು. Yes. Let the trial court be any day. Only 16th. Yes. Only 16th. Yes. No problem. Even then, 16th. 1 minute. ಏನ್ 98? ಪರವಾಗಿಲ್ಲ, ಅದು 16th. Yes.
Serial number 93, my lord.
Sir, 1 ನಿಮಿಷ. VC, I'll come. Yes. What else remains? 110, what is this?
0. I'm offering for
110. Urgency ಇದೆಯಾ?
25 years old matter, that's why.
21 ಸರ್, 4 ವರ್ಷ ಓಲ್ಡ್ ಅಷ್ಟೇ. ನೀವೆಲ್ಲ ಹಳೇದೆಲ್ಲ ತೆಗಿಬೇಡಿ ಈಗ. ಎಸ್, ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಸೇಮ್ ಯಾವತ್ತು ಮೇಡಮ್? 17th. 17th. So 18th.
Millards, one submission, Millards. Millards, pertaining to, my lordship has had my matter serial number 68 on 10th, Millards. I filed an application, my lords, for just for
68.
68.
ಏನದು?
For that's 2014 matter, my lord, that is for
No,
determination.
68 is 2016 matter.
63, I'm sorry.
2014, Farah Fatima.
Sorry, my lords. My lords, I request for Monday, my lords, only because my application I filed, my lords, I've just filed an application for spot inspection. If it happens, my lords, if there's an order.
No, I've told it will come on 10th. 10th ಅಂತ ಹೇಳಿದೀನಿ. 8th go 10th go ಏನು difference?
No, my lords,
10th,
if
yes.
there's an inspection done, it can
You
come up
tell
on
me,
Thursday. my
holiday
lords.
is on Monday or Sunday? It's on Monday ಅಂತಲ್ಲ. State government is going to declare it on Monday, I'm told, I don't know.
Please.
Appears to be not. Appears to be Monday, I think would be declared.
So ಅದಕ್ಕೆ 8th and 8th ಬದಲು 10th, nothing.
Please, so can I take my chance tomorrow, my lords, only for consideration of application?
No. ಆಮೇಲೆ ನಾನೇ ತಗೋಬೇಕು ಇದನ್ನ ಕೇಳಿದ್ರೆ.
Let's let them file.
Nothing on that day, 10th.
My lords, if there's any objections, if any, let them
10th,
file.
madam.
No, my lords, let there be a direction. Let them file objections. by
Nothing
them.
I'm going to pass now except 10th, yes.
No, my lords, for filing
10th only.
objections, ಅವ್ರಿಗೆ my lords.
ಅದು ಮಾಡ್ತಾರೆ ಬಿಡಿ ಬೇಕಾದ್ರೆ, yes.
103, my lords.
ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಹೇಳ್ಬೇಡಿ.
103.
Wait sir, 103 ಏನು?
9th, my lords.
103 ಏನು?
Receiver application.
GMCPC.
Yes, 103.
GMCPC will come, not on 9th. This is 11th.
11th, my lords.
11th, yes. ಈಗ one ನಿಮಿಷ. One minute. Now take this 85 ಏನು? Party in person. Wait, 84 party in person. Is 84 party in person? Why are you making a mention when the advocate is there? He needs your assistance to make a mention? Then go and sit back. Yes, sir. You can't talk, is it? You're making your client make a mention. What is this? Come forward. Wait.
The other side has the right time to close the road. Therefore, I filed.
The urgency ಇದೆ ಅಂತ ಹೇಳಿ ಮತ್ತೆ. Why should he tell? 84 list on Wednesday 9th. Then 85. Is there, is it? We'll take it on 9th. List on 9th in preliminary hearing. Mele Bharat. Then 86, Vasant Kumar.
Lord, in 86, my lord, 86. On the last occasion, my lord, I have handed over 20 lakhs rupees check, my lord. No, 15 lakhs. I had promised, my lord, after kindly see the order. Therefore, my lord.
ಎಷ್ಟಿದೆ ಕೈಯಲ್ಲಿ?
15 lakhs ಇದೆ.
Respondent ಯಾರು? ಈ ಕಡೆ ಬನ್ನಿ, ಜಾಗ ಬಿಡಿ.
My lords, the interest amount due is much more than this.
How much more than this?
About 9 lakhs more than this.
ಅಷ್ಟೇ ಅಲ್ವಾ? ಈಗ 15 ತಗೊಳ್ಳಿ. The land senior counsel, SP Kulkarni hands over a demand draft of rupees 15 lakhs to the respondent. The same is the receipt of which is acknowledged.
Please, my lords.
Another 6 lakhs, I think, remains, my lord.
We'll see. List the matter on 16th.
Interim
Please.
order.
Interim order
My
subsisting.
lords, the interim order was not extended on the
Now,
previous.
because of this, I will extend.
Okay.
Interim order subsisting will continue to the next date of hearing. Yes, 86 ಆಯ್ತಾ? Next GMCPC ಯಾವುದು?
103, my lords.
103.
Lord, I am sorry, 82, my lords.
89 sir, serial number.
One ನಿಮಿಷ, I'll get back, sir. Yes. 103 ಏನು?
Receiver application, my lord.
ಅಯ್ಯೋ ಎಲ್ಲ ಅವತ್ತೇ 16th ಬರುತ್ತೆ. Wait, yes.
11th.
ಯಾವತ್ತು ಹೇಳಿದ್? 16th ಯಾವತ್ತು ಮೇಡಮ್?
11th.
11th, yes. ಇನ್ನೊಂದ್ಸರಿ ಮೆನ್ಷನ್ ಮಾಡಿದ್ರೆ 18th ಹೋಗ್ಬಿಡುತ್ತೆ, ಮಾಡಬೇಡಿ.
89.
Yes, one, sir.
My lord, 82, my lords. Is a case where land acquisition petitions have been allowed, quashing the notification.
Correct, 10th ಹಾಕಿದ್ದೀನಿ ಸರ್. 10th or 17th ಬರುತ್ತೆ, ಎರಡರಲ್ಲಿ ಒಂದಿನ. Because old ಎಲ್ಲ 10th ಹಾಕಿದ್ದೀನಿ. These B group matters on 10th.
Division bench also allowed.
10th and 17th, B group will come at the top, so we'll close it, yes. 80? ಏನು 89? ಹಾಕಿದೆಯಲ್ಲ 17th ಗೆ. Yes.
Serial number
83, my lord.
62 ನಾ?
housing board matter, even the petition.
This 10th, yes.
Lord, 83.
ಅವತ್ತು ಹೇಳಿ ಯಾರನ್ನ. I can't disturb it, yes.
Serial number 108, my lord. Extension of parole, your honor. Tomorrow itself, yes.
I'll take it. Extension of parole, both I'll take, wait. Bahir
Lord, serial number 83.
Our name is not shown in the list.
ಎಲ್ಲಾ ಡೇಟ್ಸ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಸರ್, ಅದನ್ನ ಚೇಂಜ್ ಮಾಡಲ್ಲ ಯಾವ್ದನ್ನು. ಎಸ್, ಅವತ್ತೇನಾದ್ರು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಮಾಡಿ.
My lord, 88 ನಮ್ಮ ಹೆಸರು ತೋರಿಸಿಲ್ಲ ಸ್ವಾಮಿ. ಪ್ರದೀಪ್ ಕುಮಾರ್.
88 ಅಲ್ಲ. ಯಾರಿಗೆ? PV ಚಂದ್ರಶೇಖರ್ ಇಲ್ವಾ?
ಇಲ್ಲ.
ಸಂತೋಷ್ ನಾಗರಳ್ಳಿ ಇಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ. HL ಪ್ರದೀಪ್ ಕುಮಾರ್
Registry to print the name of HL Pradeep Kumar in place of PV Chandrasekhar as appearing for respondent 2 to 4. Yes.
Lord, your lordship, leave 83, my lord. I have filed an IA for seeking a salary for having worked, my lord. They have not paid.
Service matter.
ಹೌದು ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಡಿಸೇಬಲ್ ಆಗಿದ್ದೆ, ಅದಕ್ಕೆ ತಮ್ಮ ಮುಂದೆ ಬಂತು.
Who appears for the petition? Respondent ಯಾರು?
ಬಾಳಿಗರ್.
83.
He is out of employment and no payment has been paid either too.
The service matter is special or list on Friday.
Publish.
Friday in preliminary hearing.
Publish.
Yes.
Let second list, 10th matter.
Second list, all day after tomorrow. Entire list.
Madam. Serial number 108, parole extension.
Parole, extension of parole.
Tomorrow is the last day of his parole.
Go back to the call.
He got married, your honor.
Got married?
Yes.
Why?
Based on that ground only, a parole is granted, your honor. And the
for getting married, granted parole.
Yes, sir. 60 days now.
You got married.
Yes.
How long you want to stay out now?
Advisory board has recommended is for premature release, your honor. 14 days is completed. More 30 days I am seeking for.
You got married now, and how old are you?
35 years.
So 21 you went in prison. Offense ಏನು?
302.
6 times he has taken parole, 7 times.
ಮಾಡಿದಿರಲ್ಲ? ಮಾಡಿದ್ಮೇಲೆ ಮುಗೀತು.
30 days.
60 days. ಮತ್ತೆ ಬನ್ನಿ. ನಿಮ್ದೇನು ಅದು ಇಂಟರಿಮ್ ಬೇಲ್ ಕ್ಯಾಟ್ರಾಕ್ಟ್?
Number 7 and 8, lordship. Just last.
Yes, Rahul.
Yes.
Cataract ಆಗೋಗಿದೆ.
ಆಗೋಗಿದೆ.
ಮತ್ತೇನು 30 days.
Again,
only two, human, only 2 eyes.
Now
then third eye ಯಾವ cataract?
We are very kind, the order of this honorable court. Just say, because very difficult to get some order in this matter. For that reason, only one son is there, 2 sons died by the accident. For that is some lordship. I just leave it on this honorable court. I prayed for 30 days. I leave it on this honorable court.
ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ, 2 ಸಾರಿ ಕೊಟ್ಟಿದ್ದೀನಿ.
The last, as even I undertake, I will not come for again. For
एक अंक, 2 अंक, तीसरी अंक का.
एक दिल भी है ना lordship.
Oh, दिल.
For mother's दिल lordship at least. Some
दिल के साथ.
Para number 7 and 8 is only on the imminent aspect. Because mother, 2 sons already lost. He's the only son is from past 3 years already spent in a jail. For that reason lordship.
दिल का मामला.
For mother, not for other. That is the problem. No, the conditions lord she is obliging. Every 3 days is going. Every three days in a week is going. There is no complaint in that aspect.
Yes, Rahul.
Lords, the problem is by virtue of this court order. Today, my lords, in a coordinate bench has dismissed it, asking them to go before division bench, citing the same order in spite of your lordship observation. In the trial court, they are saying
what is happening
that see,
my
the
learned friend has made an attempt. The coordinator has conceded. What my
yes, we have my lords
that
gracefully
already something is done.
considered for the operation, not for follow-ups.
Something is done, lordship. For that reason, I am requesting for as a mother, just few days, lordship. At least 15 days. Lordship.
2 days, 2 times I have given you. 60 days ಆಗಿದೆ. Now you go before the division bench and ask anything.
Lordship, that is appeal. We have already bail. We have filed it.
In the appeal, you ask anything.
Then we will take it.
My jurisdiction is over.
Kindly 2 weeks. 2 weeks. That's it.
My jurisdiction is over.
My humble request, Lord. 2 weeks.
This is not correct. You say division. You have Sunil Dutt Yadav reject ಮಾಡಿದ್ದಾರೆ.
That is there is no order passed. That said, appeal bail is pending because the bail was rejected. Kindly appreciate. Bail was rejected. Then he has not preferred appeal. For that reason, court has said the appeal you prefer. That is the only lordship. There is judgment of Bombay High Court. Bail rejected. Writ petition jurisdiction is there for the court.
ಅದಕ್ಕೆ 2 ಸಾರಿ ಕೊಟ್ಟಿದ್ದೀನಲ್ಲಪ್ಪ.
Just 2 weeks, lordship. My humble because she is 60-year-old lady.
She was discharged on 19th
only
of June.
one
Already 11 days have
just
been
I am request this honorable court. I leave it on this honorable court with the hope
I'm sorry,
lordship will consider it.
No, they have filed bail application before the trial court later.
We will certainly will try, Lordship, just only because very difficult to get it all this.
We'll take it day after tomorrow, we'll see.
Lordship, fourth is the last date, Lordship, for that reason.
Day after tomorrow is 4th.
I
Don't
will
worry.
be in Jaipur High Court, Lordship, on that day. Kindly
Appear
have it tomorrow.
Jaipur High Court, appear
Thanks,
online, yes. 4th I'll take, ನಾಳೆಗೆ ಆಗಲ್ಲ ಇಲ್ದೆ ನಾಳೆ
2:30, Lordship.
ನಾಳೆ ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಬೆಳಿಗ್ಗೆ ಮೂವ್ ಮಾಡಿ, we'll see, get Prasanna Kumar, we'll see.
Please.
Ask or secure some instruction and come.
But if there is no deviation in the conditions, he followed that, diligently he has followed that.
ಎರಡ್ ಸರಿ ಆಯ್ತು. How long can you?
For that reason, myself is mentioned there in para number 8, we will not come again for the extension. I am also I understand.
Last time
what is
also
the
it was the
limitation
same
of this
guarantee
honorable
given.
That's why I said, ek ank, do ank, teesri ank kahan hai?
And that's why I requested this court. There is also the heart of mother. She also expects few days to be spent with the son.
All right, we'll see, we'll take it. 2:30 move ಮಾಡಿ ಬೆಳಗ್ಗೆ. We'll get it.
May I seek my lord's indulgence, my lord?
Yes, sir.
Lord, we are living without street lights in the colony.
ಎಲ್ಲ ಲೈಟ್ ಇದೆ? ಲೈಟ್ ಎಲ್ಲ ಕಾಣ್ತಾ ಇದೆ?
ಇಲ್ಲ, ಇದು ಸೂರ್ಯನ ಬೆಳಕು ಮನೆ ಒಳಗೆ.
ಸೂರ್ಯನ ಬೆಳಕು, ಆಲ್ ರೈಟ್.
ಇದು ವಿಶೇಷ ಲೇಔಟ್ ಅಲ್ಲಿ ಒಂದು BDA ಅಪ್ರೂವ್ಡ್ ಲೇಔಟ್.
ಗೊತ್ತು, ಸ್ಟ್ರೀಟ್ ಲೈಟ್ ಕೊಟ್ಟಿಲ್ಲ ಪರ್ಮಿಷನ್ ಅಂತ, ಪೆಟಿಷನ್ ಪೆಂಡಿಂಗ್ ಇದೆ ಅಲ್ವಾ?
ಅಲ್ಲ, ಅದೇ ಇದೆ, 93ನೇ ಮ್ಯಾಟ್ರ್ ಇತ್ತು, ಅದು ರೀಚ್ ಆಗ್ತಿಲ್ಲ.
93?
ಹೌದು.
ಅದೊಂದು
ಮೊನ್ನೆನೂ ಇದೆ.
ಮಂಡೇ ಆಗಲ್ಲ, ಬುಧವಾರ ಹಾಕ್ತೀನಿ.
ಆಯ್ತು.
ಬಿಕಾಸ್ ಲೈಟ್ ಇಲ್ಲ ಅಂದ್ರೆ.
ಹೌದು, ಲೈಟು ಇಲ್ಲ, ನೀರು ಕೊಡ್ತಾ ಇಲ್ಲ, ಕಾಟ ಕೊಡ್ತಾ ಇದ್ದಾರೆ BDA.
ಆಯ್ತು,
ಟ್ಯಾಕ್ಸ್ ಮಾತ್ರ ತಗೋತಾರೆ.
ಆಯ್ತು, ನೆಕ್ಸ್ಟ್.
Serial number 101.
Where were you? Be there only. Yes.